I declare open this hearing of the Education and Employment Legislation Committee into the 2024-25 additional estimates. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to the elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee has resolved that written questions on notice should be received from senators by close of business on Tuesday the 4th of March 2025. The committee has fixed Monday the 24th of March 2025 as the date for the return of answers to questions taken on notice. The committee's proceedings today will begin with corporate enabling services across portfolio and general matters of the employment and workplace relations portfolio. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The Senate has endorsed the following test of relevance questions at estimates hearings. Any question going to the operations or financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded the Senate order specifying the process by which a claim of public interest immunity should be raised. I incorporate the public immunity statement into the Hansard. I remind senators of their obligation on the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. An officer called to answer a question for the first time should state their full name, the capacity in which they appear. Mobile phones should be turned off or switched to silent. I now welcome Senator Honourable Murray Watt, Minister for Employment and Workplace Relations. I also welcome representatives from the Department of Employment and Workplace Relations, including the Secretary, Ms. Natalie James. Minister, do you wish to make an opening statement?
Yes, thanks, Chair. Good morning, everyone. Good to be back with you. Under the Albanese government, wages are rising, jobs are rising, all while we're bringing down inflation and seeing industrial action decline. This was clear in last week's jobs and wages figures. Under the Albanese government, more Australians are getting jobs and more Australians are getting more money in their pockets through rising wages. Now, this doesn't happen by accident. It's a very deliberate result of the decisions that the Albanese government has made. We recognise that things are still really tough for many Australians, and that's why we'll keep working hard to keep these wages rising, to keep as many Australians as possible in employment and to keep bringing inflation down. In January this year, we saw 44,000 new jobs created in Australia, with most of them being full-time jobs. In fact, since the Albanese government was elected, 1.15 million new jobs have been created in Australia, the most any government has created in a single parliamentary term. Last week's data showed that we have now had 5 consecutive quarters of wages growing above inflation under the Albanese Labor government. Now that stands in massive contrast to what we saw under the coalition before we were elected. The 5 quarters leading into the last election, we saw real wages going backwards under the coalition. There could scarcely be a clearer contrast between the parties, wages up under Labor, down under the coalition. For the decade they were in power, Peter Dutton and his colleagues went out of their way to hold down the wages of Australian workers. In fact, they boasted that low wages were a deliberate design feature of their economic architecture, and they have continued this shameful practice in opposition, voting against every change our government has made to lift wages, just like they've voted against every cost of living measure we've provided. They've actively tried to make life even harder for Australians. To lift wages, we've had to make big changes, things like passing our same job, same pay laws, which stop labour hire workers being exploited. We've made it easier for workers and businesses to bargain, which is seeing more enterprise agreements reached. We've put our money where our mouth is by directly funding pay rises for low-paid aged care and early childhood workers, industries where the workforce is highly feminised. And we've directly advocated for raises to the minimum wage through the past 3 annual wage reviews, meaning 2.6 million minimum wage workers have got 3 consecutive pay rises. In 10 years, the Coalition did not once argue for a rise to the minimum wage. And just last week, I announced that the Albanese government will be intervening in a Fair Work Commission case, which is seeing the supermarkets and big retailers of Australia try to strip penalty rates off retail workers who are earning as little as $53,000 per year. Weekends are special, and people who give up their time to feed us and clothe us on weekends or weeknights in unsociable hours, they deserve their penalty rates, and they deserve a government that's going to protect those penalty rates. Cruelly, Mr Dutton has said that he won't get involved. He'll let the supermarkets cut penalty rates for their workers without even a whimper. Labor's interventions are working to get wages moving. The average full-time worker in Australia is now earning more than $150 per week extra compared to 2 years ago. The gender pay gap is at the lowest on record, and later this year, of course, we will head to the polls for an incredibly important election. Australian workers' pay slips will be on the ballot paper at this election. There is a genuine choice on wages and workplace conditions. It's a choice between a Labor government that is helping Australians earn more, or Mr Dutton and the Coalition who want Australians to work longer for less. It's a choice between Labor's plan for higher wages and more money in your pocket every single payday, or an arrogant and reckless Coalition who kept wages low when last in power, opposed every pay rise while in opposition, and now promise to cut pay again. The question that every Australian is going to have to ask is, can they afford for their pay to go backwards under Peter Dutton? Because that's what's on the table. I look forward to having a discussion today, and I really look forward to debating Senator Cash about these matters at the National Press Club sometime over the next few weeks, if she's up for it.
That's a very strong challenge, Senator Watt. I'm looking forward to hearing the response. Ms James, would you like to make an opening statement?
I would. Thank you, Chair. Natalie James, Secretary, Department of Employment and Workplace Relations. I have 2 matters that I'd like to go to, one procedural and the other a matter more substantial relating to my responsibilities with respect to the administration of outcome 1 of this department. To go to the procedural issue, I would like to table for the benefit of the committee a copy of a letter from Senators Cash and O'Sullivan dated 18 February and my response dated 24th of February. That response contains answers to the questions we were asked where the information was readily available within the requested timeframe. So that was sent to the senators and the committee on the 24th, and I table it for the record. The more substantive issue is one that relates to matters that have arisen with respect to our department's administration of mutual obligations under social security law and the compliance framework, which helps ensure that people meet those obligations. A copy of the statement that I'm about to read is being circulated. I apologise that it is quite long. This is a complex matter and I do seek indulgence from the committee. I haven't done opening statements very often or when they're not important. The concept of mutual obligations for people who receive social security benefits when they're unemployed has been part of the legislation framework in this country apparently since 1945, and the policy behind this is well known. It's to ensure that people are actively looking for work and participating in activities that are believed to help them into employment. The mutual obligation requirements set out activities that a person does to demonstrate their willingness to actively seek, accept and undertake paid work. The current requirements are established by the Social Security Administration Act 1999. The requirements in the Act are also underpinned by a compliance framework which establishes consequences if the requirements are not met by the participant. The current approach to compliance, the targeted compliance framework, was introduced in 2018 after the Parliament passed legislation enacting it. These provisions are contained in the Act. I've noted a reference in the statement for your information, and they're supplemented by an instrument made by the Minister under the Act, under section 42AR of the Act, which is known as the non-compliance determination. This framework covers people in Workforce Australia and the Disability Employment Services program. The administration of the framework is carried out by the Secretary of Employment. Various decisions and functions have been delegated to officers in my department, officers in Services Australia, including the Chief Executive Officer of Services Australia, and people engaged by employment service providers. Under this framework, under subsection 42AF1, if a person commits a mutual obligation failure, their payment may be suspended or put on hold. The framework provides now 5 business days for a participant to provide a valid reason for not having met their requirement, which is known as resolution time. A person's payment is not impacted within the resolution time, and if they meet their reconnection requirement within this period, it will not be impacted at all. When a person has their payment suspended for a mutual obligation failure, Section 42AM of the Act requires they are notified of a reconnection requirement and the effect of not complying with it. A suspension remains in place until the person has met this reconnection requirement or requirements. Unless their payment is reinstated earlier, that can happen under Section 42AL. If a person meets this reconnection requirement, their payment is restored, and in 90% of cases this does occur before a person's social security payment is due to be paid. The framework also provides for specific consequences where the Secretary is satisfied that a person has persistently committed mutual obligation failures without a reasonable excuse. In such a case, I or my delegates may determine that an instalment of a person's payment is reduced by half or in its entirety, or that the person's payment is cancelled. The non-compliance determination I referred to earlier is very relevant to the decision-making that occurs under these provisions. That determination sets out a process generally where if a participant fails to comply with their mutual obligation without a valid reason, a demerit is recorded in the department's technological system. If a sufficient number of demerits accumulate within a certain period of time, it becomes a trigger for a reduction in payment, or, if this is repeated, a cancellation of a person's social security payment. This framework is administered with reference to a series of zones, and we've used language in this committee before, warning zones, penalty zones and the like. If a person accrues a demerit, the person enters the warning zone. If a person accrues 3 demerits in 6 months, their service provider or the Digital Services Contact Centre conducts what's known as a capability interview, which assesses the suitability of a person's requirements and identify any causes of the non-compliance. This is an important check-in, and if in that capability interview a view is formed that a person's requirements are not suitable, in other words, the mutual obligation requirements they failed to meet are not suitable, they will have their requirements adjusted to better reflect their circumstances. They will have that demerit reversed, they'll return to the green zone. If the capability interview determines a person's obligations are appropriate, and if they then proceed to accrue 2 more demerits within the 6-month period, Services Australia will then conduct a capability assessment. The non-compliance determination provides that a person cannot be found to have persistently failed their obligations without this assessment having taken place, and without that assessment taking place, there will be no payment reductions or cancellations under these provisions. This capability assessment carried out by Services Australia is designed to identify any previously undisclosed issues affecting the person's ability to meet their obligations, and it will again consider the appropriateness of those obligations. If Services Australia forms the view that a person has issues preventing them from meeting those requirements, or the requirements are inappropriate, they will be returned to the green zone. Where Services Australia finds that a person's requirements are appropriate and after their 5th demerit, they enter the penalty zone. Once in the penalty zone, if they meet their requirements for 3 months, they return to the green zone. If a person fails to meet their obligations without a reasonable excuse once they're in the penalty zone, then reductions in payment are applied under the non-compliance determination. I'm responsible for the general administration of these laws as they relate to mutual obligations under Section 7 of the Act and the current administrative arrangement orders. My role, and that of the public servants in my department, is to ensure the systems we administer are operating within the law enacted by Parliament. The framework is administered through an IT system. The department undertakes a regular program of assurance in the IT system to make sure that it's operating correctly and as intended. This program of assurance validates whether the IT platform delivers the policy intent and the legislative requirements of the system, and whether decisions are made fairly and consistently with legal requirements. The program has identified a number of IT defects occurring in the system that have impacted on people's payments. 3 separate incidences have occurred. The first of these impacted on participants from July 2018 to August 2023. The impact of these IT issues is that some people had their payments reduced when they shouldn't have, or their payments cancelled. And if they were cancelled, they had to reapply after a 4-week preclusion period. This should not have happened. We subsequently identified 2 further systems failures, both of which resulted in a person incorrectly remaining in this penalty zone when they should have been moved out. These failures were identified in February and May 2024. Across these 3 incidences caused by the IT system not aligning with the policy, 1,326 people were impacted and approximately 1,280 were repaid an amount equivalent to their social security benefit that was reduced or not paid. Attached to this statement, I will just confirm that it is attached, we have a document that outlines more detail about these issues, the mitigation and fix for each one and the number of people impacted. So can I just confirm that that's been tabled? Thank you. When the impact of each of these failures was identified, I decided in May 2024 to repay the job seekers who were impacted, and the department took action to prevent them further impacting on anyone, rectify the system as outlined in the table attached. The department remediated this through the compensation for detriment caused by defective administration scheme, or where possible, directly through the social security system. That's not always possible for reasons of a provision in the Social Security Act. So approximately 1,280 job seekers were repaid $1,233. Sorry. The figures in the statement, 1,233,527. It's a very specific number. In addition to assurance of the IT system, we have begun systematically reviewing the way decisions were made under legislation. This systematic review is important, especially in light of the lessons from the Robo-Debt Royal Commission. We are closely looking at decisions made under this framework that impact on participants' payments, that is, suspensions, payment reductions and cancellations. We're doing this to ensure they're being lawfully made. We are also ensuring we fully understand what automation is occurring in the system and what impact that is having on people. While the Act envisages that computer programs might be used for some social security law decisions, we see Section 6A of the Act, we considered it important to review these decisions and assure ourselves the decision-making was appropriate and lawful. In July 2024, it became clear that some decisions to cancel people's payments due to persistent mutual obligation failures, which is the framework I've outlined earlier, may not have been validly made under subsection 42AF sub 2 sub D, paragraph D. The impact of this is that 985 decisions under the framework to cancel 964 people's payments made between the 8th of April 2022 and 4 July 2024 may not have been validly made. On reaching this conclusion, I decided to immediately cease these cancellations, and they remain ceased. I decided to pause cancellations in line with my responsibility for the general administration of social security law as it relates to mutual obligation compliance under Section 7 of the Act and the current administrative arrangement orders. In taking this decision, I also considered my obligations under the Public Service Act to uphold and promote APS values and the APS employment principles, which include acting with integrity. Cancellations were paused on the 4th of July. They remain paused until we can be sure the system can operate effectively. I made a subsequent decision to review all payment cancellation decisions which may not have been validly made during this time frame. We have been engaging with representatives of important peak body groups about the approach to this review, and we will provide further information once this approach is settled. It is noteworthy that the Commonwealth Ombudsman has also announced on 4 February 2025 that he is examining this framework and in particular cancellations decisions that are being made under it to ensure that they're being made in a way that is lawful, fair and reasonable. The department is engaging with the Ombudsman and we're committed to supporting this work. We now have a number of examples where the system is not operating in alignment with the legislative framework and associated policies. This is a framework that can lead to decisions that have a profound impact on people's experience of the employment services system and, critically, their social security payment. It is a serious and pressing concern to me that we take steps to ensure the integrity of the framework. The government has commissioned an independent assurance review to look at the IT system and examine it against operational policy business rules to ensure that it's operating as intended. To date, we've provided 120 documents that contain all of the business rules to the independent reviewers and access to the IT code. This is to support a robust, thorough examination of the system. I've had a briefing with the independent assurance review team, and I anticipate the review will identify matters which the government should act on to ensure the integrity of this system. I've also instructed my department to undertake a legal review to examine whether decisions in this area are being properly made and whether the decision-making processes are aligned to the legislative powers under which they're being made. This commenced in 2024, November, and is being undertaken by internal and external lawyers, assisted by advice from the Australian Government Solicitor. Decisions which have the most impact on people's social security payments are currently being prioritised for the legal review. At all times, my department's highest priority is in ensuring that participants' payments are not affected except in accordance with the law. I want to assure the committee that if following the completion of these reviews I remain concerned about the application of the framework, I will take actions to ensure my department's compliance with the legislation. If I have reasonable concerns the framework is not operating in accordance with the law, I have a duty to act on that, to change the relevant processes and systems so I can be satisfied of the lawfulness of decisions being made under it. If there are constraints on my capacity, if there are constraints that limit my capacity to make such changes, I can pause the impacted decisions pending remediation occurring, as I've done with cancellations under Section 42AF. This might be through system changes or legislative amendment. The processes that are underway will enable me to make these important decisions. Thank you.
Good, thank you very much. Senator O'Sullivan?
There's obviously a lot here that we need to go through.
Understood.
It is primarily for outcome one.
It is.
Given that there may be some questions that relate more to corporate that we want to deal with, will you have people here during outcome one that we can call upon if we need to?
Yes, Senator. They're all here.
Yeah.
Yeah,
Because it's later in the day. We just need time to go.
Yeah, we thought it
Yeah.
was more appropriate to deliver the statement at the beginning of the day, so that you do have time. But we were expecting you'd ask most questions about it in outcome one.
Yeah. Cool. Thank you.
Good, thanks. Senator Cash.
Thank you. Could I just turn to, you've tabled the department tabled a letter from the Fair Work Ombudsman about the wage underpayments. That was 001768, and I'm just going to table the letter just so that the committee have it. Can I just work through the issue of the wage underpayment, which we have obviously explored at previous estimates, just to try and draw it to a close?
Of course, Senator.
Can you confirm whether the department's wage underpayment issue has now been completely finalised?
Yes, Senator.
Yes, thank you. Have there been any further underpayment issues or potential underpayment issues since the finalisation of this particular wage underpayment investigation?
No, Senator.
Are you able to guarantee the committee that all staff have been and are being paid correctly since this matter was uncovered? And as I said, that staff are being paid correctly at this point in time?
Senator, we've done a lot of work around the systems and controls. We've previously traversed evidence in this committee of audits and reviews. I am comfortable that that we have an appropriate system of risk oversight and management of our people's entitlements, and noting that we do have a relatively new enterprise agreement. We are, as we work through new policies that are being made under that agreement, ensuring, again, the alignment between those policies, the IT systems that deliver people's pay, and the enterprise agreement. So, yes, I am confident that we have the systems, processes and people capability in place to ensure that our people are paid properly and in accordance with their lawful entitlements.
Okay. I asked for you, given you are the Department of Employment and Workplace Relations, and you are the department that, as we've discussed before, should be setting the example for the rest of Australia, I asked you if you could guarantee that there is nobody being underpaid at this point in time. The evidence you just gave did not contain a guarantee, but you did refer to the new agreement.
Yes.
So I just need you to clarify for the record, are you saying that the new agreement may result in future underpayments?
Senator, that's not what I said at all. What I've said is that we are doing what every responsible employer should do, and in particular what this department should do in ensuring that the infrastructure that ensures that every person receives their appropriate pay and conditions every pay fortnight is correct.
Okay. Again, what I asked you to do as the department who A, is responsible for the legislation, B, is the department that is the lead example for all employers throughout Australia, and I'm assuming you would expect others to be able to assure you that their employers are being paid correctly, given in particular that you have had an underpayment, and we'll explore that further shortly. Again, I'm asking you, can you guarantee that the staff in your department are being paid properly?
Senator, I don't think I have anything to add to what I've already said. I mean, I'm not sure, Ms Jenkins, if you would like to supplement. I mean, we can more systematically work through what is supporting my level of comfort and confidence.
Perhaps I should ask then, have your arrangements received independent oversight? given the underpayment issue?
Senator Deborah Jenkins, Deputy Secretary, Corporate Enabling Services Group. Senator, as we've traversed in previous committees, we had an internal audit that was undertaken. We also mentioned at our last hearing that we were having a further internal audit review. We are waiting for the pay and conditions audit, I think it is called, to be done by our internal audit team. We continue to have reviews done by through the SDO, which is the delivery office.
Sorry, what was that? The SDO
the
is the...
SDO, yeah, that's where our payroll is processed.
what does SDO stand for?
Service Delivery Office.
Sorry, the Service Delivery Office,
Service
yes.
Delivery Office. We have spot checks, and we obviously rely on the audit and assurance that is done through the Service Delivery Office. So at this moment, I'm not aware of any ongoing systemic or significant issues, but we continue to monitor those things. We also have a governance framework where we are going through to make sure that the implementation of our agency agreement, in implementing it, we've got the policies, the procedures to ensure that we meet the terms of that. That's probably really all I can...
Just in terms of the original internal audit, and then you said you now have a further internal review that is being undertaken, and you are still awaiting the outcome of this. What is that further internal review?
Let me just... Senator, I'm just going to get the details of that one.
Secretary, do you have a number that your staff can call if they believe that they've been underpaid?
Our staff have a number of channels into our human resources team with respect to their entitlements and conditions.
And if they believe they've been underpaid,
there's a particular number. I think people tend to send emails and or call, but we can...
when you say or call, that was the point.
Yeah, there's certainly phone numbers that people use to engage with our payroll and human resources team.
Okay, and using those, they're well known to everybody. If I believe I've been underpaid by the Department of Workplace and Employment Relations, as some have been, I'm able to call that number and report that I believe I've been underpaid. I'm just asking this on behalf of some employees who've asked for that number.
Okay.
Could you call the number out for us?
I would need to take that on notice, Senator.
The number?
Yes, that's right. I don't have it to hand. Usually if a person was sitting in our department with a query about their entitlements, I expect they would go to our intranet site and look it up in the corporate directory or elsewhere. So I'm happy to take that on notice, but
Does anyone in the room have the number?
I'm sure they do. We'll take it on notice, Senator, and endeavour to give that to you as soon as possible. I think, subject to that being a straightforward query, we can...
Thank you. So just in terms of the further review, you were providing me with some additional information. Thank you.
Senator. So in late October 2024, we commenced a discovery activity into the review of the working hours of EL 1 to 2 employees, the use of EL time off in lieu provisions under the enterprise agreement, and we're expecting the report late February, which is obviously later this week, or early March. So that was another one that we did through the internal audit framework.
No,
so
thank you for that. So we're still awaiting the outcome of that.
We are of that one, yeah, that's correct, Senator.
Just again, just so I can close this off, given it's this estimates now, what were the final costs of the underpayment, given obviously it's taxpayers' money? So what was the final cost to the staff, the number of employees that were underpaid, but I also then want to go through the legal costs that were incurred by the department?
Senator, we confirmed in our response to your and Senator O'Sullivan's letter...
So that was
The numbers have not changed since the evidence we gave you at the last hearing.
Okay. So 243,064 was the final underpayment number. 201 employees of the Department of Employment and Workplace Relations were underpaid. In terms of the legal costs, I think you'd given evidence a few estimates ago that there had been at least 2 firms engaged and an actuary. What were the final legal costs for the underpayment?
They have also not adjusted since we last spoke about this.
Could you just remind me what the number is?
You might need to check, Senator. I'm not sure I have that.
I have to check the numbers. Senator, are you after the final legal cost number?
Yes, please, the final legal cost number, yes.
Okay, the total legal fees, and so this was answered at our 6th of November hearing. And
So
in the
nothing
letter.
further's come in since that date?
No, that's correct. The total legal fees number that we gave you at that time, and it continues to be 116,42617. And just, I think you mentioned 2 legal firms. As we said last time, it was 3.
Oh, it was 3 legal firms that the department had the benefit
and
of.
there was no actuary involved in the legal,
in the end, there wasn't an actuary
legal
involved.
services.
Okay, so there were
That's
3
correct.
legal firms. Could you just remind me who those legal firms are?
Yeah,
Or were?
sure.
The first legal firm was
Ashurst,
Ashurst, and then you had the benefit of being able to go to a second legal firm,
which was Kingston Reid.
Kingston Reid, and then you had the benefit of going to a third legal firm.
That was outlined in our letter of, in the 3rd of June, which is AGS.
That's right, the AGS. So does that include the auditing costs that you've referred to?
They are a different cost. They're not legal services.
What are the auditing costs and who's undertaking the audit?
They're the same. I'm just going to make sure.
Talking about the one that related to, so there, I think we're up to 3 things we might describe as audits now.
Oh, 3 things we might describe as audits. Okay, so
well, and we have traversed this before, Senator.
no, and I'm trying to wrap it up for a final estimate, so it's all there.
Understood. There was the calculations in the first instance.
Yep, which was Cobalt.
So that was Cobalt, and do you have so that was Cobalt, which was an audit firm. What were the final costs for Cobalt, please?
I'm just going to, I might just get... Sorry, just we've traversed this before.
No,
so I'm
that's okay. I just
making
want it
sure I don't
nice and
give any
neatly,
incorrect
all
numbers,
summarised.
Senator.
So data analysis, Cobalt Consulting, the number is 168,576.54.
168.
576.54.
So $168,576.54.
That's right.
Okay, that was the audit number 1. What was auditor number 2?
So I think you're referring to, Senator, when the Chief Internal Auditor engaged McGrath-Nicol to undertake an internal audit of the payroll systems and processes. Is
What was
the one
that?
you're referring
What was the
to?
cost of that?
I will just check if I have that figure to hand.
And
I
just
don't want
who
to
did
give
you
you the
say undertook
incorrect
the
figure.
audit?
McGrath-Nicol.
So, I can't quite hear you. Sorry.
McGrath-Nicol.
McGrath-Nicol.
Yeah.
Sorry. McGrath-Nicol, and that was an outside firm.
That's
That's
correct.
right.
Okay, McGrath-Nicol, and you'll get me the expense involved there or the cost involved there.
Yeah, look, I think we'll take that on notice, Senator. We may be able to get that to you relatively quickly, but because it didn't relate it flowed from this event, but it was looking forward and it was looking proactively for other issues. We haven't tended to associate those costs directly with the costs of this remediation. So we'll take that number on notice.
And so you did say there was 3. What was the
I think the
third?
third one is the one currently underway that Ms Jenkins
It's done by our
just
internal
referenced.
auditors.
And which one? Who's undertaking that one?
That's done by our internal auditors. I'd have to check with our
Is
chief
there a
internal
cost
auditor.
involved in that?
Would be an internal cost,
An internal
Senator,
cost.
and I'm not sure we tend to... Do we cost our internal audits?
So 243 and 64 underpayment, legal fees from the 3 legal firms 116,426, 160,426. The first audit, Cobalt, $168,576, and then you'll get back to me, re the second audit, McGrath-Nichols, and the third audit. So we're up to, I think, almost $530,000. Right.
Senator Cash, there may be, I gather there's going to be quite a number of questions. I know we're coming back to this in outcome 1. I don't
Oh,
want
it's just the next letter I wanted to go through was one that was tabled in just...
corporate, sorry, yeah. Sorry,
corporate.
matters, yeah. Sorry.
So,
Sorry, I just wanted to let you know one of the numbers. We have provided it before on the 3rd of June. It's in Hansard. So it was $81,000.
and that was for McGrath-Nichols, $81,000.
So it was in our
Thank
evidence
you.
previously.
And just to clarify, I wouldn't attribute that cost directly to the remediation. So those sorts of proactive, forward-looking audits, that was about assuring ourselves that there were no other issues. And so we have not been attributing that cost to that event. What we've been saying is there are, of course, costs associated with maintaining ongoing compliance. As the Fair Work Ombudsman noted in its letter to us, that this is, we are expected, and all employers are expected to take steps to ensure that our systems are regularly reviewed and updated and ensuring compliance with the law. So I would attribute that second audit cost to ongoing compliance and not directly to the remediation under the determination.
But it did come around because of this event.
Well,
It's a
we
flow
certainly
on. You've gone through
prioritised it. We
It's a flow on.
prioritised it as we should, and in that case used an external provider. And so we are now comfortable, I think, about our own internal capability here, and so internal audit is also an entirely appropriate methodology to use. But from time to time, of course, we should be going back out and getting that independent assurance and testing being done.
And Senator...
Sorry, I was just going to say, if we could just, you mentioned the letter from the Fair Work Ombudsman. In that letter at point 12, it states, the FOIA's assessment of the information provided as part of the assurance process in respect of matters which are the subject of the self-report should not be regarded as an endorsement that DUA has been fully compliant with workplace laws at all times. Can I just ask then, what laws haven't your department complied with?
Senator, I don't believe that the statement in the letter is suggesting there are other examples of non-compliance. I mean, you'd need to ask the Fair Work Ombudsman about the language.
I'm just asking you because it's a finding in relation to your department.
I mean, our view is that there are no others, I think, because this investigation was very specifically into this event, this particular example of non-compliance. So, of course, the Fair Work Ombudsman, no one would make assurances about compliance outside of the scope of what they looked at. So that is
very disturbing, quite frankly, that there is an underpayment. The FOI here states in its letter back to you, this is the investigation, at point 12, their assessment of what you have provided should not be regarded as an endorsement that you have been the lead department, the Department of Workplace Relations, that is meant to set the example for the rest of Australia, has been fully compliant with workplace laws at all times. What action did you take, Secretary, upon reading that?
I understood that...
So Ms Jones, just before we answer, sorry, Senator Cash, how long have we got to go? So
I've got a few more. Yep,
so I rotate shortly?
Yep.
Right, thanks.
I understood, Senator, that statement to mean that the Fair Work Ombudsman's letter and conclusions relate to the scope of the issue that they looked at and do not relate to anything outside of that scope, which I do not consider to be exceptional or unusual, because I don't think anybody would make a statement with respect to things they hadn't looked at.
And that's my worry. That's exactly right. What action did you take? You have underpaid your employees. The first estimates at which we discussed this, the number was a lot smaller in terms of both the employees underpaid and the number in the underpayment. that has progressively got larger, 201 employees, $243,064. The benefit, unlike so many businesses, you had the benefit of engaging 3 law firms, Ashurst, Kingston Reid, and then, of course, the Australian Government solicitor. You've also had the benefit, other companies don't have this luxury, especially smaller businesses, of having auditors, Colbert, McGrath-Nichols, and then currently you've got the internal audit. I am very concerned that you receive a finding that it should not be regarded as an endorsement, that the lead department has been fully compliant with workplace laws at all times. My worry then is, did you ask the Fair Work Ombudsman what they meant by this and what laws potentially you have not complied with?
No, Senator.
You didn't?
No. I think I've just articulated in response to your previous question my interpretation of that paragraph, and so that did not indicate to me that I would like what the letter as a whole indicates to me, if we go to paragraphs 14 and 15, is, and it outlines very clearly what the department needs to do and the Fair Work Ombudsman's expectations. We need to ensure our current payroll systems, processes and controls are sufficient to maintain compliance with relevant awards, enterprise agreements and the Act. We must also ensure the systems are regularly reviewed and updated, and that's part of the activity that Ms Jenkins has outlined that we're doing now. The Fair Work Ombudsman expects that we will ensure we have appropriate systems expertise oversight in its workplace relations, risk and audit functions to prevent and detect underpayments or potential non-compliance. This includes ensuring that governance and risk controls maintain adequate line of sight to business units about what is happening in practice at an operational level. All the activities we've outlined are designed to achieve those things. That will be an ongoing responsibility of this department, and I am comfortable and confident that all the actions we're doing are consistent with what they need to be to ensure compliance. So no, I didn't, noting that the letter makes it clear that this matter is now finalised. I wouldn't, it's not the Fair Work Ombudsman's role to offer ongoing compliance programs. It's its role to, and so I don't think that, I mean, with respect to what the Fair Work Ombudsman may have meant with respect to that paragraph, I've advised in response to your question how I interpreted it. If I was wrong, perhaps you could put that to the Fair Work Ombudsman, but I'm comfortable with our response organisationally to this event and this letter.
Well, on behalf of the Australian taxpayer, I can assure you I am not comforted by this, given in particular where we started and where we ended up, the fact that you still have an internal review on foot, the fact that, in particular, did you speak at all to the Fair Work Ombudsman about the letter they sent you?
I did not, Senator, no.
You didn't think a call to them, in particular in relation to item 12, just to tick off the lead department in Australia that sets the example? Are you sure there's nothing else that we should be looking at?
Noting paragraph 11, the matter is now finalised.
That is not the point. That is not the point.
So, no, I did not.
Right,
Senator.
Thank you very much. You did not. Is it important for your department?
Sorry, time to rotate, yeah. Senator Pocock.
Thanks, Chair. Thanks for being here. I wanted to go to the question of artificial intelligence. Minister, you made a statement recently quoted in the Financial Review saying the government was, quote, developing several pieces of work all aimed at ensuring use of AI in Australia is safe, ethical and responsible. What are the pieces of work underway on development?
I don't mean to be difficult, Senator Pocock, and I'm very happy to talk about that. We probably need to wait till outcome 3, I think it is, workplace relations, because I'll have the relevant officials with me at the table then.
It is next, Senator.
Yeah,
Okay.
once we get through corporate, but very happy to talk about that.
Okay, good. I'll come back to it then. I wanted then to have ask a question around portable entitlements.
That's probably also outcome 3.
Thank you. And some questions then about your consultation process around small claims review.
Also outcome 3.
3. That was quick,
It was.
but I'll be back.
No problem.
Thanks. Thank you, Senator. Back to you, Senator Cash.
Thank you so much. And I do note we are moving on. I may have to come back to this, but it is already 10 o'clock. Secretary, could I now just turn to, again, the letter that Senator O'Sullivan and I forwarded to you. We asked for a copy of any internal correspondence, guidance notes or policy documents regarding the right to disconnect for department staff. Unfortunately, there doesn't appear to have been anything or any correspondence regarding the department's right to disconnect. Instead, in the letter, you said the department's corporate areas regularly communicate with our staff about their conditions. Can I just ask, did you actually attempt to look for any correspondence about the right to disconnect?
Senator, I note that in your previous letter to us with respect to this issue, you asked for some material which we provided to you because the right, and that was because the right to disconnect being quite new, we created quite a bit of guidance material. And so that guidance material was prepared to provide a reference for all of our people. And so given its commence, we haven't developed more material like that.
Right.
Yes, interim guidelines. Look, we are, because of our enterprise agreement, doing formal consultations with our people about guidelines. But
do we have a copy of the interim guidelines? Was that something that you had
I think that's what we might have provided last time.
Would you mind?
I think, Senator Cash, I think that was provided last time because I remember you asking questions about this last time.
Can we
but
just
we can
make sure it has been? I just want to see from the time period till now, because there's been a time that's elapsed, whether or not there's any further guidance. Because the question is, have you had any further communications with staff about the right to disconnect?
And Senator, on that, so you asked about our efforts with respect to identifying communications, noting where we started. We have a human resources area that regularly responds to queries from managers and staff. A number of our managers would be communicating with, because it's new, and obviously a big talking point, would be communicating with teams. I wasn't comfortable that within the time frame I could identify comprehensively the things you are asking for, because internal correspondence. So I don't believe there are any new guidance notes or policy documents, but it was the internal correspondence. I am absolutely certain there has been some. But noting that we regularly correspond with our people, different cohorts, about these entitlements, managers and staff, I couldn't be comfortable of that within the time frame that I could get that for you. I mean, you're welcome to ask on notice, and of course then we would give it due import in that form. But in the time frame, it just wasn't something we could be comfortable with.
That's correct. And Senator, you asked...
So could I just confirm that you believe there was internal correspondence, but you haven't provided it? Were searches actually undertaken for this internal correspondence?
I was aware of one or two, but again, wanting to be comprehensive, it's not something that I was able to deliver to you in the time frame. Noting that it's important that we give accurate and complete information to the Senate.
So the only question I have then, given we do provide the letter so we can get information to ask questions, were searches actually undertaken?
We didn't conduct, and we tend not to, Senator, conduct comprehensive searches in response to your letter when we're aware that it's a large amount of material. So again, you know, we
just don't bother. The department doesn't bother. Is there a limit, Senator, in terms of
Senator,
the type of search you might undertake? I mean, if the Australian Greens ask for something, if an independent asks for something, if we ask for something, is there a difference in what you do or don't search for?
Senator, when I talk about comprehensive searches, I'm talking about the kind of thing we would do for a freedom of information process, where we would trawl. So we do have several thousand staff who communicate with one another in various ways. And so and we make decisions all the time about appropriate use of resources. I was not that kind of process, the searching process we would undertake, for example, for a freedom of information response, takes quite a bit of time, and in order to be thorough, you need that time and you need that formal process. That's not something I believed that we could achieve in the time frame for the letter.
So if we could give you additional time next time, you're saying you'd be able to undertake the search, because I'm more than happy to do that.
Well, Senator, if you were to put the question on notice, then that's the approach we would take. But noting again that because of the reference to internal correspondence, managers and staff and our human resources and people and staff are talking to one another through emails and other forms of communication all the time. And so it could be quite a number of documents. It could contain private information, if you understand what I'm getting at here. So the policies and formal guidance is a lot easier and more confined.
I know, have we just been... Is that what was tabled last time? So I'm just trying to ascertain from last time to now, has there been any further update?
Not formal guidance, I don't
What
believe.
I can let you know, Senator, so in our letter to you of the 4th of November, we attached a copy of our intranet information on the right to disconnect.
Yes.
Within that was a copy of our interim guidelines. Consistent with our agreement, we have gone and we are currently consulting with our staff on those interim guidelines. I can check with you and come back after the break where we are up to and when we're expecting those to be finalised, but they were the interim guidelines. There has been correspondence and engagement through consultation across the department to make sure that we have got the guidelines pitched with the scenarios that people need. And I can tell you that, I know personally that there has been information, it's been in discussions where we've talked about the right to disconnect. But as the Secretary said, your question was quite broad and we wanted to make sure that we didn't give you only half the story. I can come back after the break, though, Senator, to confirm this.
Just remind me, when did the right to disconnect commence for the department and for businesses other than small businesses?
August 2020. 26th of August 2024.
Right.
And so we had those guidelines in place ready for that, the interim guidelines, and then we've consulted on them since then.
And it's now February going into March 2025, and the Department of Employment and Workplace Relations, the lead department in Australia that is meant to set the example for all other employers, still does not have the finalised guidelines for its, how many did I say? 4,000... How many staff do you have? 4,373 staff.
20% more than they'll have after the election if you win.
Can I just confirm that the Department of Employment and Relations, the department that writes the legislation, that oversees it, that demands of others in the Australian workforce, and we're going to work through what it actually means for the department shortly, has not yet finalised its guidelines in relation to the right to disconnect. You have interim guidelines, but you have not finalised the guidelines.
We're consulting on those guidelines,
Senator,
yes, so no, we haven't finalised them because consultation with our people is very important to us.
Okay, so of the 4,373 employees in the department, so I want to talk about your department, how many does the right to disconnect apply to?
All of them, Senator.
All of them?
I think we've traversed this evidence before.
It's been very confusing each time we have, unfortunately, so I just want to now confirm all 4,373. So does that mean yourself, Secretary?
We've certainly traversed this before, Senator.
So I'm just
although I am not an employee, so I'm not covered by the Fair Work Act.
Right.
But I do I do talk about my own way of managing my time and my life and my work using similar language.
Correct.
But I'm not entitled to it, just to be clear.
But you exercise the right to disconnect within the department. Correct. Deputy secretaries, does it apply to them as well?
It applies to all of the employees in the department, Senator.
So, and that's what I just want to confirm, again, for the purposes of my questions. 4,373. So deputy secretaries, it also applies to them? They have the right to disconnect?
It applies to all employees in the department.
Regardless of salary?
It applies to all employees in the department.
Regardless of salary?
The way in which it applies is dealt with has a number of criteria that do go to salary, seniority and a number of other factors, but it applies
to all people in the department. Are you able to table those guidelines, please, that you just referred to, for the benefit of other businesses who are working through this?
We have provided them. We provided them to the committee last time.
So these are the interim guidelines again. There's nothing further to provide.
We've covered that.
Right.
Yes.
So just in relation to a deputy secretary, on average, what is their salary?
Don't actually have that information in front of me.
Is it about $500,000 a year? It's set by the Remuneration Tribunal, I'm assuming. It
is not set by the Remuneration Tribunal with respect to deputy.
Okay, so can you just give me an idea of what a deputy secretary earns? I just want to work through the factors that you say apply in the department in terms of working out who has the right to disconnect
Senator,
and when.
with respect to salary, I think what I'd prefer to do is refer to figures in our annual report. So I will get those figures for you. But when I'm talking about people's remuneration, I'm conscious that there are only, how many of them are there? 4. There's 4 of them, and we are getting into territory where I want to make sure I'm getting it right and not disclosing information that I shouldn't. Unless Mr Manning would like to disclose his own self.
No, I'm not asking for a person to disclose it. I'm not asking for that. We would never ask for that. The publicly available figures are all I want.
No, I'm playing catch-up, though, said the catch-up. I wanted to come back... Sorry, Greg Manning, Deputy Secretary, Workplace Relations Group. I just wanted to come back to that issue of the factors, and you're asking, is that in the interim guidance? There's a range of factors set out in the legislation, section 333, uppercase M for Manning, subsection 3, which sets out factors to help determine whether an employee's refusal to monitor, etc., be available for work is unreasonable. And it's important to note there it's a non-exhaustive list, and it includes the reason for the contact or attempted contact, the method and disruption it's likely to cause the employee, whether the employee is being compensated to remain available, the nature of the employee's role at the employee's level of responsibility, and the employee's personal circumstances, including family or caring responsibilities.
Okay.
So there's a
what
couple
does
there.
that mean, Mr Manning?
I think that means in practice if
No, I don't want you to think. I'm asking on behalf of businesses. The Department of Workplace and Employment and Workplace Relations has 4,000, how many did I say? 373 employees. The right applies to them all, including the Secretary, albeit not as an employee, but the Secretary herself has said she exercises it. You've now read out a number of factors. If you are a business who does not have the luxury of legal teams of putting together guidelines, etc., and you have to apply them, I want you to now take me through how a business applies them with the confidence they are getting it right, because, yet again, since the last estimates to now, I continue to have businesses call me. They've gone onto the Fair Work Ombudsman website. They ask who the right to the disconnect applies to, when it applies, what time of day it applies, what form of communications are appropriate, what forms of communications are not appropriate, what level of seniority excludes the right to disconnect, what is considered reasonable contact, what is considered unreasonable contact. All they get from either this department or the Fair Work Ombudsman are vague examples. I don't know if you've gone onto the Fair Work Ombudsman's website of when it might apply. So what I want to work through is exactly how it applies in the department to give guidance to businesses.
Can I just make, there's a loose connection to corporate here. We're sort of getting into outcome 3 territory about how the right to disconnect works. I guess there's a loose connection to corporate here, so I'm fine for Mr Manning to answer this if he wants to. I would make the point, Senator Cash, that I suspect one of the reasons you get calls from businesses about the right to disconnect is because you and your colleagues have kept running around telling people that the right to disconnect means that they can't contact their workers after hours, which of course is completely untrue. So perhaps you could take a bit of responsibility yourself for not unnecessarily alarming business by misrepresenting what the right involves. But Mr Manning might want to answer the question.
Perhaps Mr Manning could also address then why the Department of the Senate managed to finalise their guidelines for the right to disconnect for their staff here in Australian Parliament House by October 2024. And this department has been unable to do that.
After Mr Manning answers it, I'll go to Senator Pocock and then we'll go to Labor.
I think that question, Senator, relates to our department. I'm very comfortable with the guidance and support our people have around the right to disconnect. I'm very comfortable that it's appropriate that we should be consulting on the details and giving our staff and managers the opportunity to engage in how we frame this guidance, and that we continue to have ongoing discussions at the workplace level around this entitlement. And so I am very comfortable with where we're at with our policies under the enterprise agreement. And I don't think that I've got anything to add on that. I am, of course, happy to traverse questions about how we think this is going in our department, questions that relate to how other businesses or employers might be implementing this are appropriately dealt with in the next part of the program.
The ongoing discussions, unfortunately, and Chair, I do know you're going to rotate the call, doesn't make it clear though. That is the first issue, given that it became law in August of last year. The question is, people want clear guidance on when it applies and when it does not. And once again, we sit here, we've done this at previous estimates, and it is not made clear at all, but I understand we need to rotate the call and I'll come back to this line of questioning.
Senator Pocock.
Thank you, Chair. And just on this line of questioning, can you tell us whether you've had any internal disputes or conciliation hearings or any matters that you've had to deal with internally in relation to your 4,000 plus employees in relation to the right to disconnect?
Yeah, thank you, Senator. Not to the best of my knowledge, we have had no disputes in relation to the right to disconnect and how it applies to our staff. We've been actively engaging with them and having conversations, but no, not that I'm aware of.
Have you had to take any disciplinary measures in relation to the misuse of the right?
No, Senator.
Do you feel the right is being used appropriately for your workforce?
I wouldn't know.
What I would say, Senator, is that our staff are aware of it, and you know, I have heard of people talk about their ability to use it. So that's probably the best I can share with you.
Well, perhaps, I mean, what I might add, Senator, is our APS census results do emphasise that workload is an issue and hours of work are an issue for our people. And so I think some 60% of our people said that they're working beyond their current capacity in our APS census. Now, that doesn't surprise me. So we've had an ongoing discussion with our people about welfare and access to the range of flexibility options. And when we talk about the right to disconnect, noting that it is formally a new entitlement, we tend to talk about it and encourage our people to talk about it in terms of workload, work patterns, hours of work, and the right to disconnect as part of that picture. So none of these entitlements are operating independent of one another, noting, of course, that we do, in fact, I think our guidelines on the right to disconnect, while we have some specific material because it's new, they sort of sit within a broader frame around flexible work-life balance and the like. And so we, you know, it's the kind of conversation that would have been going on before, but the new laws provide term and a name for it, and perhaps a way of initiating that discussion. And I think that the term right to disconnect, I mean, wasn't it named Word of the Year by someone or something? It was, I think it's become a prompt for a discussion that maybe hasn't been being had in some workplaces. And so I would say the same with respect to us. Noting, of course, that the right to disconnect is about, it's not about your arrangements when you're at work or your hours of work. It's about engagement with your manager or your employer when you're not regularly working, when you're not expected to be working. And we all know things come up. And yes, certainly, Senator Cash, the Deputy Secretaries and I do find ourselves engaging in a number of ways outside of normal work hours. But if Mr Manning is on leave or he tells me he's got something to deal with, I would probably go to someone else outside of work hours rather than bothering him. So, you know, it is a good prompt for the discussion. And so the guidelines are important, but as much as anything, it's the concept that provokes a discussion that is important for us to have that perhaps we haven't always had, because particularly some staff working in budget areas or elsewhere, we can get used to the idea that we're always on call or that we're working through weekends or into the night. We have great flexibility now with our laptops and what have you, but we as a department need to manage welfare, health and safety issues and resourcing overall as well.
And is it not the case, Mr Manning, you've just read out the criteria that shape the way in which the right is implemented. There is a criteria there in relation to the nature of your responsibilities in that list. Can you go to that point?
Yeah, so one of the criteria is the nature of the employee's role and the employee's level of responsibility, and probably related to that is whether they're being compensated to remain available. So, for example, in my case, or a Deputy Secretary's case, your instrument, your agreement, essentially acknowledges that you'll be contacted outside of work as required.
As does the employment contract for my media officer. He has a loading to be available on the weekend and as hours that I need. So it would therefore follow that senior executives in the department would have a right that is distinguished from someone on a much lower, perhaps a third of your salary, where their right might be interpreted very differently and enacted on the ground in a very different way.
Yeah, I mean, I would say that what it means is what that right looks like in practice for a person depends on the circumstances of that person and the circumstances of the workplace in terms of what the workplace is dealing with at a particular time. And
specifically in the law in relation to the role and whether they are compensated.
That's one of the factors, certainly.
Yeah, but one of a basket of factors.
But I say they're not exhaustive factors. So there's not a simple black and white rule according to each of those factors. It will depend on the overall circumstances of the case.
But clearly the right anticipates that certain roles have different levels of application. Yeah. Do you have regular meetings of your senior leadership team, Ms James?
We do, Senator.
And do you discuss at that meeting how your human resources arrangements are working out in the different divisions in the department?
We do, Senator.
Have you ever had a discussion about how the right to disconnect is tricky and that certain jobs are not getting done and the management of work by senior executives is being interfered with by the exercise of right to disconnect?
The right to disconnect has never come up as a barrier to us getting the job done. If anything, we spend a lot of time making sure that people are taking the opportunities when they arise after intensive work periods to disconnect. That we are talking to senior leaders about the concept of time off in lieu, and that we are balancing workload and work intensity across our department. My people work extremely hard. The census results show they are very dedicated. Some 80% of people might have been more in the census said that they're willing to go the extra mile for the work, and that's admirable. But when I also see the concerns about hours worked, that's something that we need to balance.
Could I just jump in at that point, Senator? I should put on record my thanks and the government's thanks to the staff of this department. I think everyone acknowledges this term has been a busy one in the employment and workplace relations staff, and the significant reforms delivered could not have been delivered without the work of the departmental officials. So I recognise that people have been working really hard.
And just a last question, you'd be aware, because you prepared the documentation for the right to disconnect, about the growing body of research which shows capability to manage your time and have some say, and especially to disconnect, is associated with increased efficiency and productivity and higher morale in workplaces where it's implemented appropriately.
Senator, certainly in our census, we've got very strong results about people feeling that they have a right to access flexible arrangements, and this is very much part of that picture.
Thank you. Thanks, Chair.
Good, thanks very much. Just want to just go to the Secretary then, some questions. I mean, there's a bit of an overlay. Minister Watt raised in his opening speech about the importance, of course, getting wages moving again as a priority under the Albanese government. And we've seen a decade of deliberate wage stagnation under the coalition. Of course, there has been a great deal of work to be done to get this on the right track, and the Minister touched on its appreciation of the work that's been done by the department over what's been a very busy 3 years. But also the government's invested in the capability of this department as part of a suite of measures to help Australians earn more. We know that Peter Dutton has announced that he's promised a cut of 36,000 jobs to fund his nuclear fantasy, and he seems to find everything he comes along, he says, let's slash some more services to his Australian public, because that's what the 36,000 jobs mean, not only a loss of incredibly important work to the community, but directly also to the community and services being provided efficiently, effectively and appropriately. I just want to be clear, and this is a question, what impact have additional staff made to delivering on the government's agenda of getting wages moving while supporting Australians in well-paid, secure work?
Senator, perhaps if I need to take the question, I think, from a department-wide point of view. And so the department's staffing levels is something that fluctuates with every budget process. And so we have had an increase in ASL since this department first came into existence in mid-2022. And there have been a number of reasons for that that relate to us delivering for government and the community. It's worth noting that a significant reason for changes in ASL goes to conversions from roles that have in the past been delivered by contractors and are now being delivered by public servants. So, for example, that's occurred with staff in our employment contact centre. So these are the people who talk to job seekers and Workforce Australia participants. And in my opening statement, I touched on some of the issues that they traverse in around people's social security benefits and mutual obligations. And so we have insourced, I think, well over 100. I don't have the exact figure there, but we've increased the numbers of public servants doing that work, and we may have even overall increased the number of people doing the work. We also insourced the PALM scheme, which was previously delivered by private providers, and I think over 250 people have become public servants who are now delivering that scheme, and that scheme involves people across Australia. Many of them are in locations where the PALM workers are, and so we understand that they're quite dispersed. They're talking with employees, they're talking with employers, and they're doing that direct service delivery on the ground. And so I referenced our census results before with respect to how our people feel about their current workload. And so certainly this is a busy department delivering a lot of things across employment and skills. The skills program has been very busy and seen a lot of reform since 2022. And we are constantly looking to make sure that people are where they need to be, and that does involve us having to be agile and review resourcing across the department to ensure we're able to deliver for government, both in respect of ongoing work like the PALM program or responding to job seekers' concerns through our call centre, but also to deliver with respect to unexpected things that happen where it wasn't planned and there was no budget allocation, and we need to redirect people from other important work into these emerging priorities.
So just then sort of leads to how's the department not only save money, there's been money saved by reducing spending on consultants and contractors, but also how's it driven efficiency and coordination within the department by having people directly employed?
Look, I think what I would say to that is that employees of the department are very invested in the work of the department. And I want to be careful here. I would never say our contractors aren't. I recall early on in the Victorian office meeting a bunch of people. I used to be state manager in that office, so these were people I didn't recognise, and they said, oh, I'm a contractor, I'm a contractor, I'm a contractor. But they really loved the work, and I think a number of those people have since been employed as employees or engaged as employees, and so I think it gives people certainty. We have people who are very committed to the goals of the department, and so it also gives us and them options as they learn the work they're doing to be moved into other functions a lot more easily. And there are some roles where I think we know it's very important to have public servants doing certain roles, in particular where they're exercising certain delegations, and we have the Code of Conduct and other values in the Public Service Act that operate with respect to that workforce. There's always going to be a need for and a role for people on a short-term basis, because that might match funding arrangements. And there are some areas, particularly in our IT, we have a very significant IT area that develops digital solutions that we use across our programs. We do have a number of contractors in that area, and that's reflective of the market. But you know, any one of them who'd like to become an ongoing public servant, go talk to Adam Shane, and he'll have a chat with you about what we might be able to do there, because we'd love to have many of those people on the books if the arrangements can be made to work for them.
Just my final question, it may have to, maybe assistance from the Minister on this, but the 20% cut that's been announced, that's been proposed effectively by Peter Dutton on the public service, what would a 20% cut in the workforce mean to delivering for programs and services to the Australian public?
Senator, firstly, I'll take the proposition of a 20% cut. I'm not sure exactly what has been formally said, and I'm conscious that approaching an election, you know, we have a large number of public servants who might become concerned about their position. You know, I will say that I have overseen reductions in resourcing in many different contexts before, and it would certainly be my responsibility to do that, implement any reductions in a fair and appropriate way and in a way that complies with my legal obligations about employee entitlements, as Minister Cash has been asking me about earlier today. You know, I think it's really important that we do work efficiently and consider different ways of working. Our census identified that There are a number of people who feel that the most significant barriers to them doing their best work relate to our structure and our way of working. So 55% of them said administrative processes get in the way of them doing a good job. We've got a process underway at the moment of asking people for ideas that help us reduce administration. We're a bureaucracy. A bureaucracy always has administration that it could make more streamlined. And nearly 70% of people said that work is being done at a higher level than it needs to be done. So we are also doing a lot of work around delegation and getting work done at appropriate levels. But I would say, noting what I said before about we do have a number of people who work outside Canberra in direct service delivery. So 40% of our people are based outside of Canberra. People like a lot of our workforce for the PALM program, people working with employment service providers and others are out in the field, like people I used to manage in our Victorian office, the people who are answering the phones to job seekers. We secured extra funding for more employees in that call centre I think it was the last budget, because the call wait times were pushing out, and that puts pressure on our people. It means that the participants are waiting longer for their help. And if, for example, they're a person whose payment's been cancelled or reduced because they haven't met their mutual obligation requirements, as we discussed it at the opening, they really need to talk to someone. And so, we do have a number of people who do work that directly impacts every day on the community, and any reduction is going to involve a person in my position making choices about where to direct those resources. Those choices are not always easy. And so that's probably as far as I'd say. I mean, I will say that public services, we're often asked to reduce in areas because a program is terminating or because certain priorities are no longer a priority. That's absolutely business as usual, but significant cuts do require departments to stop doing things or do things very differently.
Thanks. Back to...
Thank you.
Just make an observation, but again, I just want to echo also the Minister's observations again to the public, the public servants here, and particularly in this department, which many of us around this table have had dealings with over the last 3 years and prior. The hard work and dedication has been phenomenal, and the driving of the efficiencies and changes that you've done as a group is impressive for the country, because it actually makes a heck of a difference. I'd be particularly loathsome to see that the important work you do for the community, as well as the engagement with the communities. You've outlined the services that, waiting times improvements, the expectations of the community, of course. For those waiting times to be blown out by a cut in the public service is an effect on Australians that are employed around the country, but it's also a massive effect on the Australian community right around the country if that was to occur. Senator Cash.
Thank you. If I could just briefly return then to the wage underpayment issue, which I said I might come back to. Minister, could I just ask you, in relation to the letter from the Fair Work Ombudsman, back to the department, and in particular the assessment, the FWO's assessment of the information provided as part of the assurance process in respect of matters which are the subject of self-report, should not be regarded as an endorsement, that the department has been fully compliant with workplace laws at all times. Were you provided with a copy of this letter from the department?
I'd have to search my records, Senator Cash. So happy to come back to you on notice about that.
Yep. Were you aware of that letter prior to today?
I've certainly been aware, bearing in mind that this letter was sent on the 11th of September, so several months ago, which is why I want to check my records. I'm certainly aware in general terms of both the work the department has been doing to rectify this and its communication with the Fair Work Ombudsman. I've spoken about it with the Secretary offline on a number of occasions.
And have you expressed your disappointment to the Secretary in the fact that staff in your department were underpaid?
Well, I think you've asked me a similar question, not just at the estimate since I've been the minister, but before when I represented Minister Burke as well, and at all times in a public hearing, I've expressed my disappointment that this occurred, and our expectation that any worker gets paid what they're owed, whether they be in the public sector or the private sector.
So it's not acceptable, is what you're saying?
No, it's not.
So in terms of your awareness that your department wasn't fully compliant with workplace laws, and in particular noting paragraph 12, what action have you asked the department to take?
Paragraph 12.
Yes.
Paragraph 12 being the Fair Work Ombudsman's assessment of the
Correct.
information provided as part of the assurance process in respect of matters which are the subject of the self-report should not be regarded as an endorsement that DUA has been fully compliant with workplace laws at all times. I mean, my reading of that is that that's an observation by the Fair Work Ombudsman and doesn't require the department to do something in response to that. It's the Fair Work Ombudsman providing its assessment and them saying that should not be regarded as an endorsement that DUA has been fully compliant with workplace laws.
Correct. That's the whole point.
Yeah.
Yes.
What have you done to
Should not be regarded
The
as an
depart-
endorsement that you've been fully compliant. If I was sitting in your seat, you would be having a go at me if I had done nothing. So I'm asking you,
If you were sitting in my
what
seat, you'd be
have
cutting
you
workers' wages right
done?
across the economy is what you'd be doing, and cutting jobs.
What have
What have you
you
done
done
to
as
satisfy
the
yourself?
minister who lectures businesses? What have you done as the relevant minister? You have a letter from the Fair Work Ombudsman in relation to an underpayment by your department of 201 employees. What have you done in relation to that part of the letter that says this should not be regarded as an endorsement that DUA has been fully compliant with workplace laws at all times?
Well, I repeat the point that if you were sitting in my seat, you would be... Can I answer?
No interruptions, please.
Senator Cash began her question by saying if she was sitting in my seat, this is what she'd do. And I'm reminding you that the last time you sat in this seat... You're really defensive about your IR stuff, aren't you? You don't want us to talk about your plans.
Answer the question,
The last time Senator Cash... Well, you really are defensive. I've said very little today.
There is one question being asked by Senator Cash. There is an answer being given by the Minister. Minister, could you continue on your answer?
Thank you, Chair. The last time, Senator Cash, you sat in my seat, you presided over workplace laws and changed workplace laws that saw workers go backwards, that saw real wages fall 5 quarters in a row leading into the last election, and casualisation increase. So God help us if you ever sit in this seat again, and I'll be doing everything I possibly can to make sure that you don't sit in this seat again so that Australian working people don't have their wages go backwards.
So in relation to the question...
In relation to this point,
take?
I have already said to you that in private conversations I've had with the Secretary offline, I know that she's very clear about my expectation and has been clear that this be fixed. You've already heard that the Fair Work Ombudsman does consider the matter to be settled. I'm sure that everyone involved in this will learn from this and do everything they possibly can to make sure it doesn't happen again.
When you say I'm sure, as the Minister responsible for this department, what actions are you again taking to ensure that this does not occur again?
Well, I'll hand to the Secretary who can...
I'm asking you as the Minister.
I know. You would be well aware that the administration of any department is the responsibility of the Secretary. The Secretary has taken you through on numerous occasions the work that she and her team have done to rectify this and to ensure that it doesn't happen again. And what I've said to the Secretary, and I'm sure she's clear, that my expectation is that we won't see a repeat of this again because of the procedural changes they put in place.
And in relation to, as I said, paragraph 12, what discussions have you had with the Secretary in relation to potential non-compliance with other workplace laws?
I have not got out every clause in the Fair Work Act and gone through it line by line with the Secretary to ask whether they are complying with every one of those laws. I think the Secretary is clear that it's her responsibility to ensure that the department complies with laws, as is every Secretary for every department, and the Secretary's given you chapter and verse on many occasions about the work that she and her team have done, which I support.
The issue I have is you have a letter from the Fair Work Ombudsman, and again we'll explore this with the Fair Work Ombudsman this afternoon.
A letter to Ms Jenkins rather than to me.
A letter, so, no, I said we have a letter from the Fair Work Ombudsman.
But it was a letter sent to the department correctly.
Yes.
Because it is the department's responsibility.
Correct, but what I'm saying is you have a letter from the Fair Work Ombudsman which states that the department you are responsible for may not have been compliant, and your attitude appears to be that you don't really care. That is my worry.
That's not what I've said at all.
What have you instructed the Secretary to do?
Don't verbal me.
What have you instructed the Secretary to do?
Senator, we have traversed in a number of the hearings the roles and responsibilities of ministers and secretaries with respect to these matters. We have both Minister Watt and Minister Burke before him have asked to be kept informed, have from time to time, I have a recollection of one occasion of being very specifically asked about future audit programs by the former minister, and we have briefed them appropriately. As I'm reviewing the transcript from the 6th of November at estimates, I note that Minister Watt said, we've certainly discussed the matter. In fact, I think quite recently I received a written brief from the department advising me of the finalisation of the matter, which would have been after the letter from the Fair Work Ombudsman was provided to us. It's something, this is Minister Watt, that I've checked in on both directly with the Secretary and with my office, who then communicated with officials in the department. So I consider, and I've said on a number of occasions in this hearing that, or in these estimates committees, that it is appropriate for the Secretary under the PGPA and the Public Service Act to be dealing with this matter. The ministers have been kept abreast of the matters, and they have made very clear to me their expectations that this should be a priority, and we've had appropriate traversing of that topic in my view.
Could I now turn to one more section in cross-portfolio, and then we will, subject to other senators having questions, be able to move on. Secretary, could I just go back to the letter that Senator O'Sullivan and I had sent to you? And again, in that letter, we asked you for information in relation to the CFMEU administration, and in particular any correspondence between the department and representatives of the CFMEU since the last budget, any correspondence between the current minister and representatives of the CFMEU in the same time period, correspondence between the former minister and representatives of the CFMEU since the last budget, notes or records of phone conversations between Dura and the CFMEU since the last budget, notes and records of conversations between the current Minister for Employment and the CFMEU since the last budget. The response was questions 8 to 12 refer to interactions between representatives of the CFMEU and variously the department, the current and former Minister for Employment and Workplace Relations and their representatives since the May 24-25 budget. The department ministers and their officers interact with the CFMEU and its representatives in different contexts. We didn't get anything provided to us though. So again, I ask you, there is a reason that you weren't able to provide us anything in relation to what we had asked for?
Senator, So as the response notes, we are engaging across the department with a number of stakeholders about a number of things, as are our ministers and former ministers, and we don't centrally record interactions with the CFMEU, noting that at the moment the union is being run by an administrator, but also noting, for example, we have across the department a number of different ways or reasons we might be engaging with the union. So, for example, the Jobs and Skills Councils, Build Skills, is doing really important work around the skills required in that industry for the future, and I would be very surprised if there weren't members on the board or people participating in that process who aren't associated with the CFMEU or the Jobs and Skills Australia is engaging with industry all the time about skill shortages, and we have a large number of programs where unions and employer organisations are relevant to our work. This is not information centrally held, and particularly when asked about correspondence, phone conversations and any records, that would be a very comprehensive search we'd need to conduct, and it's not something that the department can do without a decent amount of resourcing, and certainly not in the time frame within which we were asked.
So did you undertake any searches at all for us? If the answer's no, it's fine. The answer's no.
Look, I think that I would have, as I have in the past, when asked for correspondence, my first thought always goes to, and I do ask about what's centrally held. So, for example, if you're only asking about formal correspondence, we could search our PDMS system and we could find that. But when the ask is about any correspondence, that includes emails, and when the ask is also about meeting notes, which might be everything from people's notebooks to sitting on their laptops, they might be varying degrees of formality. We start to get to a large range of material, and I was very confident in my view that this was the kind of question which, without a formal search of the standard that we would do, say, for example, for a freedom of information process, I wasn't confident that I'd be able to identify what you were looking for in any sort of way that was accurate or comprehensive in responding to your question.
And not one of the 4,373 ASL could have done this work for you?
Senator, that was my decision. Under the PGPA Act, it is my job to manage the resources of this department in a way that is efficient, ethical, effective and economical. And every day, every one of us is weighing up relative priorities, as we discussed earlier with respect to resourcing and workload. These are issues that I consider, and so that's the call I made.
And given this is Senate estimates, and given obviously in particular the administration of the CFMEU is incredibly important and something we wanted to explore, I have to say, I personally find that decision very disappointing.
Can I just make one point, Chair? One thing we have done to ensure the committee is fully informed is I tabled the report from the administrator, which I only just received in the last few days. I was not required to table that report for quite some time, but I made a judgment that it was in the interests of the committee and transparency to table that report. So we've certainly done more than was required to enable the committee to have some information about the administration.
Chair, I'm happy to move on from cross-portfolio or take a break if...
We might just take it back and resume at 11:05.
Perfect.
11:05?
Yep.
Thanks.
Fabulous. Could I just turn
Senator Cash.
Thank you. Thank you, Chair. Could I just turn to a line of questioning in relation to the Secure Jobs Better Pay review? And could I commence? Secretary, could you just take... I just want to talk about the statutory review that's underway. So the interim report's being handed down. We're still awaiting the final report, which I understand is due at the end of March. Just in terms of the reviewers, what is the length of contract for each of the reviewers? When did it commence and when does the contract terminate?
Senator, I'll ask Mr Manning, or perhaps more likely Ms Anderson, to address that question.
Thanks, Secretary.
Thank you, Ms Anderson.
Jodie Anderson, First Assistant Secretary, Safety and Industry Policy Division. I might actually have to get some assistance in terms of the actual date of their contract, because the review itself commenced. The Minister announced the review on the 2nd of October, and the report is due, as you noted, on the 31st of March.
And there is the interim report which has been handed down. So just in terms of the reviewers, what was the... how many are there?
Senator, there are 2 reviewers.
The 2, so that's Professor Alison Preston and Emeritus Professor Mark Bray?
That's correct, Senator.
Okay. And just in terms of the contracts, what was the start date and what is the finish date?
Senator, we might take those details on notice, but we will endeavour to do our best to come back with you on those dates.
I don't have them in the room. Yeah.
Yes.
An approximate
they were
time
announced
frame?
in early October 2024.
Sorry, what was that?
The Minister announced their appointment in early October,
Yes.
so it'll be very close to that date.
Okay.
We'll just
and
come
just
back
then
to
the
the
period
exact
of
date.
time that they've been, I'll just say on or around, the period of time that they're contracted for?
It will be soon after they're required to deliver the final report on 31 March, but again, we'll confirm the exact date.
Okay, thank you. Are we able to get tabled the copies of the contracts for each of the reviewers?
We can take that on notice.
Yeah,
Senator.
Thank you. And just in terms of what is each reviewer being paid?
Yes, Senator, I can take you through that. The minimum contract value for both Professor Preston... Maximum, contract value is $155,912, and that's for both.
That's for both, is it? So divide by 2.
Each of them, sorry.
Oh, sorry. So $155,000. When you say the minimum contract value...
Sorry, that's the maximum contract value.
Right, the maximum contract value. So that the most they can be paid for November, December, January, February, March for 5 months is $155,000.
That's correct.
Is there anything on top of that, allowances, etc.?
Senator, that would equate to their maximum figure that we've got a contract with them. So we obviously keep close records of the spend attached to any contract.
That's fine. You'll give me the contracts if you can on notice. Just in terms of the selection process for Professor Alison Preston and Emeritus Professor Mark Bray, can you just take me through the selection process?
Yes, I might note that the department did initially conduct 2 procurement processes under the Commonwealth procurement rules to find a university or research institute to undertake the reviews in the first instance, but we had no suppliers submitted applications for that process. Then on the 2nd of October, the Minister announced the appointment of the 2 professors, and the panel members were appointed through a non-statutory ministerial appointment process.
So when you say the Minister announced the appointment, how were they chosen is what I'm trying to work out.
So they were chosen by the Minister.
Okay. So the department had no role in choosing these 2 names?
So having gone to market and not getting a response, the Minister then chose the reviewers.
Understood. So that so prior to their appointment by the minister, did the minister seek any advice from the department in relation to the appointments?
Senator, only to be informed that we were unsuccessful in going out to market.
We might just check the records on this. My recollection is that there was a brief to me from the department, whether we'd be recommending or suggesting the 2 reviewers that were appointed. I certainly don't, I don't know either of the reviewers, so I certainly don't recall saying, I want you to go and hire these 2 people. So we might just double check what advice was provided on that.
Okay, well, that's a completely different sort of analysis of what I've just been told. Secretary or Ms Anderson, what's your recollection then in relation to how you became aware of Professor Preston and Professor Bray?
Senator, I think we would have to take it on notice in terms of advice, what advice exactly was provided.
I'm not asking for advice. I'm asking for... your evidence is that the department did not procure these people, that your department was provided with the names from the minister or the minister's office.
Senator, that wasn't my...
That's what I'm just trying to confirm.
No, so I would have to take it on notice in terms of exactly what the exchange between the department and the minister.
Why has it suddenly become so difficult? We were doing so well.
Well, they want to give you accurate answers. You don't need to insult them that way.
So, Senator, what role did you play or your office play in the appointment of these 2 people?
Well, again, we've already said that we'll go and check the records of exactly how the appointment process came to be, but my recollection is that the 2 reviewers were recommended in some form, whether it be written, verbal, whatever it was, by the department. But we'll go.
So you believe they were recommended
that.
by the department?
That's my recollection, but we'll check whether that's correct.
Are you able to check so I can continue my line of questioning?
Yep, I'm sure we can get someone to have a look at that.
Thank you.
It's worth noting that the 2 reviewers appointed are leading Australian experts in the field of industrial relations and employment. So if you've got something to say about the reviewers, feel free to do so.
So in terms of the interim report of the review which was recently released, was a draft of the interim report provided to the minister, the minister's office or the department first?
Yeah, a draft. I certainly saw a draft of a report quite close to when the draft that's been released was published, and it was provided to us with a request to provide any sort of red line comments, given the engagement of people in the department with the reforms, just to make sure it was.
So, what is a red line comment?
So, was there anything factually incorrect? Is what I took it to mean, Senator. So
okay.
The views in the review are certainly those of the reviewers. The department hasn't influenced those, but we were given the opportunity to provide factual comment on a draft.
And just in terms of, Minister, were you provided with a copy, or was your office provided with a copy of the draft report?
My understanding is that my office was provided a copy of the draft report. I don't recall having reviewed it myself. My office spoke to me about the draft report, but I don't recall receiving it or reviewing it myself, but certainly it was provided to my office.
Okay. Did your office provide any feedback on the draft report?
Again, my understanding is that very high-level feedback, mostly of a factual nature, was provided to... feedback was provided by my office to the department, but whether that feedback was taken up or not, I don't know.
Are we able to get a copy of the feedback that was provided by your office to the department?
I'm happy to take that on notice.
Of course. Did the department put in a submission to the review? No, you didn't. I just want to...
No.
In terms of... Did the government make a submission to the review, or that would have been done via the department?
So the department provided secretariat support to the reviewers and continues to do so, but that's in the sense those staff are directed by the reviewers in terms of what they want. So the department hasn't been formally involved in the consultation processes.
Right, understood. So
I should say it hasn't been formally involved beyond that secretariat support. But it's
so what do I
beyond the secretariat support. So clearly the department's been involved in the consultation.
Yeah, no, but I was talking about
understood.
Support. No, and I was more interested in the submissions. So that's fine. That you've answered that question. Just in terms of the interim report. It states that the abolition of the ABCC and the transfer of its powers to the FWO is operating as intended. So, Minister, was it the intention of the government then to allow the CFMEU to be overrun by corruption and organised crime?
Well, my recollection is that all of the allegations which surfaced on 60 Minutes about that happened when you were the minister. Or your government was in power.
Yes, and you'll also recall you voted against every legislative attempt to try and clean it up.
Well, to answer your original question, one of the reasons we've said that we don't support bringing back the ABCC is that all of the allegations of organised crime infiltration and bikie infiltration of the CFMEU and the wider industry happened while the ABCC existed, when your government was in power.
Yes, and again,
and it was our government. It was our government who
you voted against.
It was our government who enabled the CFMEU to be put into administration.
And that is because we actually worked cooperatively with you. Perhaps if you'd worked cooperatively with us, as opposed to opposing everything, the ABCC may have had criminal powers. One of the things that...
So it's our fault that you couldn't do your job in government.
It says... So, Minister, the review pointed out that the Fair Work Ombudsman lacks a range of powers compared to the ABCC. So, for example, the ABCC could issue compliance notices related to contraventions of the Building Industry Act, whereas the FWO can only do so in limited circumstances. The ABCC could also intervene in civil proceedings if it was in the public interest. Whereas the FWO does not have these powers. So given these constraints again, how does it continue the justification that the FWO is an adequate replacement for the ABCC when this is continually raised, the lack of powers? And we'll again explore that with the FWO this afternoon, but in particular, the finding from the interim review.
Well, I'll let the officials expand on this if they'd like to, but you haven't mentioned the fact that the review at page 39 said that the review panel has not been presented with or seen evidence that the regulatory approach of the ABCC or the powers and penalties that were available to that agency necessarily resulted in greater compliance in the commercial building and construction sector.
Well, I'm asking you about these findings.
Well, and you'll see also that, you know, partly because of that lack of evidence and partly because of the other things that the review panel had to say about the ABCC, they've said in their draft report that they do not make any recommendations relating to the abolition of the ABCC.
No, but again, I'm asking you about specifically the powers.
Well, it's not for me to judge what the review panel recommends. You'll see within the report, by and large, I think their words by and large were that the Act was operating as intended, that it was starting to see wage rises delivered, all of the things that our government wanted to see happen after 10 years of wage suppression by your government. They have made recommendations about changes in some areas, in particular fixed-term contracts, and presuming that remains in their final report, we'll obviously consider that, but they haven't made any recommendations to change arrangements about the ABCC or the FWO in this respect.
So at this point in time, the government's not considering giving the FWO any additional powers?
Well, that hasn't been recommended by this panel.
No, but I'm asking, so at this point in time, the government is not
I'm just trying to think about whether...
Given them any additional powers.
That's a broad question. I mean, Do you mean about the construction industry?
Correct, exactly. In terms of the powers that the ABCC had versus the powers that the FWO have and the difference in them.
I don't recall us making a decision to grant the FWO extra powers. No.
Okay, thank you.
If that's wrong, I'll come back to you. But I don't recall us having done that.
Okay.
And again, we've made the point before that not only I know you're very committed to the ABCC, just as you're very committed to the deregistration of the CFMEU, which is the most insane idea I've ever heard. That means John Setka and people like that would be operating in a totally unregulated environment, but that's your policy. But we've also said we don't support the ABCC being brought back, partly for the reasons that I've gone through, that all of the stuff that we've seen on our TVs happened while the ABCC was there. Productivity in the construction industry fell while the ABC was in place. And, of course, we all know the stories about them pursuing ridiculous cases about stickers and flags and things like that. The FWO, you'll be able to hear from the FWO this afternoon. The FWO, with the additional powers and roles and responsibilities they have recovered significant amounts of unpaid wages towards construction workers, things the ABCC never did. So we think it is appropriate for the FWO to regulate this industry as it does every other industry.
In a media release from former Minister Burke on the 24th of July 2022, when you were abolishing the ABCC, the Minister, just like you, described the ABCC in slightly different words, as a body that wasted taxpayers' money on trivial nonsense. The courts, however, did find that in the cases that the ABCC brought, in the majority they were justified and fined the CFMEU over $16 million. In 2022, the ABCC brought a case against the CFMEU and one of its officials, Aaron Platt, over allegations he threatened and verbally abused the manager of Woolworths Distribution Centre with comments such as, "Get effed, you see, and this is a small industry, I can make your life hard." Is that what you call trivial nonsense?
So the best you can do is go back to cases in 2022 rather than talk about what's actually happening in the construction industry now.
I'm asking you made a comment in relation to the ABCC, so has Minister Burke. Do you consider that trivial nonsense?
When I just made the comment that the ABCC was pursuing trivial cases such as those involved...
And I'm asking you, is that a trivial case?
You're cutting me off. You're choosing part of my sentence and not the rest of it. I said they were pursuing trivial cases like those involving stickers and flags. Perhaps, Senator Cash, we can debate these matters at the National Press Club along with whatever other secret plans you have for workplace policies at the next election. Would you like to join us there?
Is that...
Are you finally going to tell people what your policies are?
Is that trivial nonsense?
No, I think those sort of comments are unacceptable.
So in March of 2022, and again, the CFMEU was fined $16 million by the courts. The ABCC launched a case against the CFMEU for allegedly making death threats against workers who tried to cross a picket line, actually in my home state of Fremantle, and whose workers were told, "You'll end up dead if you keep going on like this." Is that another case of trivial nonsense?
Again, I think those comments are unacceptable, and I would make the point that as recently as last week, the Fair Work Ombudsman, who now has responsibility for regulating the construction sector, is bringing cases against CFMEU officials or former officials like John Setka. Only last week they announced that they're bringing a case against John Setka for his comments, actually, about the former head of the ABCC. So so the point being, the FWO is doing its job in regulating behaviour in the construction sector, as it is in every other industry, and the ABCC referred a range of cases to the FWO for continued prosecution, and the FWO made its decision about which were the trivial cases that shouldn't be pursued further and which ones were serious and should, and that's what they're doing.
Minister, can you point out any similar proceedings then that the ABC had brought that the FWO has taken against the CFMEU before the building bad media reporting? I
think that's probably a question better put to the FWO when they're here this afternoon.
Were you aware of anything that they did?
Again, let's talk about that with the FWO. That they'll have a lot more information available than I do.
I think, Senator, I agree. The question, if I was best able to answer the question, I think they've previously given evidence around underpayment cases, prosecutions that they've brought, which the ABC would have been able to as well, but they'll be able to confirm the details.
Yes, but in relation to threats, intimidation, etc., are you aware if the FWO has ever attended a building site?
I'm very confident their officials have, but that's why we've got the FWO called later this afternoon.
It's actually one of the key differences between the FWO and the ABCC. There's no KPI to actually attend building sites.
Maybe appropriate time now to rotate the call. Senator Gregor.
Thank you. As the Minister articulated very clearly in his opening statement, wage rises are not an accident under a Labor government. We've been really clear about our intent to improve wages and conditions, which is in stark contrast to the Coalition's deliberate strategy to keep wages low. Can you just step us through what the general trend on wage growth has been between 2014 and 2021?
Mr. Cowgill will do that for you.
Thank you.
Thank you, Senator. Matt Cowgill, Chief Economist in Workplace Relations Group. On average, wages as measured by the Wage Price Index averaged 2.2% over the period between 2013 and May 2022. And since that time, the Wage Price Index has grown at an average of 3.7% per year, Senator.
Because that's a significant difference.
Nominal wages growth has increased over the recent period. That's correct.
Well, that's great to see. Obviously that's money in people's pockets. That's actually keeping pace, well, not quite keeping pace with inflation, but certainly getting a lot closer than when we had been in the preceding years. I'm also interested to know, can the department give us some information on the Commonwealth's intervention into the modern award review to protect penalty rates for working people?
I think technically it's my intervention rather than the department's, but certainly the department has done a lot of the background work on that.
Okay.
Changing witnesses.
Yes, sorry about that.
Yeah. I might start, Minister, and then we can direct questions to
that
those
great,
with more knowledge. So on 21 February of this year, the Minister exercised his power to intervene under Section 597 of the Fair Work Act to lodge a submission in this matter. Essentially, the Minister's position set out in his submissions guided by the following general principles. Firstly, that the wages of low-paid workers shouldn't go backwards. Secondly, that a fair and relevant minimum safety net of terms and conditions of employment is fundamental to award-reliant sectors, particularly those that are low-paid and female-dominated. And further, that penalty rates and overtime rates are an essential feature of the minimum terms and conditions in modern awards and shouldn't be reduced by the variations being sought in this particular matter. And also that bargaining is the primary mechanism by which trade-offs in terms and conditions of employment should be sought.
So this is relating to an application from the Australian Retailers Association?
That's right. The proceedings are technically a combination of applications, including one from the Australian Retailers Association, which has got quite a bit of media recently.
Okay. Minister, why did you take this action to intervene in this particular case?
Well, it is unusual for a minister to intervene in an award variation case, but as you know, our government has worked very hard over the last couple of years to lift wages. And you got the statistics just then about how much higher they are under Labor than they were under the Coalition. And I was very concerned about the prospect that the supermarket chains and big retailers were seeking to remove penalty rates from awards covering retail workers. Obviously, awards are a safety net. They are the minimum pay and conditions. And the workers that we're talking about here are not highly paid. I've seen some of the retailers try to argue that it's about senior staff, as if that's a reason to remove penalty rates. But the people we're talking about here, while they may have managerial roles in stores, they're earning as little as $53,000 a year. It's somewhere between about $53,000 and $61,000, $62,000 a year, way below average weekly earnings. Highly feminised industry. And my view and the government's view was that we shouldn't stand by and allow the supermarket chains and big retailers to remove penalty rates from those low-paid workers. And as Mr Manning has said in my submission to the Commission, I've made the point that there is the ability under our workplace relations system for employers, workers, unions to negotiate trade-offs between pay and other entitlements, but that should happen through the enterprise bargaining system, which is supervised by the Fair Work Commission, where the agreement that's reached has to pass a better off overall test. None of that would apply if these changes from retailers were to go through. And, you know, while I've got the floor, I might make the point that it was very disappointing to see Senator Cash and the Coalition indicate that they will not back our intervention. They've said that it's a matter for the Fair Work Commission. They won't get involved in this attempt from the supermarket chains to remove penalty rates. And that reminds me a lot of the approach we saw from the Coalition when they were last in power, when they never once made a submission to the Fair Work Commission to lift minimum wages. Not surprisingly, we saw wages flatline or in many respects go backwards under the Coalition. We had a change of government. Labor has made submissions to the Commission seeking rises to the minimum wage, and that has occurred. So there's a really stark example of what can happen when you've got a government that's prepared to speak up on behalf of low-paid workers, because that would seem to result in wages going up, versus a coalition government that will just give the green light to supermarket chains and retailers to do whatever they want.
And when we're saying to do whatever they want, you're talking here about people on not high wages. You're talking in the sort of $50,000 a year kind of wage bracket. Why are they looking to reduce the terms and conditions for those people?
Well, I guess you'd have to ask the retailers, but their argument generally is that they want to simplify the awards. And what we say to that is that we're all for simplifying and modernising awards. The reason this award is being reviewed by the Commission is that former Minister Burke set up a process for them to be reviewed and to be simplified. But simplifying an award shouldn't mean that low-paid workers take a pay cut. And that's what the retailers are.
It's just robbing people of the
correct.
money they're entitled to.
Especially at a time when people are doing it tough. And that's why I was surprised that Senator Cash said a future coalition government would do nothing about that. But again, maybe that's something she can debate with me at the National Press Club if she's up for it.
I'm very much looking forward to watching that.
How about it, Senator Cash? Senator Cash? Calling Senator Cash. Senator Cash doesn't want to have a debate, it would appear.
Well,
just like she never answers questions and doesn't do media outside the Sky News studio. What are you embarrassed about your wages policy? Is it 10 more years of wage suppression? I'd be pretty embarrassed about that too.
I should start charging you rent, quite frankly, for living in your head, Minister Watt.
Why don't you? Well, you are in my head because you are a massive risk to working people's wages, just as Peter Dutton is. And I'm going to do everything in my power and every fibre in my body to stop you becoming the Minister for Workplace Relations, because I don't want to see working people's wages go backwards. But I look forward to debating you about that at the National Press Club.
Hear, hear. So on that, Senator Cash has said quite clearly, I think in a Closing the Loopholes second reading speech, that the Coalition will always be on the side of employers.
I remember it well.
And we know that there are some employer organisations who have pushed to scrap penalty rates, minimum hours of rest, overtime, all of those types of conditions that we see. when we're looking at this move that you've intervened in, what sort of entitlements are workers going to be losing? These workers who are not on excessive wages by any stretch of anyone's imagination, around that sort of, 50,000 a year. What are they going to lose
in the retail award
Senator
case?
Cash gets away?
In the retail award case?
Yeah.
So the range of entitlements that retailers are seeking to remove in return for what would actually be a very small pay rise in dollar terms include penalty rates, overtime, breaks, paid breaks, annual leave loading. There may be others I've forgotten.
Certain part-time provisions, certain allowances, payment for work on a public holiday as well.
So, it was only last week, and Senator Sheldon was there, we met with retail workers, great people who feed the rest of us, clothe the rest of us on weekends, weeknights, unsociable hours. They're not earning a lot of money. These are not rich people.
But they're doing a critical job.
Doing critical work for the rest of us to be able to live our lives and to shop when it's convenient for us. And they made it very clear that if they were to lose their penalty rates in particular, let alone the other conditions, that would have a massive effect on their weekly income, notwithstanding the small pay rise that the retailers are offering in return for that. And outside of the enterprise bargaining system, which has all those safeguards about the Fair Work Commission supervising it, better off overall test, etc.
Well, that certainly doesn't sound like anything like a fair swap. Good luck in the intervention on that case. It's a disgraceful move.
And it's not too late for Senator Cash to tell us that she'll stand up for those penalty rates like we will. What do you reckon, Senator Cash?
I have a series of questions in relation to another.
Won't stand up for penalty rates. There you go.
If I'm
well, that's a.
I mean, they have voted against penalty rates 8 times, or Peter Dutton has at least. So, back to the future under the coalition: low wages, insecure work.
Well, it's not even just this term of government. While Labor's been looking to increase the terms and conditions for working people out there, that they've voted against everything. I think their 10 years in government was a disgrace, and prior to that, they voted against anything meaningful and progressive in terms of workers' wages and conditions and keeping people safe.
Correct.
Chair, thank you.
We've got a few more minutes for our slot. I just wanted to sort of ask, before I go to Senator Pocock, just to finish off. There was a worker, Darren, who works at IGA in New South Wales, and Darren says he works 38 hours a week from 5 a.m. until 1 p.m. because Darren relies on those penalty rates that he receives because he's a single father, and the extra money is critical in supporting his daughter. Now, he says that we're some of the lowest paid workers in the country, but if they take that away, they're putting us further down the breadline. Minister, how concerned are you for Darren if this happens?
Well, I'm very concerned about Darren and people like Darren who, as you say, work, unsociable hours. Did you say 5 a.m. to 1 p.m? That's pretty early in the morning. Single father, I think you said.
That's correct. And a young daughter.
Young daughter, who goes out of his way to do that work for the rest of us and stands to lose his penalty rates. And again, it would seem that Peter Dutton and Senator Cash are happy to just stand by and let that happen without putting up a fight. Well, I'm going to put up a fight, and our government's going to put up a fight.
Well, I'm looking, that's hard-working Australians and people like Darren, deserve someone in their corner.
Exactly.
This is an important case for lots of hard-working Australians.
Exactly.
Senator Pocock.
Thank you. I'm racing to get to another committee, so brisk answers much appreciated. Minister Watt, fulsome of course, however, you recently were quoted in the Fin Review saying government was developing several pieces of work all aimed at ensuring use of AI in Australia is safe, ethical and responsible. We've heard in this committee this morning with the Secretary's document in relation to the automation of payments, the possible hazards that lie in automation of key decisions around benefits and the extraordinary consequences they can have for people they affect. What are the pieces of work that you have in development? Topics, deadlines, and who are you talking to?
Sure. So this is an issue that I've got an active interest in. I presume you'll have an opportunity also to ask questions in the industry department estimates.
Yep, I'll be there.
As you probably know, they're the lead agency within government for AI policy. So both I and my department are working closely with Minister Husick and his department about that general piece of work. But in addition to that, you'd be aware, and in fact you may have participated in a couple of recent parliamentary committees. Yeah, and we're in the process of considering those responses. So I guess we're at the stage of considering what needs to be done rather than having decided what needs to be done. In addition to that, the National Workplace Relations Consultative Committee that Minister Burke set up, the tripartite group, considering a whole range of workplace relations matters, they have a subcommittee looking at issues around AI in the workplace. I understand they met on the 6th of February, so that's again an active piece of work there. And but one thing that has been done in this space, and I think in fact it starts today, is the deactivation code for gig workers. So some of the reforms that I think this was introduced through one of the closing loopholes bills. As you'd be aware, Senator Pocock, with the growth of employment in the gig economy through apps, we have seen a whole range of workers, aged care, ride share, delivery drivers, not enjoy the rights of employees. And the way the law currently stood, those workers could be terminated without any review process, right of respond. The deactivation code applies from today and is, I guess, a very good example of the work that we're doing as we consider more.
Are you doing any work on the implications of using AI in relation to surveillance, recruitment and promotion in particular?
Again, that's absolutely one of the things that we're considering, and I think the reports of those committees had things to say about that as well. I mean, I think from the government's perspective overall, we absolutely see the benefits of AI and other forms of technology in the workplace, in the economy, the productivity gains that are possible, etc. But if not applied properly, those sorts of technologies can wreak havoc for workers in the workplace. And the examples you've just given are good ones. If they're misapplied or misused in terms of surveillance, recruiting decisions, you've probably written academic papers about the risk of bias in AI-driven recruitment processes. So all of these things are exactly what we're looking at.
Have you looked at European models of AI regulation?
I've looked at some of that personally, but certainly I know the departmental officials have had a much closer look than me, and I'm sure they're happy to talk to you about that if you'd like them to.
Are you looking specifically at the uses of AI within the department in relation to mutual obligation and the failures in the last 7 years in relation to over 1,000 people having their benefits cut off?
Ms James probably knows a bit more about what the department's doing in terms of the use of AI, so I might...
Specifically in relation to making sure to get assurance that it's an automated decision-making is not having detrimental effect on Australian citizens and their payments.
Senator, with respect to the employment services programs, as I outlined in my opening statement, we are very much focused on automated decision-making in our system and the way in which the system is operating. There isn't artificial intelligence per se in this system, and the technical people will talk about artificial intelligence and machine learning as being distinct from automation. But we don't use artificial intelligence in our decision-making in that system.
And is that a government commitment, Minister, that you will not use AI in relation to decisions that affect the lives of Australians?
Well, I'm not sure that I can give a flat-out commitment about where AI will and won't be used. These are obviously things that governments need.
We have two huge disasters on our hands.
Absolutely, but what I can guarantee is that our government does want to have proper oversight mechanisms in place for these sort of automated systems. We'll probably have a longer discussion about this in Outcome 3, but
my
already,
will be
and I don't know if you were here for the opening statement from the Secretary, so we're doing everything we can to make sure those systems, which I might say we inherited from the Coalition, don't operate in a way that hurt people.
Look forward to the outcome of that discussion this afternoon. Have you looked at establishing a positive duty for employers to minimise the risk of AI and its negative consequences?
I'm not sure that I'd say we've reached any decisions about what sorts of changes we would make. As I said, we're really at the stage of considering some of those reports and doing, literature review, looking at what other countries are doing. So it's probably a little too early to say exactly what types of things we would do.
But we have moved in the health and safety realm to a realisation that duty of care is a very important way of framing these issues, to place responsibility where it belongs. So it is something you will consider?
I'm happy to consider that, along with a range of other ideas. This is an evolving field, as you know. Employer groups, unions, academics have all got all sorts of suggestions about what we should do. We've now got a couple of committee reports, so we're considering all of that.
Thank you. Can I move on then to portable entitlements? In February 2024, at estimates, the department said they were, quote, exploring the government's election commitment on portable entitlements, and we're looking to start consultations in the first quarter of that year. So that's a year ago from now. However, the government later agreed to employ a request to delay consultation on portable entitlements for workers. Where's the department got up to with exploring the possibility of portable leave entitlements?
We haven't undertaken further work since that time.
You haven't undertaken any?
No, so that consultation you referred to, there's been no further action since the government decided that it wasn't going to proceed with it at that time.
And Minister, what's your view about not pursuing? Why have you not pursuing such an important issue for so many, particularly disadvantaged workers, to get access to leave as they move around the labour market?
I guess, obviously, that decision was made by Minister Burke. I wasn't really that close to the decision. I'm not exactly sure what his decision was based on, but I haven't chosen to reactivate that in the time that I've been the minister. There's been plenty of other things that we've been getting on doing.
I'm conscious of those.
Yeah.
But, I mean, this is a very important issue that you made an election promise on, and it's seen no progress. Is that what you concede?
Well, I concede Minister Burke made his statement at the time as to the government's position, and things haven't changed since then.
And are you making election commitments again in relation to portable entitlements for the next round?
There's an election coming up sometime before long, and we'll announce whatever commitments we make during that campaign.
Thank you.
But Senator Pocock, I wonder what commitments Senator Cash will make.
My time is short, Minister. If I can move on to the small claims review rather than see the rehearsal of the theatrical piece. The department recently put out a report on its review of the Fair Work Act small claims procedure. Who did the department consult for that review? I'd like to see a list of stakeholders if we could manage it.
Just get the relevant witnesses to come to the table, Senator. So I wasn't personally involved. My understanding was that the review occurred on a confidential basis, but I see Ms Brayshaw's got more information in relation to it.
Thank you, Senator. Elizabeth Brayshaw, First Assistant Secretary, Entitlement Safeguards Division. Senator, that is correct. The consultations were, the approach to the small claims review was to do a desktop review of literature and then to do targeted consultations. And so the approach that was taken was to be in touch with employer representative groups, business representative groups, academics and community groups on a targeted basis. Following some initial roundtables, I understand that they were provided a consultation paper and invited to make submissions. And that consultation paper wasn't for public consultation, but was for that targeted, and so was done on a confidential basis. And then I think submissions were provided, and people were asked whether or not they would like to have their submissions identified in the final report, and we did receive a couple at the time who said that they didn't want to be identified. So I think we treated it more in a... We reported on what was found during the process, but we spoke to those types of groups, but we didn't list those individual
So I'm asking you
organisations.
now, could you provide a list? I can't see a public interest argument against it. Usually you do provide those lists.
Yeah, we'll take it on. So we don't have it with us, Senator.
No, but if you could take it on notice, that'd be great.
Senator, are you open to us checking with those, particularly those two who said they would prefer not?
I'm not talking about the submissions, so I'll come to that.
Okay, right.
I'm talking about the list of stakeholders who were consulted.
Okay.
If you could supply that.
We will.
Thank you. And the review, I understand, received 17 submissions. You're saying 2 requested confidentiality. Will you be making, as I'm asking you to, those submissions public?
Senator, I think we can take that on notice, and if it's okay to check with those.
Of course, excluding those who seek confidentiality, but it sounds like that's only a couple.
Yeah.
Great. Thank you. Thanks for all your answers. Thanks, Chair.
Thanks, Senator Cash.
Sorry, just that was a small claims procedure review. I couldn't quite hear. The acoustics aren't great. No, thank you. Could I just follow up then? It was released on the 30th of January of this year.
That's correct, Senator.
That is correct. When was it meant to be released?
I don't think there was a date. It was finished a little while ago.
I think the report was dated February 2024.
That's right.
So why wasn't it released in February 2024? Why was it released almost a year after its publication?
Senator, my understanding is we provided the report to the Minister in June 2024.
June 2024?
That's right.
Right, okay. And it was only just released in January?
So, and my understanding, Senator, is just there was other priorities in terms of work underway before it was released. There's nothing more to it than that.
Okay, well, it's been sat on for 7 months and there are a lot of people interested in the small claims procedure review. One of the things in the media release states that the completion of the review is an important step, etc. So, in delivering a fair industrial relations system for all workers. If that's the case, why was the review not released in February 2024, given to the Minister in July 2024? Was this not seen as a priority?
It's clearly important work. I think there were other things obtaining higher priority status.
So what were those other things taking higher priority status?
Lifting workers' wages, doing same job, same pay, reducing the level of casualisation in the economy, getting rid of 10 years of wage suppression by the coalition, those kind of things.
So we get to the small claims procedure review report was basically sat on for 7 months. It was dated February 2024, provided to the Minister in June 2024, and then it wasn't released until January 2025. One of the other things it's stated is there's a reference to work already underway on several of the recommendations. What recommendations is there work underway on?
Just while Mr Manning or his colleagues gather the answer to that, I might remind you, Senator Cash, that this review was commissioned by this government arising from matters investigated by the Migrant Worker Task Force, which spotlighted significant exploitation of migrant workers while your government was in power. So I can't recall the reason why there may have been some delay in tabling that review, but it's worth remembering that it was this government who even bothered to do something about this issue.
Could I just get an answer to my question? What are the other recommendations about which work is underway?
Yes, thanks, Senator. In terms of the report had 12 recommendations,
Yep.
and they cover both this portfolio but also the Attorney General's Department's portfolio. In terms of some of the recommendations, that work is already underway. There is currently, recommendation 6 refers to enhanced safeguard measures that would enable migrant workers to pursue recourse for workplace exploitation. And so one of the things that is underway is the Workplace Justice Visa Pilot, which is primarily
Workplace Justice
Visa Pilot.
And just remind me when the pilot started.
It commenced on 1 July 2024.
Yep.
And so it allows visa holders to extend their stay to pursue their workplace exploitation claims, and that's a pilot that Home Affairs has the lead on. Some of the other recommendations also go to the need for helping people, particularly vulnerable people, trying to navigate these schemes, what sort of support both the courts and the Fair Work Ombudsman can help them in terms of the types of materials. And I understand that the Fair Work Ombudsman has been doing work to assist in relation to that. And so they might be able to speak more to it. Some of the recommendations go to legal assistance and the Federal Court and Federal Circuit Court's procedures. So I think Attorney General's Department would be a better place to speak to
understand that aspect. That's fine.
And then I would say that some of the recommendations I note were also considered in the interim report of the Secure Jobs Better Pay. So, for example, one of them relates to the effects of the increased monetary cap, and that was a recommendation that once data on that becomes available, the Department of Employment and Workplace Relations should consider whether any additional changes to the procedure are necessary. And I think at this stage, those provisions have been in place for approximately 18 months. We've been talking to the courts around getting some further data just to better understand, but that's still a work in progress. So there's some of the examples of things that are progressing.
Just in terms of the reference to enhancing safeguards for vulnerable workers, is that the recommendation 6, the Workplace Justice Visa pilot?
That is my understanding, yes, Senator.
That is what that one was. Thank you. Could I just turn very briefly to, just in the interest of time, the appointment of the new chair of Safe Work Australia?
I'd love to talk about appointments by governments to industrial organisations and tribunals. Shall we start with your stacking of the Fair Work Commission?
My question is, does Mr Mayor still occupy his current job as the National Head of the Mining and Energy Union?
Mr Maher?
Mr Maher?
I believe he does.
He does.
Just as Ms Joanne Farrell, I'm not sure whether she was still at Rio Tinto or had been when you appointed her, and I mean no disrespect to Ms Farrell. I'm told she did a very good job.
So can I just confirm then, you just said Mr Maher does still occupy his current job as the National Head of the Mining and Energy Union?
I believe so, and I believe that someone like Mr Maher, who has spent his entire working life standing up for the safety of workers in the coal mining industry, an inherently dangerous industry, is a really good appointment. And you will have seen my media release when I announced Mr Maher's appointment went through his extensive experience in workplace health and safety matters.
So if I just recall when, I think it was Minister Gillard, herself in 2019 had stated Safe Work Australia will be an inclusive tripartite body comprised of 15 members, including an independent chair. Given that the new chair still occupies his current job as the National Head of the Mining and Energy Union, you don't see a conflict of interest in him holding that position as well as being the independent chair?
No, I don't.
Okay, good. In terms of the obligations under Section 11 of the Safe Work Act, which I am assuming you're familiar with, the consultation with the relevant state and territory ministers in relation to the proposed appointment to the position. Can I just confirm the government did undertake the consultation?
Yes, we did.
Okay. When did that commence?
I wrote to all state and territory ministers on the 6th of December 2024 to consult them on my intention to propose Mr Maher for appointment to the role of chair.
Okay, so you wrote to them?
I wrote to them, yeah.
Did the department contact them at all?
My office, I'll let the department respond as to them, but my office, I understand, also called each of the state and territory ministers' offices before the letters were dispatched and advised them of the proposed appointment, and that feedback was requested by the 9th of January.
9th of January.
About a month.
9th of January. Was feedback received from the states and territories?
My understanding is that As of the 9th of January, there'd been one response and no objections were raised.
And who was the response from? Which state?
My recollection is it was
territory?
Queensland, but I'm just double-checking that with my office.
Queensland?
And we received a response from the Tasmanian Minister well after the date. Sorry?
Western Australia.
Oh, Western Australia. Yeah. Was the one who responded in time?
Yeah.
Okay.
So Western Australia responded?
Western Australia responded by the 9th of January.
By
Sorry,
the
I
9th
thought
of
it was
January.
Queensland.
So when did the other states or territories respond?
I'll let the departments answer.
Oh, if you could take me through it, thank you.
Yes, so on the 21st of January, we received a response from Queensland.
Queensland.
On the 28th of January, we received a response from Tasmania.
Tasmania.
And on the 2nd of February, we received a response from the Northern Territory.
On the
2nd of February.
2nd of February, from the NT?
From the Northern Territory, that's correct.
And any others?
Apologies, Senator, I've just realised I didn't introduce myself for Hansard.
That's okay.
Sarah Godden,
We know
Chief
you, it's
Counsel,
all right,
Workplace Relations Legal. We didn't receive any responses from any other responses from states or territories, Senator.
Right, and are you able to table those responses?
I can take that on notice, Senator.
Can you? And in relation to the response from Queensland, what was that? What feedback did they provide?
I don't have the response in front of me, I'm sorry.
Does anybody at the
Senator.
table recall what the feedback was?
I've got a summary that it neither supported nor objected to the appointment of Mr Maher, but noted the union role.
Okay, and from Tasmania?
I have a summary that Tasmania expressed concerns.
Expressed concerns. And the Northern Territory?
Expressed no concerns, but I'm sorry, I'm going off summaries.
No.
Senator, I don't have...
We'll table them. So, Minister, were you made aware of the response from the Tasmanian government?
Certainly my office was, but as I say, those responses were received well after the date that we had asked for feedback by, and in fact, Mr Maher's appointment had been approved before we received those letters from those states. Because,
So when you say approved, what does that mean?
well, you understand what the processes are within government about
That's what I'm saying. So you mean
Yeah.
that formal approval process, the formal approval process.
So he had been formally approved prior to us receiving those letters, because, as I say, that was at least 3 weeks after we'd sought that feedback.
And you'll table, I mean, I know you don't have them with you, that's fine. You'll table the responses, and including the one from Western Australia, if that's at all possible, on notice.
I've taken that on notice, yes.
Yeah, no, thank you very much. Could I just go now to, and I know we discussed this last time, but we weren't able to get any information from you in relation to the CFMEU administration. This is more of an operational issue. I know that the case is now finished. The judgment is being written, so no further evidence is being taken. So can you just give me an understanding of the relationship now between the department and the administrator?
Well, essentially, the administrator steps in the shoes of some of the office holders and bodies running the union. So it's a registered organisation like other registered organisations now. So our relationship is the same with it as it is for others.
Well, Mr Manning, with all due respect, this is as a result of a piece of legislation on the basis of media reports that identified that the building industry in Australia was rife with organised crime. So I think we all agree, very serious allegations, and that is why it's in administration. So I hope what your evidence is not that it's business as usual, because that would concern me if it was. So again, can you take me through what the department is therefore doing to oversee and ensure everything is going as planned?
So there's an existing regulatory regime which the union is subject to with the administrator in charge. So the registered organisations regime, which is part of the Fair Work Commission, the General Manager has responsibilities. So the General Manager has those obligations, as it does for all unions. Additionally, under the legislation that established the ability for a determination to be made to put the union into administration. There are some reporting obligations. I think the Minister mentioned earlier that the first 6 monthly report had been tabled this week.
That's it?
Well, certainly the department, if you're looking at the department's role, the department supported the government in the High Court litigation, which you've just referenced.
Put that
as well.
separately. The High Court litigation is a separate issue. That was a case that was obviously before the courts. Can you take me through then the interaction that the department has with the administrator?
Certainly, we interacted with the administrator as part of those High Court proceedings. We've interacted with the administrator... Separate
to the High Court proceedings?
Yeah, no, sorry, OK.
That was in relation to...
Certainly in relation to the report that was tabled.
So take me through what the contact was.
I'll hand over to Scott. So we... Oh, hang on, Scott.
Certainly, I had a call with the administrator earlier this week in relation to that report, Senator, after the department received it.
Right. So perhaps I take a step back further. Who is the point of contact in the department for the administrator?
There's no single point of contact, Senator. It would depend on the nature of the engagement. I would characterise our engagement with the administrator as required. And
Minister, I might just distinguish between a couple of different types of contact. So we referenced earlier that there is day-to-day contact. So, for example, sorry, not day-to-day contact, but there's normal contact that we might have with the union. For example, there are CFMEU representatives on the National Construction Industry Forum, and so when we're setting up the meetings and dealing with people and getting views relevant to that, there'd be a part of a department who's dealing with the union on that.
I'm specifically interested in the administration, Mr.
Sure.
Manning. Yeah. That is the legislation that went through the Australian Parliament.
Yeah.
So in terms of, is there any formal contact?
It's on an as needs basis, depending on our assistance of the government to administer that legislation.
Right. So how is the government satisfied?
I know Mr Manning has made this point, but it's the Fair Work Commission who, I'm not sure what the right word would be. It's not so much about regulating the administration. They are the regulators. So it's the Fair Work Commission who have that sort of oversight role rather than the department, and obviously there'll be an opportunity to talk to them this afternoon.
And I understand that, but given the gravity of this situation, given the gravity that over a very long period of crime, organised crime has infiltrated the building industry in Australia... When
you were in office, you mean?
Given the fact that we joined with you to place the union into administration, I'm trying to understand what role the government has, the department, in ensuring that the legislation is working as intended.
Well, that's specifically the role of the Fair Work Commission. It's set out in legislation.
And my questions are the level of the government's engagement or the department's engagement to ensure that it is doing as intended. Can I ask some questions then to see if the department has the answers to this? Are you aware if the administrator has been given full access to the CFMEU financial records?
I don't have any particular knowledge of the level of his access.
Okay.
Senator Cash, have you had an opportunity to read the report the administrator that I tabled yesterday?
I'm asking the questions.
I'm not trying to be a smart aleck.
No, I'm going through.
Because he does address some of this there.
I have a line of questioning that I will be asking in relation to the knowledge of the department.
Senator, perhaps if I could say the situation is an unusual one. You suggested it was business as usual before you used that term. I wouldn't describe it that way, but it is the case that the administrator stands in the shoes of the union, and the unusual way in which the administrator came to be in that position and that framework is obviously something where we supported the government with respect to, we continue to monitor, we speak with the regulators in this picture, the Fair Work Commission and the Fair Work Ombudsman, to ensure they're able to do their job. If there are questions about the interpretation of that framework, noting it is quite novel, we may become involved in that. Any information we have with regards to the kind of question you're asking, what the administrator does and doesn't have access to, that kind of information I would expect would only come to us either via one of the administrator's reports formally, or maybe via conversations the administrator might have with other regulators.
So under the legislation governing the administrator has to provide a general purpose financial report. To go to your question, Senator, we haven't been given any knowledge that suggests that he's unable to do that. That is in addition to his obligation to do and provide audited financial reports under the Registered Organisation Scheme. Likewise, that would be a report to the General Manager of the Fair Work Commission. Again, we're not aware of any basis upon which he wouldn't be able to do that.
And as is made clear in the report from the administrator that I tabled yesterday, he has also appointed a special purpose auditor to undertake a special purpose audit of the union's finances.
So perhaps we'll go through some questions then in relation to, just level of knowledge. Can you confirm whether the administrator has the power to conduct forensic audits into CFMEU financial transactions prior to the administration?
That's certainly what the Part 2A of the Registered Organisations Act and the determination that sets out the scheme of administration provides for, Senator.
Okay. Are you aware of when the administrator first looked to engage, the minister's referred to the forensic accounting advice, I'm assuming the forensic audit. Do you know when the administrator first sought to engage this?
No, that's a matter of day-to-day running of the union. That's a matter for the administrator, Senator.
Okay. Secretary, have you had any contact with the administrator?
Senator, the only engagement I have had with the administrator occurred at the meeting of the National Construction Industry Forum, I think on the 16th of October 2024, where the administrator...
Construction Forum?
Yes, the National Construction Industry Forum on the 16th of October heard from the administrator. That was the same forum where the body unanimously agreed that collaboration was required to deliver effective long-term change to the industry and agreed on developing a blueprint, a construction industry blueprint for this purpose. So that is, the administration was a response from government to the events that you've referenced. The other response was the use of the National Construction Industry Forum to work with industry on long-term cultural change, and that work is underway, and it was a very useful attendance by the administrator. It was quite early in the administration at that point at that forum. I don't believe I'd met Mr Irving before that point, in fact, but that, to my recollection, is the only engagement that I've directly had with him.
Can I just go to then the process in terms of the administration and something happening that is then reported in the press, and just the response from the department or even the government in that regard? So I'm just going to table a document. It's a media article. The CFMEU organisers ute firebombed in southwest Sydney. This was an incident in February whereby a CFMEU organisers' union car was firebombed in the middle of the night, just 3 months after his house was vandalised with the words CFMEU dog. Just in terms of the article, 2 union sources confirmed the car on fire was owned by an organiser whose house, driveway and fence were graffitied with slurs and vulgar images. The actions are believed to be an attempt to intimidate the organiser, who the Financial Review chose not to name for obvious reasons, due to concerns of retribution. Some union sources believe it may be related to a dispute with a disgruntled subcontractor, while others say it may be fallout between the union and the industry following corruption claims in the Building Bad investigation by the Financial Review and other 9 owned outlets. the organiser is understood to have been auditing the wages of the subcontractor at the time. So when something like that is raised in the press, I mean, these are very serious allegations, obviously, and for the person in particular whose car was on fire, what does the department do when you read something like this? What's your reaction to this?
Can I jump in and say, while the department prepares its answer, I can tell you what I and my office do and have done when these things occur. And obviously, this is just an abhorrent thing that shouldn't happen to anyone in any workplace or to do with any workplace. You'll see in that article that you've tabled, Senator Cash, it goes on to say that the New South Wales Police have commenced an investigation into the incident.
Oh, no, absolutely, as they should have, as they should have.
Because obviously there are different views as to what this was motivated by. But when there have been stories like this appear in the media, my office invariably contacts the administrator and his team to inquire about their welfare. And as recently as last week, I met with the administrator and to get a bit of a progress report from him, but in doing so, asked about the welfare of him, his team, the officials that are now working for him, and when other threats that haven't been reported, and I won't go into, I've made similar approaches.
So just in relation to this particular one then, was the individual whose car was firebombed, were they given any extra security?
I don't know that myself. I'm not sure. We'd have to take that on notice. I mean, but certainly, I mean, you'd be aware, and I think it's been reported, that there have been a number of officials and organisers who have been provided with security of some form, as has the administrator.
I mean, the article says it's referred to the police, which is what would expect to happen with actions like this. And in the administrator's report, he speaks about his engagement with relevant regulators, including the police, and how those relationships are going well, for want of a better term. So we don't know whether the victim of what looks to be a crime was given any police protection.
Is that security paid for by the CFMEU?
Well, police security, I just mentioned police security. So
yep,
no,
so but if they are given security, would it be paid for by the CFMEU?
The government has funded security arrangements for the administrator.
For the administrator, yes.
I'd have to get the details about whether it's just for him personally, whether it covers others, whether it's ongoing. I don't have those details.
If you could do that on notice, and who's actually paying for the security. And Minister, just in your comment, you mentioned other incidents. I don't know if you've said of violence, so I'm not going to say that you said that, but other incidents, I was referring to the car that was firebombed that are not reported. How many other incidents are we talking about?
Oh, I'd rather not go into that. But in terms of
my worry is there's still incidents of violence. I mean, you read about them, you hear about them. I have grave concerns, obviously, for the people who the violence is being experienced against. And my greatest fear is that the CFMEU, it's still overrun with organised crime officials.
Just on that, the incidents that I'm aware of that aren't in the media, and I don't intend to put in the media in any degree of detail, there are various allegations made about who's behind them. Sometimes it's about figures who are or used to be involved in the union. Sometimes it's employers. Sometimes it's labour hire firms. Unfortunately, the construction industry is one that has seen too much violence, and that's one of the things that we hope to clean out through the administrator's appointment. On the security point, just reaffirming, you asked for a bit. So the government has funded security for the administrator. Again, I don't have details about whether it goes beyond him or exactly the nature of that. Our view was, and again, it's never clear, or it's often not clear, exactly who is behind threats. So our view was that it wasn't appropriate to ask union members to fund that security when some of these threats may be coming from other groups not related to the union. And similarly, my view was that we've asked the administrator and his team to do a really hard job where they are literally risking their personal safety, and the least we could do is do everything we can to ensure they're safe.
Just in terms of the culture of violence, so Mr Irving is reported, I think it was an article in the newspaper, which I'm more than happy to have tabled. The CFMU administrator has launched an investigation into the culture of violence in Queensland construction industry after criticising the union's past leaders for getting drawn into cycles of retaliation against anyone who opposed them. Mark Irving QC announced in a statement, so it's his statement, he would force current and former CFMU state officials to cooperate with an inquiry into violence, threats of violence and menacing conduct, and flagged he would also look at employers who engage in such behaviour. Do you have an understanding of what that investigation will entail, the investigative methods that Mr Irving will be using, etc.? Will somebody run the inquiry? Is he running it himself?
I don't know an enormous amount more than what's been in the media. And again, the report from the administrator that was tabled yesterday has a bit more information about this. But in general terms, I'm aware that the administrator was concerned, based on preliminary investigations, about the level of violence in the construction industry in Queensland.
Yep.
And as you've seen, it's not necessarily just within the union. There have been media reports in Queensland, I'm not sure if you've seen them, with allegations about some employers using bikies to enforce security against union officials. You know, all of these things at this point are allegations, and Mr Irving has decided it's necessary to have a specific investigation about violence within the Queensland industry.
And exactly, the Queensland industry, very much so. There was in an article that was reporting on this, footage emerged of last year's brawls between striking and non-striking workers at CFMU picket lines at the Cross River Rail. Workers in high visibility vests were recording punching men in plain clothes on the picket line and dragging each other across the road. I think there was another situation where a worker at Brisbane's Cross River Rail project was bashed by two masked men with a metal pole for crossing a picket line. I'm assuming that the government has a very strong view on those crossing picket lines should not be subject to violence, intimidation, bullying or harassment.
I don't think anyone in a workplace should be experiencing violence.
And that is something the administrators obviously will look at?
Yeah, look, I don't know specifically exactly the incidents that he's looking at, but I think it's fair to say the administrator has formed a view that there is a problem relating to violence in the construction industry in Queensland, and that goes across the industry. It's not just within unions, it's not just within employers, it's not just within labour hire firms, it's across the industry. And he wants to see that cleaned up, and he has the government's full support in doing so.
One of the issues that's been raised with me is in relation to the non-union workers against whom this action has been taken. What steps is the government taking to ensure that non-union workers and CFMU members are not subject to violence, from the thuggish elements who are members or associates of the CFMU when they're going to work just to do their job on a daily basis?
Well, I guess a couple of things I'd say. Obviously, there are laws in Australia which seek to regulate people's behaviour in industrial disputes, and the Fair Work Ombudsman has a range of powers to take action if people behave in a way that breaches those laws. Secondly, when it comes to the activities of union officials and employees, I think I remember at the last estimates taking you through the guidelines the Administrator has issued to all employees of the union around menacing conduct to essentially set out his expectations around behaviour, and he's made very clear to people that those who fall short of those expectations will face disciplinary action.
So in terms of that behaviour, will the Administrator include that in part of the training that he's undertaking?
Sorry, could you say that again?
Will the Administrator include that as part of the training he's undertaking?
I understand he's already begun doing that.
Yep, okay.
And if that's wrong, then he certainly intends to.
Right, and I'll have to follow that up, obviously, hopefully with the Fair Work Commission might be able to...
Senator, can I just make one point on this, just in relation, you asked earlier about who will conduct the investigation.
Yes.
So it's just worth noting that in the report that the Minister tabled, the 3 attachments contain investigations where the Administrator has used others like barristers or people eminent in the field that a person with anti-corruption qualifications or experience to do the report. So I imagine he'll see...
Sorry, say that again. Sorry, I jumped in. I wasn't quite sure where
in terms of what the Administrator will do, it's worth noting that in the 3 reports tabled so far,
yes,
he has engaged others to carry out the investigations and to assist him to carry out the investigations. That's just one point. So I imagine that's a model he may continue to use in other investigations.
So just on that then, could I just ask, has the department had any discussions with Mr Irving about the inquiry into the culture of violence within the CFMEU?
No, I haven't. No, we haven't, Senator. And the other point I was going to make in terms of the aims of the inquiries, again, I think in the report, Mr Irving makes clear his intent and obligation to try and restore the union to one that's democratic, properly representing the members and operating lawfully. So to go to the question about whether he would be looking at unlawful behaviour by members, I think he would be, but of course I imagine he would also be very mindful not to cut across police investigations, noting some of those examples you gave are, allegations of serious assaults would be criminal, and if there is evidence of them already, I imagine the police is doing that, are looking at it already, and that Mr Irving would be very mindful to be assisting those inquiries rather than duplicating or cutting across them.
One of the issues that have been, again, raised with me is Mr Irving taking submissions about the CFMEU's culture of violence. There are people who would like to make a submission but they're not sure where to go to, and if so, will they be provided with anonymity? They're very worried to put their name to a submission about the CFMEU's culture of violence, but obviously if people don't come forward, the evidence base is not there.
Certainly in his report he spoke about the complaints mechanism and whistleblower mechanisms he's established, including the ability for people to make anonymous complaints, but I might hand on to Ms Godden to speak to that a bit further.
So Part 2A that was introduced, Senator, contains an obligation for the Administrator to set up a whistleblowing scheme, essentially.
Has that been set up?
Yes, it has.
So that was the Part 2A you referred. Yes.
Yep.
And it's received a number of complaints.
So the other thing that is consistently raised with me, and this is just smaller players in the industry, not big players who have access to finding out information. They don't know where to go, they don't know what to do, they don't know about their obligations, they're too scared to come forward, they're still receiving threats, they're not going to be media, they're not media savvy, they don't know where to go to. How is the department satisfying itself that these people do know where to go to? Because if you don't have the body of evidence, even though it's there, there's nothing to actually work from, and yet people are constantly saying, I'm being intimidated, I'm being threatened, my business, etc., but I just don't know what to do and where to go.
Yeah, so the Secretary referred earlier to our fairly regular meetings with the Fair Work Ombudsman and the Fair Work Commission in relation to these matters, Senator. The department is aware that both of those agencies have done significant work to establish mechanisms to obtain that information. So it's not just the Administrator setting up the whistleblowing scheme as he was required to do. The Fair Work Commission set up a dedicated sort of contact arrangements that was on their website, on their front page. I haven't gone to their website recently enough to tell you if it's still there, Senator, but it certainly was towards the end of last year. And the Fair Work Ombudsman has also undertaken certain activities that they can talk to as well. So the department's role has really been in speaking to the Fair Work Ombudsman and the Fair Work Commission about what they're doing that is complementary to what is being done by the administrator. And that gives people in the situation that you're talking about multiple avenues, so they could approach the police if it's a criminal matter, they could approach the administrator through the whistleblowing scheme, or they could approach either the Fair Work Ombudsman or the Fair Work Commission. So there are multiple avenues that people can use.
One of the other issues that is being raised again is in relation to the administration staffing issues, which are being reported in the press. So, for example, Travis O'Brien, the Executive Director of the Queensland branch, decided to leave the CFMEU administrator abruptly. People were very worried about that. Do you know why Travis O'Brien decided to leave the CFMEU administrator?
I think the administrator actually put out a statement at the time.
And what was the reason?
It was essentially that he had agreed, Mr O'Brien had agreed to take on the role for the, I think it was the establishment phase or some phrase like that that the administrator used, and he'd made a decision to return to being a barrister.
Sure.
I mean, these are really taxing jobs that people are taking on, and
the churn is a worry for people that they see someone there and they're then gone, and the continuity, it's just not providing, should I say, the level of security to people who do want to come forward. When someone's there, a statement's issued, they're then gone.
Yeah, I understand that. Having said that, you know, while there have been a couple of departures from the administrators team, there's a range of people who remain in their jobs. The New South Wales administrators, for example, are exactly the same people who were there when it first started. South Australia is the same. I think Victoria is now had a pretty stable one for quite some time. But, you know, these are taxing jobs, and we can't sort of chain people to doing them forever.
No, I understand that, but the issue that's being raised is the churn, and then do I come forward, do I not come forward? If I do come forward, as I said, do I have the protections if this person was there and then they leave? What then happens to the information that I might?
Well, on that, I mean, I can, and I've raised this with the administrator. I can absolutely guarantee, based on his assurances, that any information the administrator's team receives is being held extremely tightly, and that people can have full confidence that they can put forward complaints on an anonymous basis through that web portal.
So then one of the other issues, just following on from Mr Bryan's sudden decision, is the question's being asked, why was Jared Abbott appointed to replace Mr O'Brien in the executive role, despite being the Assistant Secretary at the Queensland Council of Unions that objected to the CFMEU being put into administration in the first place? So that's now also creating some disquiet as to why a person who objected to the administration has now taken over the role of this of Mr O'Brien. Do you have any knowledge in relation to that?
Well, it's a decision for the administrator who he appoints to those roles, and neither I nor my office, and I expect the department, had any sort of role in choosing or vetting that appointment. One thing I think worth noting, and I'm sure you saw the media reporting of this, Senator Cash, is that last week a group of apparently a couple of hundred...
300 workers.
Yeah, 300 people surrounded the Queensland Council of Unions building, and in some cases charged up fire escapes.
Staff being told to lock their doors and wait for police.
Absolutely unacceptable. And it was said that protest, which got pretty out of hand, was partly in reaction to the rumour of Mr Abbott being appointed. So I'm not sure that anyone... That would indicate to me that Mr Abbott is not seen as a patsy for the former leadership of the union.
It's a very violent sector, unfortunately, obviously. Just also then in terms of, the next one that's been raised with me is Chief of Staff Alison Curry decided not to extend her contract with the administrator. Do you have any knowledge as to why?
Well, again, the administrator made a statement at the time. And again, I think it was quite similar explanation to the other departure, in that I think it was along the lines that Ms Curry had agreed to take on the role for the establishment phase and had decided to, I can't remember whether she's going back to her previous job or what she's doing. And again,
So, and then in New South Wales, wasn't as stable as we could have hoped. Mr Joe Brechik, again a member of the CFMEU administration in New South Wales, my understanding is he only lasted 7 days. There was an article in a newspaper, and I'm happy to table it. It's understood that Mr Brechik came under enormous internal pressure in a state where an organiser's car was firebombed only a fortnight ago. What was the enormous internal pressure that Mr Brechik was under?
I don't know about that. I saw the article, but I'm not aware of those details.
It's been raised again just by people on the ground. Did it have anything to do with the fact that it started to investigate organisers allegedly aligned with the ousted leader Darren Greenfield and road contractors that were pushed onto sites?
I don't know the answer to that.
Senator Cash, we're now at 20.
It's lunch already, sorry.
At lunch.
Are you happy to come back after lunch then?
Yeah, and we'll go to us first and then we'll come back to you.
Yep, that's fine.
Yeah, so we'll now adjourn until 1:40.
Too much space.
Back on air. I just want to just remind everybody, just this is, I usually mention this at the beginning of the day, but I just thought I'd mention it now because it's fit and appropriate, and it's not because it's an afterthought, because I know that all of us should be mindful of this at all times, but there is a parliamentary workplace support service, and there's some fact sheets which we actually have out here as senators to remind us all, but also just remind everybody that if you do have any issues of concern that regard respect and diversity questions or prohibited behaviour, we're all committed to upholding the code. This is not a reflection on anything that's happened at the moment from my point of view, but I'm just saying to everybody we do encourage and remind people of both your rights and our obligations as a team in this room. I say team in the very most broadest collective way.
Very broad.
Oh, you're saying it in the most inclusive of ways.
Inclusive.
That's excellent.
I said collective. No, I said collective. I had to get the word collective in there just in case somebody...
Thank you, Chair.
And inclusive, comrades. And Deputy
Right, come on,
Chair.
seriously.
I might just respond.
Chair, I've been very comfortable thus far with the proceedings.
Chair, if I may, thank you for reminding us this. I think this committee has always functioned well, certainly in this term of Parliament, and the way that you chair is a very fair and even application of the rules, and so I think that reflects in how this committee conducts itself, and I certainly, as Deputy, will continue to support that.
Thanks, Deputy. Thanks to the committee, and thank you, Ms James, and to the rest of the very large team that's here as well. We appreciate that as well. I'll now go to Senator Brown.
Thanks, Chair. I want to go to some questions around the closing the loopholes legislation, bearing in mind the commitment of the Coalition to tear away the rights of 2.7 million workers. And I want to draw your attention to Senator Hume's comment around adding rights, or quoting, I'll quote, adding rights, more rights for workers for something that is just part of a normal working relationship is unreasonable, end quote. Can the department take the committee through on what the closing the loophole legislation was designed to fix?
Which one?
Sure, certainly, Senator. Closing loopholes, which was eventually 2 acts of Parliament, so I'll run through both of them. But certainly, Closing Loopholes Act of 2023 was designed to address loopholes that can undermine principles of fairness, secure jobs and better pay, and it did this by introducing a wage, by criminalising wage theft, introducing it as an offence. What's called closing the labour hire loophole, which is essentially about ensuring that bargain terms and conditions are observed on workplaces, enhancing delegates' rights and introducing a new offence of industrial manslaughter. The second Closing the Loopholes Act of 2024 introduced a framework to set minimum standards for employee-like workers, so commonly called gig workers, to enable the Fair Work Commission to set standards of work for them, likewise for road transport contractors. It also amended the definition of a casual employee and established a new framework for casual conversion to permanent work, gave workers the right to challenge unfair contract terms, made some changes to bargaining and introduced the right to disconnect that we discussed earlier this morning. So they're both quite broad acts.
Before I probably ask for some more detail, I might just go to the Minister. Minister, why did the Albanese Labor government introduce this legislation? What problems did the government inherit from the coalition?
Thanks, Senator Brown. Well, as I mentioned earlier, I guess when we were elected, we promised to get wages moving again. across the economy after 10 years of the coalition deliberately keeping wages low. And one of the ways they had kept wages low and kept too many Australians in insecure employment was by allowing these loopholes to emerge in our workplace laws that some employers were exploiting. The most prominent ones, I guess, are the ones that Mr Manning has taken you through. So we've seen the emergence of the gig economy over the last 10 or 15 years with little to no regulation of that, which was leading to workers in the gig economy being exploited. We saw the emergence of labour hire being used not to supplement a permanent workforce but to undercut wages of the permanent workforce. We saw the definition of casual employment changed by the coalition, which restricted the ability of casual workers to become permanent even when they were working permanent hours. So our view was that we needed to change the law to close those loopholes as one way of trying to get wages moving again and trying to deliver more secure work for Australians, and I think the evidence is pretty clear that that's working.
Thank you, Minister. Is there any, with those two pieces of legislation, at any point did the coalition support any of those initiatives or that you just outlined?
No,
to remove the unfairness or to support secure jobs?
No, the coalition voted against every part of that legislation, just as they've voted against every workplace law change we've made. And to make matters worse, they've already signalled that they will unwind some of those changes, in particular the right to disconnect, the protections for casual workers. They're not backing in the same job, same pay laws protecting labour hire workers. And of course, they've also flagged a number of other, what Angus Taylor called targeted repeals of workplace laws, but they won't tell us what those are. But perhaps Senator Cash would like to share that with us all either today or if she takes up my invitation for a debate at the National Press Club.
Thank you, Minister. I'd probably pay to come and see that.
I can promise you it'll be a good day.
Peter Dutton has committed, as you've indicated, the coalition have committed to removing a number of commitments, in fact tearing away many of the rights that have been put in place by the Albanese Labor government. I just want to go to Peter Dutton's commitment in removing the right to disconnect for working Australians and recent reports that claim that unpaid hours have been reduced by 33% a week. How is the right to disconnect ensuring workers are able to clock off and protect work-life balance? I think it's probably important if you would allow me to just run through and put a face to how these entitlements and rights really affect workers out in the community. So Caroline, a worker in finance, has said, and I quote, "The right to disconnect means that I can spend time with my friends and families. It also means that I can spend time on my hobbies. I even have taken up a couple of new ones because I know I won't be interrupted by my boss in my own time. I'm very concerned about the fact that Peter Dutton has already said that he will get rid of the right to disconnect. This will impact our work-life balance," end quote. So my question is, how is the right to disconnect ensuring workers are able to clock off? And we've heard from Caroline, but also, Minister, are workers like Caroline at risk of Peter Dutton's targeted package of repeals?
Yeah, well, to go to the first question about what difference is the right to disconnect making. The government acted on this primarily because, as we've seen, technology, whether it be mobile phones, emails, all sorts of other messaging services, as they have taken off in the world, we have seen that make a greater intrusion into people's personal time outside of work. And of course, most people get paid to work certain hours. They don't agree to be at the beck and call of their employer after hours when they're not being paid, but increasingly we have seen that occurring. And as I've said in this committee before, everyone understands that there are emergency situations where a worker needs to be contacted after hours, or it might be the level of seniority of someone's role that means there's either an understanding or a formal agreement that they'll be contactable after hours. But, you know, for most working people, being contacted after hours about things that can wait till another time is an intrusion on their personal time, and their family time, their sports, their hobbies, and they're not being paid. So the idea behind it is to give working people a right to not respond to those sorts of contacts outside of working hours unless it's an emergency and the various other factors that we've pointed to in the legislation.
And it was getting increasingly more difficult, particularly with technology, about disconnecting.
Yeah.
Which is why this policy was so important.
Absolutely. Yeah, I mean, it's about enshrining that principle that your work time is work time and your non-work time is non-work time. And I think the vast majority of Australians agree with that. Unfortunately, Peter Dutton has specifically said that if he wins the next election, he will scrap the right to disconnect. So what that means is that it's an open door for employers to contact people after hours when they're not being paid, and we don't think that's fair.
Thank you, Minister. I might just go back to the department. Does the department have any information on how closing the labour hire loopholes have given workers much needed and deserved pay rises?
I might get the witnesses who are dealing with the regulated labour hire agreements to come to the table, Senator. So that's one of the measures that I mentioned in the closing the labour hire loopholes that has had a number of matters at the Fair Work Commission, some of which have been resolved and leading up to reported pay increases of up to $60,000, but the witnesses can run you through them.
How much did you say? I
think it's up to $60,000 is the highest that I've seen reported.
Wow.
And I guess I'll let obviously the departmental officials, another way of thinking about those sorts of dollar figures, Senator Brown, is that that's the amount that people were being underpaid compared to permanent employees of particularly companies in the mining industry, but other industries as well.
So there's a lot at stake, Minister.
Huge.
Senator, yes, some of the data today, the Commission, the Fair Work Commission, that is, as at 31st of December 2024, they've received 120 applications for orders. The Commission so far has made 18 orders, and they can cover employers with multiple employees. We don't always get the data on exact numbers of employees for those orders, but at sort of, I suppose, a best count, we have more than 3,500 workers that have benefited from the provisions to date. And as Mr Manning said, they've received increases anywhere up to $60,000 per year. I can give you a couple of other examples.
Yeah, if you could. Yes, please.
So recently we've had 90 workers in a New South Wales coal mine operated by Boggabury, sorry if I've got that name wrong, but Boggabury Coal Operations, who have secured pay increases of between $15,600 and $35,000 per year for those workers. We've also had...
with those, you said 90?
90 workers.
90. So how much did you just say, how much per week would they be getting extra?
So annual increase of anything between $15,600 and $35,000
per annum.
I don't have the numbers of workers for this one, but there's been it was a meat processing facility in Queensland that received pay increases up to 25% due to the order.
25%.
That's correct,
per
Senator.
Annum extra.
That's correct, Senator.
That's a huge amount.
Yep.
Yes.
It is.
There's also up to 200 labour hire workers.
So just going back to the 20, do you have any idea of what we're talking in dollar figures? 25%. Do you have that information in front of you?
Let me just check, Senator, if we've got the... I'd imagine meat workers are probably potentially on the award rate.
We don't.
Sorry, we don't have the dollar figures for that one. I have a dollar figure here for 200 labour hire workers at Kmart's Lighton Distribution Centre, also in Queensland, that have reportedly received increases up to $11.56 per hour.
56? How much were they getting paid?
And there's probably the most recent order that was made was in relation to BHP, who've actually, rather than have the order actually issued, decided to directly employ more than 20,000 labour hire workers in New South Wales. Actually, it was following an order, apologies, but they've now actually directly employed those labour hire workers.
Sorry, I missed that.
So we have had instances on the back of these changes, so basically resulting in some employers actually directly hiring those labour hire workers that have been subject to an order. And a recent example of that was in relation to BHP.
And you said, did you say there were hundreds of workers?
That was 200 workers.
And where was that?
That was in New South Wales, Senator.
Right, okay.
It's worth mentioning, just picking up on that, Senator Brown, so obviously when I and others have talked about the same job, same pay policy, we've primarily focused on the pay rises that labour hire workers have got as a result of this. But as that example you just heard from Ms Anderson shows, in some cases it's also led to businesses directly employing people rather than employing them through labour hire. And that, of course, provides a whole range of other benefits to those workers as well. Qantas has done that as well, has started in some cases. I can see Senator Sheldon twitching. Qantas has in some cases started directly employing staff who were formerly engaged by labour hire. Yeah. So there's that benefit as well.
That's exactly right, with those extra entitlements. It's just amazing. Miss Anderson, do you have, so you've told me how many so far workers have achieved great results under the labour hire clauses, but are you able to tell me how much? I suppose it might be a bit difficult, but in approximate how much people have received extra in terms of wages?
I think, Senator, I can only probably go on sort of in broad terms. The orders themselves don't always, the public orders don't always provide all the detail. So we get some information through orders that have been made through the Fair Work Commission, but others, the information we get through reporting. In terms of our analysis of the overarching impact, going back to the figure again that Mr Manning quoted earlier, the pay increases per annum have been up to around $60,000 per annum as a result of the orders. And on our calculations, again, just based on what we know of some of the orders and reports following sort of orders being made, there's probably well over 3,500 workers so far that have received pay increases as a result of orders.
Well, Minister, just that one example that's been given of $60,000, that's really life-changing, really. That potentially, that's where you can go to the bank and perhaps get a home loan. You know, these
Absolutely.
are the Albanese Labor government changes have really been life-changing for people. And here we are in a position where if the coalition win government, they want to rip these increases away.
It certainly looks that way, Senator Brown. I think it was Senator Hume who, in a media interview, said that the Coalition will review the same job, same pay laws. So we can only assume that this will be one of the targeted repeals of workplace laws the Coalition have promised. And again, Senator Cash has an opportunity today to tell us all that the Coalition won't rip up those same job, same pay laws and won't return those labour hire workers to being underpaid by up to 60 grand a year. Senator Cash?
Sorry, I thought that's where we asked you questions.
Well, I would have thought there's a lot of people out there now
There's a lot of uncertainty.
who are earning, who are no longer being underpaid as a result of Labor's laws. Your colleagues have said you're reviewing those laws. You could put all of their minds at ease today by assuring them that the Coalition won't touch that law. But you don't seem to want to do that. So I guess they...
Is it our turn to ask questions, Chair?
I guess they can worry about their pay, which is unfortunate.
Senator Cash.
Senator O'Sullivan's got some quick questions here.
Yeah, thanks, Chair. And of course, this is for senators to ask questions of the department and the minister. So I'll continue with our questions. Sally McManus has stated that she's made representations to the federal government about banning employer lockouts. Is that true?
Ms McManus has certainly raised that with me. I think it was particularly in the context of the recent lockout of workers at the Opal factory in Victoria, where the company there locked out its entire workforce of 200 or 300 people because a small number, as in a handful, of workers, I think, stopped work for a short period of time. And Ms McManus's view was that the employer's action was totally disproportionate to what those workers had done. So, yeah, she's made that point to me.
And in what form has she made that point? Was it through meetings, telephone calls?
To my recollection, she raised it verbally. I think it was probably in a phone call.
There's been no written proposal?
Not that I can recall.
When's the Albanese government planning to implement Ms McManus's latest request?
Well, we haven't given any commitment to do that.
Well, you generally do adopt all of her policies?
There's... I think Ms McManus would tell you that there's, being a good unionist, that there's always more on her list that she'd push for than any government or employer agrees to.
So is this just a policy that you're playing down here ahead of the election, but then after the election, like we saw with so many other policies that have been implemented after the election without confronting the Australian people with them?
Well, we will be making very clear before the election what our policy platform is on workplace relations. We're yet to see what the Coalition's platform is, other than knowing that they have a bunch of targeted repeals of workplace laws planned. And again, the National Press Club would be a great place for Senator Cash to be honest with the Australian people.
Has the department met with Ms McManus in relation to this point?
No, Senator.
Any officials met with Ms McManus? Ms McManus has quoted saying that based on the representations that she's had, you're saying it's just with you then, Minister, that they're open to hearing from us on it. What does that mean?
I'm open to hearing from unions or employers about any suggestions they've got about workplace laws.
Should I read from Ms McManus' comments that means that the government is considering making this change?
I've already said to you that we've made no commitment to do that.
Minister, do you concur with Ms McManus' comments that employers who activate the only power available to them during industrial action are being unfair and engaging in a devastating abuse of power?
Well, the particular case that led to Ms McManus raising this with me, it did seem a little over the top to me that an employer locked out without pay hundreds of workers because a handful of workers had stopped work for a short period of time. That seems a bit over the top to me, but I haven't given any commitment to change the law.
But based on that response, it seems you're open to reviewing the laws.
I've already said I'm open to hearing from anyone about their ideas for changes to workplace laws, as long as they don't involve cutting people's wages, that's what your mob want to do.
Has the Minister sought any briefing from the department in relation to this?
Not that I'm aware of, Senator.
No, not aware of. Senator.
So no, there's been no request for drafting of any legislation?
No, Senator.
Has the Minister or his office requested any advice or other material on amending employer powers during industrial disputes?
No, Senator.
Has the department provided advice or any other material on amending employer powers during industrial disputes? Sorry?
You mean in relation to the Opal dispute? Sorry, Senator, I might need to get you to repeat the question, please.
It's a more broad question
Yeah.
than specifically the Opal matter, but has the department provided advice or other material on amending employer powers during industrial disputes?
Senator, not that I can recall for the time I've been in this job, Senator. No.
No, Senator.
Minister, has the Greens asked you to develop a policy on this, like they did with the right to disconnect?
Not that I recall.
Okay, thank you.
Last time I had to deal with the Greens on a IR matter, it was when the Greens refused to support the legislation enabling the administration of the CFMEU. They've been pretty quiet on industrial relations ever since then.
I think it was at the 11th hour in the Senate when we were dealing with the last tranche of industrial relations laws that the right to disconnect appeared. Anyway, pass Senator Cash now. That's okay, Chair.
Senator Cash.
Thank you, Chair. If I could just go to the New South Wales train chaos. Business New South Wales estimates that the train service disruptions since the start of 2025, so this is just 2025, have now led to over $100 million in foregone economic activity in Sydney. This is based on Business New South Wales estimates that about 56% of workers do not have viable remote working options, example hospitality, construction and healthcare, under a non-pandemic environment. More than 10% of the Sydney workforce rely on trains to get to work. These workers will have to travel even if there are train service disruptions, or, unfortunately, they are forced to take leave. Amid train cancellations and lengthy train delays, my understanding is it's around 3,312 services were affected on Friday the 14th of February. These workers' economic output will be reduced. The loss in economic activity during train delays is unlikely to be recovered. Business New South Wales also surveyed around 42 Sydney-based businesses, showing that during the train service disruptions on the 15th and 16th of January, 74% of businesses experienced disruption to their business activity, 43% had to work with reduced staffing, and 36% incurred higher expenses, such as paying for staff travel costs. 31% of businesses had to cancel bookings with customers, while 21% experienced booking cancellations by their customers. And 79% of business reported that their staff members were affected by the train service disruptions, with 48% having staff members arriving late to work, 48% reporting additional stress, and 26% noting that their staff members were losing confidence in public transport. Minister, do you find these figures disturbing?
I think you'll find on numerous occasions through that particular dispute, I was interviewed by the media and expressed my frustration and acknowledged the frustration of the New South Wales public about that dispute, and that's why both privately and publicly I worked to try to resolve it.
So can you take me through your powers to intervene, or the Minister's power to intervene in strike action under Section 431 of the Fair Work Act?
Well, I'm aware, I'm pretty sure it's, could I have a quick look at I'm pretty sure it's Section 431 that does give the Federal Workplace Relations Minister the power to make a declaration terminating protected industrial action on if certain circumstances are met. And as you know, Senator Cash, no minister has ever used that power, including yourself. I know you made a threat to use it once, I think, but you know, you make a lot of threats like our changes bringing back the dark ages and emptying supermarket shelves, so I don't think anyone really takes too much notice of your threats.
So you are confirming, though, that under section 431 of the Act, there is a power for the Minister, the Workplace Relations Minister, to bring the action to an end?
Yes, and I've acknowledged that in the media. And I've also, made the point in the media that you never used that power yourself when you were the minister,
no, because
even though you were calling on me.
All I needed to do was threaten the action, and it actually stopped. It's amazing how the MUA were happy to back
give yourself
down
a rap
when I said
you're the person who threatens that our
intervene.
changes to workplace laws will bring back the dark ages. Do you think
Minister,
anyone takes your
how
threats
often
seriously?
did you speak to the Prime Minister in relation to the Sydney train strikes?
I think probably roughly 3 or 4 times.
3 to 4 times.
But actually, it might have been more than that. I mean, as you know, this is a dispute that had gone on over quite a period of time, and I was in contact with the Prime Minister from memory prior to Christmas, or prior to New Year's Eve, and again more recently.
Yes, well, it would appear that you both decided to say nothing. Did the Prime Minister ever ask
that's
you
not true.
to intervene in the strike?
No, don't misrepresent what I did. I'm sure you were monitoring my media statements.
I was waiting for you to say that you would actually
this.
bring it to the end.
I was
and like so many businesses in New South Wales, very
I'm sure you were monitoring my media statements.
You didn't have
in
the
which
guts to do
I
that.
regularly pointed out that you were calling for me to use a power that you had never once used yourself. And in all of my media statements, I not only acknowledged the pain that this disruption was causing New South Wales residents and businesses, but also I made the point that I was working the phones to members of the New South Wales Government and the trade union movement to try to resolve it. Obviously, the Fair Work Commission has now ordered an end to protected industrial action, and I sincerely hope that the parties reach a settlement of this ASAP.
Something that you could have done beforehand, you chose not to, and as I said, in Western Australia, when there was industrial action that was actually causing economic loss, I had the guts to say that I would intervene, and guess what? The MUA backed off.
Well, if anyone believes that a hollow threat from you can change the world, they're welcome to that view. Some of us actually try to resolve disputes by getting on the phone to the participants, both sides, and resolving them rather than just going to the media and make wild statements.
Did the Prime Minister ask you to intervene in the strike?
Sorry?
Did the Prime Minister ask you to intervene in the strike under section 431 of the Fair Work Act?
No, he did not. And my advice to the Prime Minister was that the Fair Work Commission was hearing the application from the New South Wales Government to suspend protected action, and we should allow the independent umpire to do its job. That's what it's there for.
In terms of the department's role, what advice were you providing or updates were you providing to the Minister, seeing as Sydney commuters and businesses were literally left stranded and there was an option on the table for the Minister to actually intervene?
I'll get Mr Keynes to talk about updates to the office, and then Ms Godden to see if Ms Godden's got anything else to add about the advice, Senator.
Senator David Keynes, Assistant Secretary, Bargaining and Industry Policy. Senator, I have a function that monitors disputes. We regularly speak to the parties to disputes and provide updates as to the ongoing nature of those disputes to the Minister's office.
Are we able to get copies of the updates that you provided?
I think that should be fine. I'd need to take it on notice, Senator.
Thank you very much. So, Minister, I just confirm that the Prime Minister did not ask you to intervene. You yourself determined that you would not intervene. In terms of...
Because the Fair Work Commission was dealing with...
Well, it's always someone else's fault, we know that, or someone else can actually undertake the solution.
It's just laughable.
Again...
You know, I'm sure you understand how much, the reaction to your calls for me to intervene were just roundly met with laughter, given you had never used that power, nor had Christian Porter, nor had any other Liberal Party minister. So it's hardly as if I'm an outlier.
Well, unfortunately, again, as I said, perhaps my threats are just better than yours when it comes to unions backing off.
No one takes your threats seriously. No one.
Threat.
So are we in the dark ages?
Backed
like
off.
you threatened we would be?
I suggest you get out and
Are
talk.
supermarket shelves empty as you threatened they would be?
Small businesses have gone insolvent under your government. That's actually a record I wouldn't personally
Not when you
be
look at the
proud
number of businesses overall.
Did the New South Wales government ever ask you to intervene?
I don't believe so, no.
You don't believe so?
No.
Is that an outright?
Well, in terms of
no?
approaches to me, no.
Okay. What?
Because they acknowledged that there were processes available to them under the Fair Work Act. They took up those options and they got the orders they were seeking.
So in terms of the devastation to the New South Wales economy, in terms of, I demean the inconvenience that people suffered if I merely said inconvenience. At no point in time when businesses were literally brought to their knees, where you saw people literally standing on the side of train stations saying they could not get to work but they needed to, they had no option but to be at work, it never dawned on you that you could have intervened and stopped the strikes, helping the Sydney commuters, but you didn't get involved because you thought at some point the Fair Work Commission would make a decision?
No, I obviously gave thought to my powers and ways that this could be resolved. My judgment was that given the Fair Work Commission was hearing applications and my view and the view of most people involved in this was that it was likely the government was going to obtain the orders that they did, that there was no need for me to use a power that no minister has ever used. I'm sure, I haven't read the decision, but I'm sure the Fair Work Commission took into account the disruption to businesses and Sydney residents in making its decision to suspend protected action.
So where was your sense of urgency, Minister?
Well, my sense of urgency was the many hours that I spent on the phone to New South Wales government ministers and union representatives trying to convince them to resolve the dispute. And I'm aware that, the reports that I hear is that they're not too far apart, and that's a good thing.
And yet you still had the power under Section 431 to bring this action to an end. You did nothing. The Prime Minister didn't ask you to do anything.
I reject the idea that I did nothing.
You caused hundreds of millions of dollars in damage.
Oh, so I caused
because
that,
you thought it was going to go to the Commission.
Not thought,
you could have stopped
not thought, knew.
And unfortunately, clearly you weren't able to convince the union. You failed to do that as well. So I would have thought, yes, the actions that you didn't take have actually resulted in the people of New South Wales. And unfortunately, as I said, the businesses, 79% of businesses reported that their staff members were affected. 31% of businesses had to cancel bookings. 43% had to work with reduced staff. 74% of businesses experienced disruption to their business activity. Are you going to admit that perhaps you should have intervened earlier so these statistics weren't as glaring?
No, I stand by the decision I made, being the same as every other Federal Industrial Relations Minister has ever made, which is to not exercise this power. But unlike you, Senator Cash, I didn't just go to my favoured media outlets and run anti-union positions to them and demand that I use a power that you never used. I actually got on the phone and tried to convince people to sort this out, and they're much closer to doing that as a result.
Well, that hasn't worked well for the people of New South Wales, the businesses of New South Wales, and as I said, when it came to me, all I had to do was make a threat and the unions backed off pretty quickly.
As I say, I don't think anyone outside you thinks that your threats influence anyone to do anything. My experience is that most people see your threats and laugh. But we could debate this at the National Press Club.
That's okay, because what's the term that the media are playing around today? King grub? King grub?
No, that was Jane Hume who used that phrase.
The media are banding it around everywhere.
I haven't
That's
done
about the only media that you've got today is King grub.
Let's go and debate it at the National Press Club.
King grub.
What are you scared of?
King
What
grub.
are you scared of?
King grub. Even your own colleagues, I have to say, said that you were the only one who'd accept the title.
What are you scared about? Why don't you come to the National Press Club and debate?
Chair, I had said that we would wrap up so Senator Allman-Payne could come in and ask questions, I believe, on the next. If you're finished with these, I'm happy to move on to employment. We don't have a lot of time.
I've got some questions here. Sorry, some questions.
Yeah, Palmer. We've got it, Palmer.
Just back to us. I just want to go to, there's been a lot of disturbing pronouncements and encouragement of right-wing think tanks with extreme approaches to industrial relations, and particularly the H.R. Nichols Society, which has a long and very close relationship with the Liberal Party. To the Minister, it was founded, as you know, it was founded by former Liberal Treasurer Peter Costello. Current and former senior Liberals have served on its board, including the current Shadow Home Affairs Minister James Patterson. Shadow Housing Minister Michael Sukkar spoke at their annual conference of the H.R. Nichols Society in November last year, and Angus Taylor did so the year before, and many others have over the years, including Erica Betts and Nick Mitchin. Some would call this, I think appropriately, as the industrial relations wing of the Liberal Party. That's sort of their thought machine, and plenty of substantial and senior Liberals have played positions on both the directorships and in constant consultation with this group as they're working out Liberal Party policy. Are you aware of the Employment Act that was put out by the H.R. Nichols Society, a modern blueprint for the future of work? And I might hand that up. I think it's been distributed. I'm sure my colleagues to the right are fully abreast of the document. It's their running document. But
yeah, I am aware of this proposal from the H.R. Nichols Society, Senator Sheldon. And as you say, the H.R. Nichols Society has had a long, and they would say proud, history of influencing Liberal Party policy on workplace relations.
The same could be said about the CFMEU. How much money did you take from them? That's a question. How much money has the
I'm very happy to go to Senator Cash after any questions that we're doing. But I understand that certainly on the recommendations from the H.R. Nichols Society that there's a number of recommendations in their blueprint. And one of the recommendations in the blueprint is to abolish all awards and replace with a single adult minimum wage. How would that impact working people's pay, Minister?
Yeah, there are some really extreme ideas in this blueprint from the H.R. Nichols Society, such as abolishing awards. That would clearly leave working people massively worse off. Of course, there's a lot more to awards than pay rates. There's a whole range of conditions. As I was saying before, it's a safety net. So this is just a wacky, crazy, extreme right-wing idea from a group that has a long history of influencing Liberal Party policy.
Minister, are you aware that there are other recommendations that are included in the blueprint that you might be able to run us through? Or
I have seen the blueprint, and I know it also calls for abolishing the Fair Work Commission, right of entry for union officials, which of course is a major health and safety risk if union officials have no power to go and inspect a workplace at all. The blueprint calls to weaken laws around wage theft and unfair dismissals. It says that the annual wage review should be done by that bastion of fairness, the Productivity Commission, rather than the Fair Work Commission. It says that the laws regarding right to disconnect should be removed. The Coalition has already picked up that one. Same job, same pay. They're on the way to picking up that one. It says that it should remove truckie protections and gig protections. It is out there. It is out there. It is so extreme, and you might as well talk about a return to feudalism.
And when we look at these mix of policies that have been put forward, I want to only go back to the Liberal Party leadership challenge and a quote in August 22 where Peter Dutton was confirmed his support for cutting penalty rates while trying to put forward other policy differences with then Prime Minister Malcolm Turnbull. So these agendas that the HR Nichols Society have been on there for some considerable time, and there are the rallying cry by certain individuals, including even the opposition leader, on a number of occasions. Is there, with the challenges that are coming up with this, with cost of living challenges that people have, the impact on ordinary Australians would be massive. Is this? What's your view of the pronunciation that Michael Sukkar actually revealed the LNP's Liberal National Party's secret plan to cut wages and conditions of workers yet again?
Yeah, I think it was really revealing that Michael Sukkar, being one of the most senior frontbenchers in the coalition, gave an address to the HR Nichols Society, which all but said this was the blueprint for the coalition's workplace relations policies. I'm just trying to pull up what he said at that speech, but he essentially acknowledged the work of the HR Nichols Society and said that it was a great platform for the coalition to take and would save them a lot of work if they won the next election, because all the thinking had been done by the HR Nichols Society. So finally, we see the secret plan from the coalition for wages and workplace laws. It's called the HR Nichols Society Blueprint, and it involves abolishing awards, the Fair Work Commission, unfair dismissal laws and all sorts of other out there stuff.
And it's consistent with, we saw from the, leaked documents from the Liberal Party in New South Wales, where there was a number of encouragements on policy there on making sure that very similar things in the HR Nichols Society blueprint to be adopted by an incoming, if there was an incoming Conservative government in federally.
No, that's exactly right. I've pulled up the quotes from Mr Sukkar at the HR Nichols Society. He referred to this blueprint and said, having had that detailed work done, having the full suite of changes that will drive efficiency, productivity and competitiveness in our country will hopefully mean that a coalition government after next May will be able to crack on and get moving quickly in repairing the economic disaster we're going to inherit. So there it is. There's the secret plan for the coalition. Back to 10 years of wage suppression like we had last time, back to insecure work. It's no wonder that people feel they'll be worse off under Mr Dutton.
Senator O'Sullivan.
Thank you, Chair. Well, I think what's clear, the only thing that's revealing here is that, Minister, you're disappointed that you're not getting any other media other than that you're just the king grub as it's been running in the media today. I mean, it's clear based on this line of questions that this scare campaign that you're trying to run is just simply to...
Well, it's not a scare campaign because...
if I may finish my question, Chair.
You've already said you're going to...
Chair, you'll have a chance to respond when I finish my question.
Okay, finish your question and then I'll point out what you've already committed to cutting.
So my question is, rather than focusing on this scare campaign, why are you not focused on dealing with the corruption and the real issues that are really going on? This debacle we've got in the construction sector. And my question is, how much money has the CFMEU donated to the Labor Party?
This is such a tired, flogging a dead horse.
How much money?
It's a question for the ALP National Secretariat, the donations that have been taken. You're already aware that under the terms of the administration, the CFMEU administrator has made certain comments about his intentions regarding political activity. You label what we're saying about workplace relations a scare campaign. The HR Nichols Society blueprint says get rid of the right to disconnect. What has Peter Dutton said? He's going to get rid of the right to disconnect. The HR Nichols Society says get rid of same job, same pay. What has Jane Hume said? That you're going to review same job, same pay. You reckon you're going to make it better for workers? Hardly. This is the blueprint. This is what Michael Sukkar has said is the detailed work that's been done that will hopefully mean a coalition government after next May will be able to crack on. This is what you're going to do.
So you continue
to run... And you won't tell us otherwise because your colleague won't debate me.
You are continuing to run this scare campaign. I've asked a simple question.
It's not a scare campaign. You've already committed to do it.
That the CFMEU, knowing what we know about them, donated $700,000 in the last year to the ALP?
I have no idea what they've donated, but what I do know is that it was this government who put in place legislation to enable the administration of the CFMEU Construction Division, and the administrator and his team are making good progress. He has said various things about his intentions regarding political activities. That's exactly the issue that's before the High Court, and I don't intend to comment on that any further.
Okay. I think we're
maybe you could tell. Why don't you just tell Australians what other laws you're going to change for
Minister,
workplace laws?
It's clear.
Angus Taylor has said it's targeted repeals.
So you're just resorting to scare campaigns that are just.
Angus Taylor has said there's going to be more repeals.
You're making this up.
What are they? No, I'm not making it up. Angus Taylor is on the record saying
happy with the king
there will
grub.
be more
You're happy
workplace
with the king grub,
repeals.
Can I?
What are they?
Can I?
We might move on.
Yes, we might just have a. Are we ready to go to? So we'll do it. We'll suspend for a few minutes and allow. Sorry, we'll suspend for 5 minutes so that we can actually have change over to outcome 1, and thank everyone that's been here for outcome 3.
Thank you. So did you say 5 minutes or 5 minutes?
Good. Thank you. Senator Allman-Payne.
Thanks very much, Chair. Good afternoon. Just want to note, Ms James, that I've read through your statement that you provided at the start of today's hearing, so I have got that. And thank you to the department who gave us a briefing yesterday around the targeted compliance framework. I do, however, have a number of questions that arise from the briefing, the statement and other information that we've got. I'd like to refer to start off with to the article by Mr Rick Morton that appeared in the Saturday paper on the 15th of February 2025. That was the article titled 10 Dead After Welfare Glitch Ignored by Government. I believe you're aware of that article?
Senator, I am aware of the article. I don't believe I have a copy of it in front of me, so I might just ask...
Yep, happy to table that.
...to get a copy of it in front of me.
Yep. I note that the things that are written about in that article are incredibly concerning, and this will be a sensitive topic for a number of people potentially who are watching. So I just want to acknowledge that from the beginning. What I want to understand very clearly is how long it took for the department from identifying that there were glitches or bugs, and I understand that there are 3 bugs in particular to which there are back payments, compensation attached. In the briefing I got yesterday, they were referred to as the first bug, the second bug and the third bug. So I want to understand precisely what was the time period from when the first bug was identified to when victims were contacted about that bug.
Thank you, Senator. So I'll ask the team to walk you through that detail. One thing I will say before I hand to them is it does appear that with some of these cases where the system has not been applying or operationalising the policy correctly and as we anticipated, it appears that in some cases we became aware that the system wasn't operating entirely as we expected, but we weren't necessarily aware of the impact. And so before I ask the team to comment on that, because you might be reflecting that that seems odd, how would we not understand the impact if the system isn't doing what we think it should be doing? And so when I met with the independent assurance team that's looking at our system this week, one of the things they reflected on is that the system and its processes is not documented end to end. And so in many cases there are, and I don't want to preempt the formal report, but the language that was used in the briefing with me is dead ends in the system. But it might not be that you can understand the impact of that until an event happens and then the team can kind of reverse engineer it. Now, I'm using not the proper terminology here. I'm not a technical person. But the reason I mention that is because in a big complex IT system, there will often be it will often not work in the way you anticipated, and we might refer to them as bugs as if they're all trivial and insignificant things. Some of those bugs don't have an impact on our participants, and some of them do. And the first one where we identified in recent times and remediated.
Can I just stop you there, though? Yeah. Because I did get a briefing yesterday and I understand all of that, and a lot of that is covered in your statement. What I'm trying to understand is some very clear timeframes. I've been told by the Chair that we don't have a lot of time.
Understood.
And so I'd really like us to try
I'll
and
ask the team to go to the dates.
Thank you.
So, Tanya Ishnew, Deputy Secretary, Employment and Workforce Group. Thank you, Senator. In terms of the date that the first bug was identified, I don't have a specific date, but as referred to in some of the Freedom of Information requests that were released, it was initially identified in 2020, but the impact of that wasn't realised and wasn't understood. And at the time, You will recall mutual obligations were suspended because of the impact of COVID. We were adjusting mutual obligations based on state-based requirements in terms of being able to leave home, etc. The impact of that bug, and then Workforce Australia commenced on the 1st of July 2022. The impact of that bug was first identified in terms of impacting on people who were in the penalty zone of the targeted compliance framework was the 13th of July 2023, and that was identified by the department through its assurance processes. An IT fix was released on the 10th of August of 2023, so within that first month. And when we then went on the 4th of September, Services Australia began back payment of those people who were impacted by that first bug, who were within a 13-week repayment period under social services legislation.
So can I just clarify? So does that mean that you're saying that everyone who was impacted by that first one, the impact was noted on the 13th of July 2023 and then everyone was notified on the 4th of September? Because that's the timeline I'm trying to understand.
Yes, that's my understanding, Senator, and I'll just confirm with the team the exact notification process for those individuals. As we discussed yesterday, that impacted it on 1,165 individuals, but Dr Wright will...
Senator Andrew Wright, Acting Assistant Secretary, Access and Participation Branch. As part of that initial process where Services Australia back paid within those 13 weeks, that group were notified of the back payment and it was arranged. Those were the group who were on Social Security. The issue had happened within the last 13 weeks, so all their details were up to date. The other groups were contacted as part of later processes.
Okay, so can you tell me what dates the other two groups were contacted on?
Yes, Senator. So on the 29th of January 2024, Services Australia commenced remediation for those remaining clients with an impact of a first or second financial penalty. And then those who were impacted by the a third financial penalty, so that's a cancellation of their income support. That process commenced with CDDA payment as part of a process approved on 4 July 2024, which was finalised by the 11th of September 2024.
So can I just clarify? So those three dates, the 13th of July, sorry, the notification dates of 4th of September 2023, 29 January 2024, and then that third tranche, 4th of July 2024, were all people who had been impacted by the first bug in 2020?
There were people in... so there were multiple bugs, but those processes were all involved contacting people affected by that first bug, yes, Senator.
Right, okay. So we've got some people, for example, who the impact of the bug was ascertained on the 13th of July 2023, but there is a cohort of people who were impacted by that bug who weren't notified until the 4th of July 2024. Would that be correct?
It's the process of repayment that we were doing rather than the notification.
So my question was, when was everyone notified?
I will take on notice the exact detail of that, Senator, in terms of notification of that first bug, the second and the third, to be very clear about when people were notified versus when people were repaid.
Yes, I'd like to get a very clear timeline, please, of when that happened. For the 10 participants that DUA have identified as deceased, what was the time distance between identifying the glitch that impacted their payment and first attempting contact with them?
So, Senator, our repayments, and I should say Services Australia recognised that there were 10 people who were deceased when we went to repay them. in terms of their payments, particularly under CDDA. So I should just stress that Services Australia actually were making the repayments for us through the CDDA because they have the system for repayment and the bank account details.
So is it the case that DUA notified Services Australia was making payments and you didn't, it wasn't picked up that those people were deceased until an attempt at a payment was made?
Senator, I think that what we might do is we'll take on notice some of the details here, that there were actually 2 mechanisms used to repay people with respect to each of these bugs. And so the Social Security Administration Act enables, if I make a decision or my delegate makes a decision to reverse a cancellation, and someone correct me if I'm getting the language a little bit wrong here, but up to 13 weeks, that money that is being paid back can be repaid through the Social Security system.
Yeah, I understand that.
But beyond 13 weeks, it cannot. There is no mechanism, and so therefore we had to use a different mechanism, the CDDA mechanism. Working through that took longer, and it also means that batch.
I understand that, but just sorry
wasn't
again,
a batch where the breach
wasn't
had
about
happened
that.
earlier.
My question was the point at which DUA became aware that those recipients were deceased at the time of a payment that couldn't be made?
It would
that
have been when the
question.
payment was made, because we don't have the records with respect to those people.
All
I would
right.
also suggest we clarify on notice the notification question, because I think that Services Australia executed the notifications with respect to the groups repaid through the Social Security system earlier. But the department, I recall we wrote, I recall clearing the letter, I'm not sure if I signed it, but with respect to the CDDA group, there was a letter. So there was different treatment based on the mechanisms available for repayment with respect to notification. But in all cases, the understanding of whether the repayments had been successful or not, and if not, why, that would have been done through Services Australia's system, and then they would have advised us of the circumstances that prevented back payment being achieved.
And the other nuance to that, sorry, Senator, the other challenge is they were also repaying people in batches as soon as they were actually looking at what they were owed, how we would remediate them. So in terms of the final process of repaying all of the people, and Services Australia make multiple attempts to contact people, that whole process was finalised in September of 2024. But as I said, for the detail of notifications and when we became aware, particularly from Services Australia, of the people who had unfortunately passed away, we'll take that on notice and give you the specifics.
Given that the impact of this first bug was picked up on the 13th of July, and you've informed me that people were begun to be notified on the 4th of September. I note that that's a period of around 12 weeks. Given that the people we're talking about, the very reason that they're on income support is because they are living on very, very limited income. I've heard several times in statements and in the things I've read that these are vulnerable cohorts. What steps did DUA take in that 3-month period that people had payments cut off to determine whether people were in incredible financial hardship and at the risk of harm? Because we're talking about people who are at risk of homelessness, not being able to have essential medications, people being at risk of destitution. We've heard that a majority of large numbers of these people are First Nations. In that 12-week period, what steps did DUA take to determine whether people were at risk of harm?
Senator, I think we might need to take on notice the engagement that we had with participants over that period. I don't recall myself what that program was. We spent a lot of time working through. There was actually decision making around remediation. That was not an automatic It's not something that automatically flowed from correcting the IT systems. So there was decision-making around that, and then there was decision-making around how to do the payments, noting the constraints in the social security framework. So I would prefer to take on notice the answer to that question because I don't know the details to hand. I don't have them to hand.
Ms James, I read your statement at the start of this session, and one of the things that stood out to me was there was no apology in there whatsoever. This is not the first time that mistakes by DUA have caused financial and other harms to the most vulnerable people in this country, and nowhere in that statement was there an apology, and nor have I heard an apology from the Minister at any stage for the harm that is being caused to the most vulnerable cohorts.
Senator.
So, Ms James or Minister Watt, at this point in time, would either of you like to offer an apology to those people who are continually being harmed by a system that is clearly, on your own admission, full of bugs?
Senator, I absolutely and unreservedly apologise on behalf of the department that we cannot have full confidence in this system delivering what it's intended to deliver. It's not acceptable, and it is my responsibility and not the Minister's in this respect, although he may wish to add his own commentary, but I will say that I am responsible legislatively and administratively for overseeing this process. As you can see from the dates, there are some issues that go back some way, and I, as I said in my statement, am very concerned and making it a top priority, my top priority, to ensure that we address these issues. I do apologise for the impact that this has had on people. People are entitled to expect better from the government, and that is why I've wanted to come here today. And I'm conscious that this has been going on for a while and we have not explained what has been going on, and that's not my preferred way of doing things. And so I am incredibly sorry for the impact that this has had on individuals, and I apologise for the fact that we hadn't identified these things earlier and acted on them more quickly.
Has DUA taken any steps to identify if any of the people who've died, of those 10, died after their payment was cancelled and from suicide? Has DUA taken any steps to establish what the causes of those deaths were?
So, Senator, as I said, Services Australia recorded when they went to contact people that 10 people in that group had unfortunately passed away. In talking to Services Australia, and obviously it's inappropriate for DUA to go into people's privacy in terms of what else was going on in terms of their payments in their lives. Services Australia have confirmed, and it's probably questions better put to Services Australia tomorrow, but they have confirmed that in each of the 10 cases there were no family or next of kin that had contacted Services Australia to raise particular concerns. So that's as much as I can say.
I don't know how someone would know, a family member would know that when a relative is in strife or that they need to ring Services Australia, but the lack of curiosity astounds me. I would have thought if you have a system that services vulnerable people and you become aware that this is the case, that you wouldn't want to at least understand whether that was a contributing factor, particularly given robo-debt and what we know as a consequence of that.
So, Senator, I wouldn't say it's a lack of curiosity or a lack of sensitivity, but it's inappropriate for us to go into Services Australia data and interrogate it. As I said, Services Australia will be able to answer some of the detail in terms of things that they investigated, but certainly in referring to the fact that family or next of kin hadn't raised concerns previously, there was nothing on the record to suggest to Services Australia that these were people who had taken their own lives, sadly. I can't confirm that for you though, Senator.
Okay. Ms James, when I read your opening statement and what you just said in response to me asking if you wanted to apologise, you talked about the fact that, you know, it's your job to assure that the system is working and that there aren't bugs in it. It's very clear from your statement, and given all the investigations that are currently ongoing, whether that be by the Ombudsman, whether it be by Deloitte, whether it be the one that's happening from the legal perspective, why hasn't the department recommended suspending the targeted compliance framework, given all the questions that surround whether it's actually working as intended?
Senator, I want to be consistent here, so I am just going to go to some of the language I've used in the statement. So we have suspended...
You suspended cancellations.
The cancellations that are occurring as a result of persistent mutual obligation failures. We've done that. I've done that because I've formed a view that the process is not doing that in a way that is lawful. So we've got continuing reviews going on. If I were to form a view that I can't be confident in the system reflecting the policy or reflecting the current law with respect to other parts of the targeted compliance framework, then I think what I would do is refer you to the last substantive paragraph of my statement where I say if I have reasonable concerns that it's not operating in accordance with the law, I'd have a duty to change relevant processes so that I can be satisfied of the lawfulness under it. So in the event that I reach those conclusions as I did with respect to cancellations, then I would take those steps. But absent forming that view, I am actually obliged to continue to administer the system. Now, I am conscious and I am not comfortable, not entirely comfortable with the fact that it can take some time when you are conferring with lawyers or interrogating a system to form a view. So what I've told the committee today is that I've got real concerns and that I'm asking the department to undertake interrogation in a range of different ways. And so I need to have sufficient information to make a decision to stop things based on administrative reasons, as I did with respect to the cancellation. So should I have sufficient information, then that decision is, I could take a similar decision and I probably would, but I do need to have appropriate advice and information before me to support a decision to stop doing something that the Act requires me to administer. I can't not administer the Act. I can't not make decisions that the Act requires me to make unless I have clear reasons. I hope that makes sense to you.
I can come back to it.
Yep.
Just take the call.
Yep, that's
I
fine.
will come back to you. Senator Brockman.
I think we're just going to change topic slightly. Palm scheme. In 2023, the government consulted with industry's bodies regarding changes to the PALM scheme. Is it correct that there was feedback to indicate increasing minimum hours would force farmers out of the scheme?
It was correct that some groups argued that, and it was correct that some groups did not argue that or argued the opposite. So there were a number of, for want of a better term, farmer-based groups and labour hire providers who argued the position that you were putting. I'm
not putting a position.
No,
I'm just asking a question.
that you were putting forward. I'm not saying it's your position. There were a number of unions, faith-based groups and other, again, for want of a better term, support groups for palm workers who put forward a different position.
But there were clearly feedback given to your department through this review that farmers would leave the scheme if you increase the minimum number of hours.
Certainly some groups said that and some said the opposite.
Given you were warned of the consequences, why did you proceed with the changes?
Well, the government had a strong view that we needed to do something about the too frequent instances of exploitation of palm workers, particularly on farms in Australia. And, you know, I'm sure you've seen the articles, Senator Brockman, about pretty horrific things happening to people who've come to Australia to work and to earn money for their families back home. So we took a view that we needed to strengthen the regulation of the palm scheme. That led us, we also had representations from Pacific nations who were concerned about some of the examples of exploitation of their own people. And so we made some changes which were designed to make the palm scheme workable for employers who wanted to use it, but also protect better the workers who participate in the scheme.
Did you model the impact of the change on the scheme?
I'm not sure there was ever any modelling, but...
I'm not aware of any modelling, Senator.
Did you get any other formal advice, information fed into that process that informed those changes?
So I think, as the Minister has outlined, there was a range of fairly extensive consultation around those changes.
Apart from consultation, did you seek any advice? Did you seek any formal information that would have informed those changes?
No. The changes actually looked at legislative provisions, making sure that workers weren't exploited, making sure that reasonable requirements that apply to any Australian workplace apply, but no formal modelling and no other information that I'm aware of.
So did you anticipate the drop since the mandatory 30-hour minimum came in palm workers in agriculture of 20% from 21,915 in July 23 to 16,705 in September 24?
So, Senator, in terms of anticipation, I think one of the things that we obviously closely monitor is the palm data and workers coming in and out of the palm scheme. The recent release from December 2024 will give you the indications both in terms of agriculture but also meat processing, accommodation and other sectors where palm workers are employed. So in terms of anticipating the drop in agriculture workers, I don't think we anticipated or modelled that. What we do know is the number
you had direct feedback from admittedly only part of the industry, but you had direct feedback that this would cause farmers to leave the scheme.
So,
surely
Senator,
you could have anticipated
I think there's a difference between approved employers leaving the scheme and the number of workers in agriculture. So, over the course of the last 1.5 years, since July 2023, we have had a net increase of improved employers joining the scheme. So we now have 493 approved employers in the scheme, and over 350 actively using the scheme. At the same time, workers in the palm scheme have gone from 26,185 in April 2022 to 27,260 overall in the scheme. So that's workers overall increasing. In terms of agriculture, we've been talking closely with peak bodies, farmers and workers. One of the things that's hard to look at is there are a number of factors that are influencing the workforce in the agricultural sector at the moment. We have looked at things like ABARES data, which is seeing a 19% decrease in workers in agriculture overall. We know that increased machine use, increased technology, but also weather events will increase agricultural workers overall. So what we have done is looked at the decrease in palm workers in agriculture, but also against broader agricultural workforce.
Some Pacific workers prefer to work more hours per week and return home sooner with higher earnings. Was this preference factored into the policy design?
So I might go to Mr Stott for the detail on that, but certainly in terms of the minimum hour requirements, the key feedback that we got from workers and from participating countries was workers want a reliable amount of income coming through. So the minimum hours setting has been negotiated and consulted on very carefully to make sure that it works for employers and for workers. So once again, we've done a review, that first review, which actually indicated that the current settings, which were started in July of last year, were in direct response to feedback from industry, from peak bodies and from workers to look at how do you average out 120 hours over 4 weeks and make sure that people are getting a minimum hours kind of.
It's been suggested to me that a longer averaging period would give much more, give the ability of the industry to participate in this scheme much more widely. I think 8 to 12 week period has been suggested. I think industry groups have perhaps suggested that to you. Will the government consider extending the averaging period?
I think it's probably more accurate to say, Senator Brockman, to my knowledge, there's a very small number of industry or employer groups who support averaging over a longer period of time. Most of the representations we've had of late from industry and employer groups have been to support keeping the current 4-week averaging system in place. So I wouldn't want it interpreted that there's a mass call for 8 to 12. There are some.
I've had individual users of the PALM scheme suggest it to me, Minister. So I don't think it's.
Yeah, sure.
I don't think it's just one industry group.
Sure. But I guess what I'm saying is that there are other industry groups who represent farmers and others who use the scheme who have been calling to retain the 4-week averaging rather than moving towards the minimum, the weekly system. But it's not the government's intention to weaken the current 4-week averaging. Again, the balance we've been trying to strike here all along, and you'll remember I had a lot to do with this scheme when I was in the agriculture portfolio before I came to this portfolio, so I absolutely understand how important it is to the agriculture sector. But we were trying to strike the balance between having a workable system for employers and not leaving the door open to having these workers exploited, as was occurring not all the time, but too frequently for our liking.
So you've introduced this temporary fix, which you've just talked about, 120 hours over 4 weeks. This lasts until July 1st, 25. Is that correct?
We've extended that to the 31st of March next year.
It's now been extended to the 31st of March. 31st of March,
and just to take you through, that was only announced, if you like, in the sense of stakeholders being notified last week.
Okay.
That's a result. You may remember we've talked about this here before. When we made the changes to the minimum hours and the other changes to the scheme, to the deed, we did say that we were going to review how they were going, the implementation of that, and that decision to extend the minimum hours to the 31st of March next year is the result of the first stage of that review, which focused on the minimum hours. There's a range of other issues that have been raised about the scheme that are now being considered in the second stage of the review. Our view was that we needed a bit more time to see how these changes are rolling out in terms of the minimum hours. As you know, there are a number of different people with a number of different views about this, and we wanted to see how this plays out before making further changes, as was scheduled for the 1st of July or the 30th of June. And the advice to me from the department was that if we were looking at an extension of the current system, the averaging over 4 weeks, it would not be a great idea to do that in the middle of summer in peak season, and that if we were going to do that, we should extend it to sometime more like around autumn. So that's what we went with.
I'm just wondering why, given this is your policy, why is it a temporary measure? Why haven't you put it into the scheme?
Well, we have put into the scheme, the way the scheme operates now, and the officials can correct me if I express this wrongly.
But why not make it permanent?
Because you know, we do support, we do, it all gets back to that point that I've been making. We want to have a PALM scheme that works for everyone involved, for employers, for the workers, for Pacific nations, and we want to keep an eye on how the minimum hours requirement is working for all of those parties who've got an interest in this. I think at the last estimates when we talked about this, we mentioned that the survey the department had done since the change was made indicated that in 100% of cases surveyed, I think a third of the, was it the employers or the workers? I think it was a third of the employers were surveyed, and in all cases employers were complying with this new requirement around minimum hours being averaged over 4 weeks. That's a good thing. And it was avoiding that system we were having before, where there were too many cases where workers were being brought here without enough work to keep them, you know, earning money. But our view was, let's let the current system go on for a period of time before we consider making any further changes.
But I mean, it also provides certainty to business if you did make this permanent, rather than continually having these extensions of a temporary measure. I mean, that makes it very, very hard for business to plan their workforce needs.
Well, I mean, we felt that extending the current system to the 31st of March next year did give business certainty for the next season. But, you know, it's not only the views of business that our government considers, Senator Brockman. We consider the views of business, we consider the views of unions, faith leaders, Pacific nations. There's a range of different views. And I think if you ask most of the business groups who support users, the employers, they're happy that we've extended this change. Not all groups are happy.
Has the government engaged with Pacific governments to discuss the impact of declining workforce in agriculture?
Yeah, I mean, yes, and we've discussed the PALM scheme generally. Before Christmas, I convened a meeting with the heads of mission, so the ambassadors from Pacific nations or participating nations that I held here in Canberra, to talk about how the scheme was going, their views on it. I've also had at least 2, possibly more, meetings with individual employment ministers from Pacific nations to talk about this. I have to say their feedback is really positive overall about the scheme. I mean, you all know the benefits that this scheme delivers to Pacific workers and their families. They appreciated the changes that we've made to ensure that their residents are protected, and it's an ongoing discussion with them.
I might just hand over to Senator Colbeck on the same topic for a moment, just while I go through what I've got left.
I just want to go to some of the issues that we discussed over the last couple of rounds of estimates in relation to accommodation, and where that sits now. I'm aware that you've been to Tassie and had some conversations down there. Gratitude from the Latrobe Council, who you did meet with. They were pleased that you've had a conversation with them in relation to their particular concerns. I'm just curious to know where that conversation has gone to, what's progressed to, and what changes are being made to manage some of the issues that they're looking to see dealt with particularly, I think, around cooperation between the department and local government.
So, Senator, I'll ask Mr Stott to give you a detailed update. This was specifically the last couple of times we had the conversation around Shearwater and the accommodation that wasn't approved employer accommodation, but
Correct.
Work that we were undertaking with the council and with the local government association. So I'll ask Mr Stott to give you an update.
Good afternoon, Jason Stott, First Assistant Secretary, Pacific Labor Operations in the Department of Employment and Workplace Relations. If we take, if you like, Senator, as read the 5 ones, I'll start with the update, if that's okay.
Sure.
Yeah. So we had an senior official from our department who was in Tasmania visit, including with the Mayor, and subsequently other officials from the department have been in contact with staff at the Latrobe Council in Tasmania. And they've developed a mechanism that we commenced trialling. We commenced earlier this month, whereby we will advise the council of accommodation occupied by palm workers. That includes accommodation organised by the employer and accommodation organised by the individuals, where of course we have those details. And I'll just take as remembered and read that we went over how that can go last estimates, I believe. So that means that the city will then have that information. What they've committed to do is to come back with assurances that the accommodation that we've provided with them, the details we've provided them, are authorised and compliant with the requirements of the. I'm trying not to say city because I believe it's a regional council with a regional council.
I'd be very happy that you've upgraded them to a city.
I think it's regional council, is it, Senator?
Local council. We've got 29 of them, Senator White. But Latrobe will be very happy to be upgraded to a city.
I'm sure, Senator, I'm sure. We're mindful of the imposition on the council, and we're mindful of what it means for 536 other local government areas if that became routine. So we're keen to see how this goes to ensure that the impact ensures safe and secure outcomes for our workers and our employers, but of course the administration is manageable for both those local government areas and the department.
So the trial commenced last month?
This month. It commenced in February. I just don't have the date with me. So.
Okay. To run for?
6 months is what we agreed.
So in respect of the local government motion that was passed on their, that they moved at the ALGA meeting last year, does any of the work that you're doing pick up those key features, or is that part of the check process that they will undertake to ensure compliance with local government requirements for housing?
I don't have that motion with me today, Senator, so I would need to check specifically. In broad terms, as I recall, the motion asked for this type of a mechanism. On specifics, I'll come back on notice.
Okay, well, if you're happy to take that on notice, that's fine. Are there any other specific provisions that have been changed in the way the scheme operates to deal with these things, or are we in a 6-month trial period to see how this goes and works for each of the parties to then determine what might happen from there?
I think, Senator, and once again, kind of drawing that distinction between approved accommodation that's provided by the employers, which are very clearly specified and covered by the deed and guidelines, versus accommodation that workers find in a local town that may or may not meet safety requirements and other living conditions. The deed and guidelines really go to the approved employer provided accommodation. This trial will give us a sense of how can we work with local councils, how do we make sure that we're notifying them and that we've got a two-way communication piece, but we're also not overloading them with that. I think it will give us lessons that then go to other accommodation in other regions and inform kind of how we look at non-approved accommodation, if you like.
Was there any conversation around turnaround times for information for
I wasn't actually at the conversation, but I take it that we would act reasonably and they would too. And it hasn't been brought to my attention that there's the possibility of difficulties with that, Senator. We have the addresses. I expect that the regional council has the capacity to go and make the checks. I think where you were going earlier, just one question ago might have been on, have we changed the deed and guidelines to take into consideration approvals and licensing, all those kinds of things within the regulatory framework, within the deed and guidelines? And I think where Ms Rishnu was going was to say we don't need to make those changes, they're already there. What this mechanism will help us do is get a positive assurance from the local government area that the ordinance or the requirements in the local government area are met.
Okay, so it's a verification process, I suppose, from your perspective, that the requirements for provision of accommodation are being met in accordance with the terms of the
In simple terms, Senator, yes.
Yeah, okay. All right. I suspect we'll talk again. Thank you.
Thanks very much.
And thank you for having the conversation.
I've just got 5 more minutes on Palm, if we could wrap that up before.
You know what, that'd be very helpful, thank you. But I know it's important subject matters you want to talk about, but please go ahead.
Just quickly on the inclusion of childcare educators in Palm, who made the decision to expand it to include childcare educators?
So the growth and expansion of the scheme is a matter that sits inside the Foreign Affairs and Trade portfolio.
Oh, okay, so you have no oversight over that, so I might even be quicker than 5 minutes. So you have no oversight over that?
Well, I mean, this department, I guess, runs, oversized the entire, whatever word you want to say, entire Palm scheme, but as Mr Stott said...
So you don't know who made the decision?
We have, just to clarify, starting with the Minister, sorry, Senator, is we have responsibility for domestic delivery of the scheme. The decision as it relates to the growth and expansion, which would include new sectors like childcare or aged care, is a decision made in the Foreign Affairs portfolio. So questions and discussion about that are best put within that portfolio.
Okay, so I'll put that to one side. I'll get that asked on notice elsewhere. But can you confirm that the Australian Children's Education and Care Quality Authority, the national regulator, has an approvals, an assessment and accrediting process in relation to educators brought in under the Palm scheme?
Senator, again, I'd have to ask that that be put to the education portfolio where that regulation is held.
Okay.
We'll have that opportunity tomorrow, I think. So.
You don't, and I'm happy to ask it there, but
so
how do you know if someone is coming in under the scheme has the proper accreditations?
So the scheme has an interest in ensuring that regulatory requirements are met.
Right.
And when part of the reason, I suppose, for the caution about new sectors entering is to ensure that things such as you're asking about, regulatory obligations, licensing, provisioning, suitability checks are made, is to account for that. In this instance, the department wasn't the decision maker, and so we would need to have those portfolios provide that advice.
I can't read your writing, mate. You ask it. Go on, go ahead.
Just one more question.
I just want to caution everybody that rather than just changing between, if you can just ask the Chair's indulgence. The only reason I'm doing that, not to be precious, is because sometimes in other places it gets out of control and we don't sort of get a clear running of the committee.
Senator Brockman to finish, I have one question and I just asked him to indicate that that was the case when he finished. But he can't read my handwriting.
You need an interpreter.
Sorry.
Well,
you're a left-hander.
Hieroglyphics.
Senator Colbeck, I can understand the problem because I have the same problem with my own handwriting reading myself sometimes.
Would you gain a knowledge of whether someone had the appropriate assessment and accreditation to be in Australia
Senator,
under the Palm scheme?
Perhaps we'll take that on notice. So you've worked your way into an area that I think cuts across 3 different regulatory areas. So there's the visa application to come here, and there would be things that need to be satisfied there. And then for anyone to work in any industry, if you're an electrician who's come from overseas or a nurse, there would be rules, licences, recognition of your skills and qualifications that you'd need. I think that we do some training here, but because then we've got obviously our PALM, the support we give employers and workers, and so I think you've identified a wonderful little area where 3 or so regulatory frameworks collide, and I'd like to take that on notice and get it right.
All right. Look, rather than wasting the committee's time, I'll put some questions on notice. But if they're not directed, if I'm directing them, if you can't answer them, could you please pass them on to the other departments that?
And certainly Home Affairs have obviously already had their session, but I will let Secretary Cook know that you might have some questions about childcare accreditation, and we might just check in the background.
Well, no, it's not really about childcare accreditation, though. It's about how it interacts with the PALM scheme. That's why...
So, Senator, if you put those questions on notice to the department, we will provide a comprehensive response in consultation with other departments.
Okay. Thanks.
Thank you for your indulgence, Chair.
Absolute pleasure, as always. Senator Colbeck, you're going to finish off. Thank you.
How I have to read my own handwriting.
Sorry.
I happen to be wearing the same suit when I'm in there freshening. We had a conversation about a 1300 number for easy contact. Can you give me any information or detail on that? So this is a conversation I had with the Mayor, who expressed a view about wanting that sort of capacity for contact for circumstances where people could communicate where things have gone pear-shaped.
Yeah, well, we would be grateful, Senator, for the help to distribute. It's the 151 51 31 number. It's available for critical incidents 24 hours a day, 7 days a week, as is the email address palm@dua.gov.au if you want to write to us, and you can report an incident, or you could raise an issue, or if you're a worker, ask for access to a grievance procedure. Others can make a complaint. Anyone can come into the scheme via that contact.
So what was the number again, sorry?
It is. In fact, I've got some cards. I can distribute them.
We can read it out to you.
Yeah. So my discovery's also become a community service.
Thank you. That's 1800 51 51 31. And I have a small number. I can make sure everybody has one when we leave.
We can table this now.
I just noticed you were reading from a business card, Senator.
It's mobile notepad.
And Senator, obviously, that particular council has our contact details and is in regular contact given the work that we've done. But as Mr Stott said, we are keen to distribute that number to anyone who's got any concerns about PALM.
Thank you. Thank you, Chair, for your indulgence.
Absolute pleasure. We've got a little bit over time. I think we were laughing too much before. Didn't keep track of the time, so now we'll go on a break.
Still break?
Yep.
Yeah.
Yep. Short break.
Oh.
And we'll now go to 3:42.
Oh.
11 minutes.
Very specific.
recommended options. There's an A and a B option. And I'm wondering, could you please explain in full what option B was?
Senator, we'll just get the relevant FOI document.
Sorry, Senator, that was the brief sent to the Minister's Office on 8 September 2023.
Yep. Yeah, and has two options, A and B, and I'm keen for you to explain to me in full what was option B.
A reference from the FOI. It's just I've got that set of documents here.
I can expand a bit. It seems in that option that Minister Burke's being told not to pause penalties. It says they're likely disproportionate to the current known issues. Then goes on to say they'll dramatically reduce engagement with requirements, have significant implications on providers' payments and viability.
I think I've got it, Senator. Can you just remind me the paragraph number you're looking at?
I've got an extract from it.
Okay. I think I found it.
I think I've got 12 says option A is recommended.
Yeah, and paragraph 13 references option B.
Yep.
Yes.
Yep.
So it's document 5, page 9 of the FOI reference.
Yep. So just keen to understand in its entirety what was option B. I note that it was option A that was recommended, but what was option B?
So, Senator, I don't have the actual option B descriptor as part of this brief.
Release.
And this relief. So, I'm afraid we'll have to take it on it because I don't have the detail of option B in front of me.
If you could provide the detail of option B on notice, I will note that from what we do have, as I said, it seems like in option B, the Minister's being told not to pause the penalties because, and the words that I've extracted from what we do have says, likely disproportionate to the current known issues, will dramatically reduce engagement with requirements and have significant implications on providers' payments and viability. I guess what's striking to me is that seems to go to a lot to impact on providers, but there's no discussion there whatsoever about the impact on the well-being of recipients.
And Senator, I'm afraid I'm going to have to take it on notice and see the detail of option B specifically. It's an extract from the covering brief rather than the actual detail of the options.
All right, if I could get that.
Senator, the only other thing I will say is, so with respect to the IT defects that we identified, where they were IT defects, each and every one of them was corrected in the system.
I understand.
So having rectified those particular defects, then the system was operating as intended as far as we knew. Now, of course, we have these reviews underway. But again, to enable me or a minister, and depending on how it's done, it could be either of our decisions, but to make a decision to not apply current legislation, that's something that does need to be justified. I will say that financial impact on providers has not been something that has factored into my decision making where the question has been about whether a decision is lawful or not. And so this was a briefing in September once we'd fixed the defects that we'd identified, but I think we were noting concerns overall with the system. So it's a point in time, and I'm not sure that, and that's one of the reasons I'm also not sure what the options were being considered at the time. So.
Yeah, I guess I just note that the statement was made, right, in the briefing documents that we've seen, that it would have an impact on providers' payments and viability. So I guess it would be interesting to know what level of damage on what number of participants would DUA say would be proportionate to justify suspending the framework.
Understood, Senator.
Are you able to answer that question? Is there an amount of people? Is there an amount of harm?
So, Senator, the brief references that particular impact. Any decision to not apply legislation as enacted, each one is going to be unique in terms of what might support the decision. So I'm administratively responsible for this system. Yep. I'm not in a position to pause aspects of it simply based on, without having a clear basis for that.
Okay. Is harm to participants ever factored in?
It is relevant, for example, relevant to the decision I did make to stop cancellations under the mutual obligations framework, because firstly, we had advice that questioned the lawfulness of the way decisions are being made, and secondly, it is a decision that has a serious impact on vulnerable people. So they were the matters that I considered when I made that decision. So absolutely, impact on people affected by the decision making is relevant. It's highly relevant.
Mm-hmm. In the standard brief MS 24-00913, it talks about the financial impacts of pausing mutual obligations for an extended period. Can you give me more detail around DUA's deliberations in relation to that? What do you mean when you talk about the financial impacts, and what are they?
I'm just getting a copy of the brief, document 6. So firstly, a reference to pausing cancellation. Sorry, which paragraph are you quoting here, Senator?
Well, it's a more general question, right? The brief says, it talks about the financial impacts of pausing mutual obligations for an extended period. My question is, what are the things that DUA would be considering there? Financial impacts on who, and what are they?
So,
can you give me some more detail around
yes, so firstly, when we talk about, and the reason I'm pressing for specificity. So mutual obligations, I would describe as the obligations set out in section 42 AC of the Act.
Yep.
And the entire mutual obligations framework includes suspensions for a single failure.
Yep.
But also cancellations or deductions for persistent breach of mutual obligations. So if we were talking about suspending the entirety of mutual obligations, we're talking about a situation where there would be no consequences for people not meeting mutual obligations. And that is a different consideration from pausing or stopping cancellations, of which there have been about 550 since Workforce Australia started. So,
but my question goes to
your question.
Financial. It talks about financial impacts. What are the financial impacts the brief is referring to in that context?
Well, I can't quite see exactly where the reference is. I'm sorry, Senator. So,
well, hypothetically, if you were talking about the financial impacts of pausing mutual obligations, whose financial impacts would that be referring to?
Look, does someone have the actual reference in front of them?
No,
I just want to confirm.
I can't see the actual reference in the brief. Sorry, Senator.
Yeah, Senator, look, I mean, the brief, because it's been released under FOI, there are obviously pieces missing, and so I'm loath to make a comment on a statement when I can't see it. But it would be the case, I think, that our people would consider the impact on the system as a whole, and providers administer the system, and it is possible that is what the reference is to.
Okay, so it would be most likely then that we're talking about the impact on providers.
Well, I
can't imagine that suspending mutual obligations has a financial impact on someone receiving income support.
It may also have, and Senator, like I say, not going into the detail, there would be considerations in terms of suspending mutual obligations and looking at what does that do in terms of encouraging kind of broader income support payments. It will consider a whole range of financial implications for individuals and the system overall. And remembering that this system also applies to a number of different programs, including disability employment services.
Okay.
But we also take into account the use of mutual obligations to help people actually engage with the system and find employment.
Mm-hmm. By the way, that's at paragraph 33 on page 19.
33.
It says IT changes will likely require significant government investment, pausing mutual obligations for an extended period and or public statements creating potential exposure or carry significant financial implications.
So without having the whole brief in front of me, it seems to me that this is considering a broader pause on mutual obligations for an extended period. It's being put to a minister as a decision. So the decisions that I would take to stop and pause things would be based on the factors I've outlined before, the lawfulness of the system and my role as the authority administering it. A policy decision to change existing policy is a matter for government, and if we're advising the minister about pausing mutual obligations, then there would be a number of things we'd take into account. We paused mutual obligations during COVID. We paused mutual obligations over the Christmas break. Pausing it indefinitely for a long period, I think it's fair to say that we would have to consider the impact that would have on engagement of people in the system, given the mutual obligations framework is designed to ensure engagement, and that would have a flow-on effect to the sustainability of the system.
I might actually go to the Minister then, because what I'm hearing is that there's a lot of stuff sits in your purview, Minister. So you were given two options in dealing with this particular targeted compliance framework issue. One was to remove the penalty zone from the targeted compliance framework, which would have taken out the financial punishment of people being impacted. But you chose the option that still subjects people to financial penalties but not payment cancellations. Why did you choose that option?
Well, my recollection of the advice to me was that there was a question mark about the legal validity of payment cancellations, and the department made the decision rightly to proceed with payment cancellations.
To proceed with stopping cancellations.
Pausing, stopping cancellations. You'll see that this brief, to me, was for noting rather than decision, because each of the decisions under this framework, each of the decisions that needed to be made were decisions for the departmental secretary, and so I was simply noting the decisions that had been made by the secretary rather than making any decisions. So under the framework that exists, it's not for me or any other minister to be deciding these things, but the department was keeping me aware of the decisions that it had made.
Okay. Going through those FOI documents, it appears that there's certainly an ideological resistance to stopping mutual obligations coming from within the department, and that's quite evident throughout the document in terms of the things that are recommended. Did you seek that advice to keep the targeted, to largely keep the targeted compliance framework operating?
I don't think I sought the advice. I think the brief was provided to me to keep me informed about the department's decision making, but I was comfortable with the decisions that they were making.
Okay. I do note that you have the power to stop mutual obligations and the targeted compliance framework at any point. Like, that is within the power of the Minister.
I'm not sure that is right under the current legislation. The officials might know better than me.
You've got the power to pause it, I would have thought. You've got the power to pause it because we've seen those things happen.
Happy to be corrected if I'm wrong about this, but I think actually that decision rests with the department.
All right. What we know right now is that we've got, if I go to the tender document that went out for the IT review, it says, and I quote, however, it's now experiencing, so it talks about, it says the Department of Social Services and NIIA use DUA's IT for their participants, including mutual obligations application. The IT system has provided a stable foundation to support the operationalisation of the TCF, and then it goes on to say, however, it's now experiencing complications due to significant multiple policy changes over the last 7 years. While this met delivery needs at the time, the ability to flexibly adapt and implement changes to government policy in a timely manner is now challenging. Now, it then goes on to say that to mitigate the risk of incorrect application of penalties and payment cancellations, the department proactively is undertaking daily assurance activities. So we've got a situation where you've got an IT system that's not responding flexibly. The concerns are so high that you've got daily assurance activities having to go on. We've got a situation where we know there's 55 bugs. One of the bugs, we were told they knew about the bug in 2020, but it wasn't until it was rolled out a bit more and we saw more things happening that we actually discovered it was hurting people. We've got an Ombudsman review, a Deloitte assurance review for the IT system. We then find out through the statement made today that there's also a legal review combining AGS advice with internal and external lawyers. Minister, you've been in government for almost 3 years and you've known of these issues for a couple of years. One, why haven't you been more transparent about the harms of the Coalition's policies on mutual obligations and the TCF failures? And two, why are you not taking the advice of advocates to pause a system that clearly everybody has concerns is potentially harming vulnerable people?
Well, there's a lot in that. I respect the fact that there are particular organisations who have been seeking whether you want to say suspension or cancellation of the TCF overall. That's not the government's position. I do believe that we've been transparent in how we've dealt with these matters, and when I say we, I mean the government and the department in terms of its responsibilities. I mean, my focus since this issue was first brought to my attention after becoming the minister, my focus along with the departments has been to fix these problems. And, you know, I think I've said previously, I think it's a good thing that the department, free of any influence of me or any other minister, decided pretty much immediately to suspend cancellations when there was advice that there may be a question about its legal validity. That was the right thing to do, to immediately act and suspend those cancellations. And it's a massive contrast to what we saw from the Coalition through Robodebt, where they were advised that there were legal problems and they ploughed on anyway. And that's very different to how this department under this government has approached these issues by immediately pausing those suspensions. I don't think that necessarily means that we or the department should suspend the entire compliance framework. You know, I respect the fact that you've probably got a different view on that, that some of the groups that have been advocating for us have got a different view on that, but that's not the government's position.
Now the right time to rotate. We just want to do one more question and I'll rotate.
About 3 more questions?
No, one more question and come back to you.
Then come back to you, yeah. My concern, I guess, does it not concern the government? That there are clearly still bugs in the system. Are you confident that there are no people out there right now on income support who are losing their payments through a glitch in the system? Are you confident that no one is in that position?
Well, I'm confident that no one is having their payments cancelled.
That's not my question.
I know, I'm just stepping you through. I'm confident that no one is having their payments cancelled because of the action the department took. I do have concerns about this system and how it's operating, and that's one of the reasons that I requested the department to undertake that external review, which is now underway. This is a system that has flaws. It's a system that we inherited from the coalition. We're determined to overhaul it, just as we're determined to overhaul employment services generally. And that work is now underway.
So you're not confident, but you're comfortable with the most vulnerable people in the country potentially having their payments
I wouldn't.
made?
I'm not saying that what I think I said I was comfortable with was that that the department and the government as a whole is doing everything possible to get this system fixed as quickly as possible, and that stands in stark contrast to what we saw under the coalition.
Since you asked for 2 more questions, and no, we're going to change, and you did 2 more questions, do you want to do the last one? One more question makes 3.
Can you confirm then that you will provide the legal assurance as soon as you get it, immediately? Because one of the things that happened with Robodebt was that it just continued on while reviews were ongoing. So is there a commitment from the government and the department that the minute you get this review, we'll get to see it?
Do you want to answer that?
Yeah, look, Senator, I will advise, I will make statements to the committee and to the public as issues come out of that review. So it's not producing one report. We are seeking advice in an iterative way on a number of provisions.
Isn't the final Deloitte report due in June?
Yes, and I don't think there are any concerns about...
The Deloitte report, which is the IT assurance piece, is due in May of this year.
And so my question to the Minister is, will you guarantee that we'll get to see that straight away, that you're not going to sit on it?
Well, I'd obviously like to see the review before I make that kind of commitment, but what I can say is that I think people can have some confidence that this government will act promptly and be transparent about what we're doing, because that's what we've done to date.
And what about the legal assurance? That's same question, because there's also a legal assurance process going on as well.
Well,
we'll transfer up.
It's not customary for governments to disclose legal advice that's received. But as I say, we are determined to fix this. We've already taken steps to do so, and it's our intention to keep doing that.
Okay. I'll have more, but I'll stop there for now. Thanks.
And I just want to make a comment to say, Ms Jones, we do appreciate the complexity of the questions being asked and the frank responses that are being received as well, and the frank questions. But also it has been a great deal of assistance to the committee by producing that document earlier today, so it's given some time. I'm sure there'll be more questions will come, but some time to the committee members, which is certainly the short time that I've been here, 6 years. It's a very unusual practice, but an appropriate practice to have adopted. Senator Grove.
Thank you, Chair. Now, in my opinion, full-time jobs are important to the health of the economy, business and to individuals. Can you just step us through what the advantages are, what the benefits are of full-time employment for people in our society?
That we can certainly step you through, Senator. I mean, obviously the link to full-time, or not necessarily full-time, but full employment, and stemming from the white paper, the commitments to the government to full employment and making sure that people are participating and working in the areas where they want to be working and where they're productive. There's clear evidence in terms of benefits to the economy, productivity, health, and here's the chief economist who will help go to the particular details. But the evidence is very clear in terms of full employment across the economy.
Thank you very much, Senator. Matt Calgill, Chief Economist. To elaborate on what Ms Rishnu said, I think a broadly shared aspiration for the labour market is that people are able to get the hours of work that they want to meet their household costs and so on, and for many people that will mean full-time work. and I'm able to report that full-time work is currently at a record high and has grown quite strongly over the recent period. I'm sorry, I'll just get the right figure for you.
Go ahead.
Sorry, so full-time employment at the moment is at a record high of 10,092,000 people, and that has grown by 345,000 people over the past 12 months. So that's over the year to January of 2025.
Do you happen to have the figure since the Labor government came in 2022?
I do, Senator. Over the period since May of 2022, there has been an additional 1.15 million total jobs added in the Australian economy, of which 706,700 were full-time jobs.
Okay. And do you know what the rates are? Well, obviously you know, so why don't I just ask you. Can you tell me what the rates are in terms of youth employment?
I can. You're making me flick back and forth here between various briefings. I'm sorry. Please bear with me for a moment. So the current youth unemployment rate is 9.1%. That's in January of this year. Mm-hmm. And that was 0.4 percentage points lower than it had been a year earlier.
Oh, that's good. And is that a trend we're seeing over the last couple of years?
It does tend to be more volatile than overall unemployment, so it has risen and fallen. But overall, in historical terms, that is relatively low for youth unemployment, just as the overall unemployment rate is relatively low in historical terms, Senator.
Okay. And do you have rates for women in there, women's employment?
Yes, I do. So female employment, there are just over 7 million Australian women currently employed, and that figure has risen by 236,100 in the past year, which is a rate of increase of 3.5%. And I can say as well that female employment growth over the past year has been disproportionately in full-time work. So of those 236,000 additional women who are employed now compared to a year before, 166,500 of those are in full-time employment, Senator.
Okay, and you're saying that's unusual?
This has been a period of overall strong labour market conditions. Unemployment has been low and employment growth has been strong, and it has been particularly strong for women. So 3.5% increase in total employment for women in the past year. That is on the high side in terms of historical experience.
That's great. Why is that?
There's been strong growth in a range of industries in which women are disproportionately employed, including industries like healthcare and social assistance and education and training. And so those benefits have...
So the policies that have been brought to bear during the Labor term of the Labor government have impacted. One would surmise that would be a significant element of.
I'm not able to quantify the contribution.
I'm not to put you in an awkward situation here.
Sure. Certainly, it has been a time of strong overall employment growth, and as I say, disproportionate strength among women, reflecting the fact that a large share of employment growth has been in industries like healthcare and social assistance and education and training, in which women are disproportionately represented.
Which is great to see. Minister, I wonder if you have any commentary on these very positive sounding figures in terms of participation in the workforce across a range of cohorts. And how they relate to the policies that the Labor government has brought to bear in its time in government.
I mean, I think Mr Cowgill has taken you through what have been some pretty extraordinary jobs growth figures, given, the economic challenges that both Australia and the world has had over the last couple of years. Sorry, I ducked out of the room for a moment, so I don't know whether Mr Cowgill made the point that it's 1.15 million new jobs created in this parliamentary term, the most in any parliamentary term in Australia's history. Some commentators like to make claims about public sector versus private sector jobs growth. Actually,
does it matter if you're looking for a job?
No, I mean, I think for starters, we're very proud of the fact that we've created many jobs in the care sector in particular. And any of us who've had relatives in aged care would know how much that needed to happen. Disability care, early childhood education and care, they're really essential and good jobs. But equally, there's been massive jobs growth in the private sector as well. I think the figure is 4 out of 5, nearly 4 out of 5 of the jobs created in this parliamentary term were in the private sector.
That's correct.
Yeah, so you wouldn't think that given what some of the commentary you see is. And I think, as I've said publicly, I think one of the other really interesting features of this jobs growth is that it's happened at a time when inflation has been coming down. So obviously the government has had a really big priority in bringing down inflation. It's highly relevant to the cost of living pressures that Australians face.
Well, I was going to go on and ask, Minister, what the impact of these, record figures in terms of employment are likely to have on the cost of living challenges that the world's been facing for the last number of years?
Well, I guess just as a principle, and it's common sense that having a job and a decent job is so essential for people to be able to deal with those cost of living pressures. Having a job that you're getting rising wages for and wages rising above inflation is important to deal with those pressures. And, the evidence is very clear that under our policies, that's what's happening. New jobs being created, public and private sector, wages going up ahead of inflation. So all of the doom merchants who were predicting that our workplace law changes would, I think it was take us back to the dark ages and empty supermarket shelves. One doom merchant in particular, who's not here to respond to this, have been proven wrong. But it's interesting. I think that traditionally, the world of economics, I guess, has told us that rising wages would drive up inflation. Actually, what's happened in Australia is that we've had rising wages while bringing down inflation. Traditionally, we've been told that you need unemployment to rise to a certain level to bring down inflation. Actually, what's happening in Australia is that unemployment has remained low and we're creating more jobs and inflation is coming down. And that's been a really deliberate exercise of a whole bunch of people in our government and the Australian community generally, and that's a good thing for Australians.
Absolutely. And, thanks, Minister, for all of the great work that you do and to the department. Some really, really good signs there. Thank you, Mr Cavill.
Senator O'Sullivan.
Thank you very much, Chair. I want to ask about the Parents Pathway program.
Certainly, Senator, we'll just
get the right people.
we'll ask the folk to come to the table.
Thank you. A survey of employment service providers indicated that providers spent $210,000 on average for establishing a site, and the survey showed establishment costs as low as $25,000 and as high as $300,000, depending on the size and location of the service. What would you say is the? Would you say that that is how much it would cost to establish a Parents Pathway office? That average?
So, Senator, I'm sorry, I don't know the survey that you're referring to in terms of the provider survey. I think the cost of establishing a centre and service will vary depending on where you're trying to establish it, what the cost of, finding accommodation would be and leasing costs. But it also would depend on whether you've got other facilities that you might be able to use and repurpose.
I want to take you to question 3712 from the 21st of November. I've got copies of it if that would help.
We have it.
You've got it right there?
Yep.
Thank you. So this relates to Parents Pathway office in Adelaide. How many staff work in this office?
Senator, I'll ask for Ms Spanos to give you the detail. It's the APS pilot office in Playford, Gawler region of South Australia. So, but Ms Spanos will give you the detail in terms of staffing numbers.
Thanks. Edwina Spanos, First Assistant Secretary, Workforce Australia Provider Support Division. So in answer to your question, Senator, as of 31st of December 2024, we had 1 APS 3 staff member, 3 APS 4 staff members, 4 APS 5 staff members, 3 APS 6 staff members, 1 EL1 and 1 EL2 that were part of the APS pilot staffing profile.
Okay, thank you. So in the budget there that you've provided, it referred to an upfront cost as design. Can you explain to me what design refers to?
Sorry, Senator, what are you referring to? Oh, in the answer to the
sorry, in 3712.
In terms of upfront costs and design, I might see if the Chief Operating Officer can answer these questions, because that was dealt with by our corporate team, who are responsible for leasing, fit out and all of those elements.
Okay. Thank you.
Were you after, sorry, I was listening intently, but the actual specifics,
so in the
amount?
answer that you provided on 3712,
Yes.
it does list the upfront costs of design, trades packages, lease furnish,
that's right.
Project management. I'd be familiar with most of that, just curious as to what design and then also trade packages are. So just those two. If you could give us the definition.
Did you say trade practices?
Yeah, it says trades packages of 1.2 million. 1.29 million, and then there's 169,000 for design. So just particularly those two, keen to understand what they are.
So broadly speaking, trades packages are the tradespersons, people that undertake the work. Yeah. So the construction, thank you, the construction and the fit out was managed by Ventia. So they are our outsourced property services provider. Under the whole of Australian Government Property Services Coordinated Procurement Agreements. So that's part of my understanding is that the trades packages part of that, which was undertaken by Ventia, was literally the electricians, the trades, and the design was obviously the design of the fit out itself. They were completed and then the pilot pathway site obviously opened on the 1st of November.
It seems to me to be quite high. Is it high by what you're used to for this type of office?
It's a slightly unusual office in that I understand that it is part of a shopping centre. So I do know in putting it together that there was quite a bit of work that went into the design around the trades and where it was. But I'm no expert on quantity surveyor and things like that. So
design of 169,550 does seem quite high. The answer in question F, you said that there was 78,829 in loose furniture. Is that correct?
I have that number. Are you at point F, the breakdown? Yep. So I have 78,829. Do you have that number?
Yes.
Yep.
And by loose furniture, I take that to be tables, chairs, that sort of thing.
Yeah.
Is that correct?
Yeah, that's my understanding.
Yeah.
I haven't visited the site. I know that Ms Spanos has. I have seen pictures of the site and there are a variety of loose furniture around the site. I don't know if that might help to kind of describe that. But yeah, as I understand it, that's the loose furniture, table, chairs for the people to visit this particular site.
Right. And there's a quantity there of 65 chairs, 47 tables. That's a lot of tables and chairs. Is that right?
That's the number that has been provided. Yep, that's.
So you're expecting that many people to be coming through that office?
That's
to have
what the
that,
design
to
was.
require that many chairs and tables. So no bookcases, shelves, printers.
Senator, we might need to take. We can give you photos of of all the furniture. We can give you photos of the site. We can give you details in terms of what other equipment is in those offices. Obviously, because you've got parents often with children coming in, we also needed to make it child safe and parent friendly.
The annual rent for this office is $214,733, is that correct?
Just trying to match where you have that figure from.
So I think that's at point D, the estimated annual running cost.
D.
Yep, just confirming that's correct.
That's the number that I have too, Senator.
So am I correct in saying that the upfront costs for opening this office were more than 7.5 years worth of rent?
I haven't
That's what I calculate when I...
So I have the figure of 1.6 million is the upfront running cost, Senator.
Yeah, so 7.5 years. Is that, again, is that value for money? It seems the fit-out cost, quite disproportionate from the annual cost of rent.
One of the important things with any procurement, particularly under the outsourced property service provider and the whole of government arrangement, is obviously value for money. And that is one of the considerations. So that would have been taken into account at the time that was procured.
Right, so 1.6 million, 1.628 million for an office that we've only got 6 years on. Is that value for money?
As I said, Senator, that's one of the considerations when these contracts are entered into through the property team via the outsourced property provider.
Minister, were the high costs associated with opening this office appropriate use of Commonwealth funds?
Well, I do think that this pilot is a worthwhile exercise to trial an alternative method of delivery. The discussions I've had with departmental officials about this indicate that they are learning a lot more about the delivery of parent pathways as a result of being directly involved. I should say I've actually been to that Playford site myself with the local member, Mr Matt Burnell. It was in its very early stages. In fact, it might have been the very first day, I think. Yeah, it was very early stages, but already I met a participant and her family. She had nothing but praise for the service that she was receiving, and it was different to the kind of service she'd received before. The staff there were very enthusiastic, and as I say, the feedback I've received is that it's delivering a good service, at good value for money for taxpayers, and is providing the department with really important evidence as we reform the system overall.
So, considering you have been there?
Yep.
1.6 million for a fit-out for an office that we've got for 6 years, is that value for money?
These things don't come for free. So, you know, I can't remember, Senator O'Sullivan, whether you participated in the Senate inquiries into Parents Next.
I did, yeah.
Yeah, and well, you'll remember, like I did too, and
I'm sure you've seen the headlines.
Thank you, Senator.
You'll remember the stories that we heard from participants in Parents Next that were pretty horrible, the experience that they had, and we were determined to change that. So this pilot is part of broader changes that we're making.
Okay, can I go back to the subject of mutual obligations? Thank you for your time. Minister, I'll just start with you. Is the Albanese government still committed to the principle of mutual obligations?
I've answered that many times before.
Well, in light of what we've heard today, that's why I'm asking.
Yeah, I mean, what we've said is that, unlike the coalition, we don't want the system to be punitive. We think it was unnecessarily punitive. That's what we want to reform.
And so can you just take us through the principle of mutual obligations, what it means to the government?
Well, I think we've been over this many other times in this committee, but if you want to do it again, that's fine. I think it's a well-accepted principle across the vast majority of the community, and it's a principle that our government shares, that just as the community owes obligations to job seekers in the sense of providing income support, training, employment opportunities, job seekers have an obligation to the rest of the community to seek employment and find employment. That's how I see it.
Is there an alternative policy to mutual obligations that the government has and is considering?
No. No, other than we don't want to see the punitive aspects of mutual obligations which not only existed under the coalition but were increased under the coalition. It doesn't help anyone. It actually hurts people. And we think it's possible to come up with a system that respects that, mutuality from the community towards job seekers and job seekers towards the community without going out of your way to harm people in the way that used to happen under the coalition.
But do you believe that mutual obligations is a useful aspect of our system that actually nudges people towards getting a job and getting into training and doing the things that they need to do to get themselves closer to the labour market?
In the way I've described it, yes. In the way the coalition used to run it, no.
So by the sounds of it though, you don't seem to support enforcing mutual obligations. So you just want them...
In what way how have I indicated that?
Well, you're saying it can't be punitive. I mean, the reality is...
You think it should be punitive?
Well, there needs to be a consequence for not.
Punitive is punishing people. That's what punitive means. I'm not really up for punishing people. No, are you?
No, I'm up for ensuring that that job seekers understand that they've got an obligation and they're reminded of that, and that there would be a consequence if you don't fulfil that obligation.
I've been answering questions from Senator Orman-Payne that indicate that the department, I think correctly, decided to pause cancellation of payments, but
it sounds to me, Minister, like...
For example, suspensions of payments in certain conditions remain under this government. So there are consequences for people who don't...
Yes.
Who don't comply with the system. But what I'm saying is that I think we've done some good work to remove the most punitive aspects of the system that didn't help anyone get a job, but just helped the coalition get a headline in attacking people. And I don't think that really helps anyone other than it might make you guys feel good, but
you're saying that there should be consequences.
Yeah, and there are.
Right, and so how can that not be... what sort of consequences should there be then?
The consequences that exist under the system. Now.
Well, you're arguing against it, though, from what I'm hearing.
No, I'm not. I've said I don't think it's necessary to have some of the most punitive aspects of the system that existed under the coalition that punished people, made their lives worse, to no benefit in terms of getting them into work. The employment services system should be about assisting people find work. It should be about assisting employers find workers. And we've had a lot of feedback also from employers that the current employment services system doesn't meet their needs either. That's why we want to reform it, for all of those reasons.
So can I ask the department, in relation to the pause, how long is it going to take for the matters that you discussed this morning and with Senator Orman-Payne to be resolved so that can be relieved?
Senator, so what is currently not happening in the system that would normally happen is cancellations,
the final point,
for persistent breach of mutual obligations. And so that is paused because I'm not confident that that has been happening under our system lawfully. I'm not in a position to say when that might change. For it to be changed, we would need to change the way decisions are made under the system. And so right now there are, as I described in my statement, there are a number of steps that lead up to that decision. But
so it'd be after the review then?
That's right. That's right.
So there wouldn't be any unpausing of that final step? step, as you've put it, until after May. At the
Well,
earliest.
oh yes, sorry. So that review that is focused on the misalignment between the IT system and the policy. The issue that has arisen with respect to Section 42AF2 cancellations is not an IT systems defect. It is advice about the operation of the decision-making not being aligned with the law, the legal requirements. Yep. So changes in the way, and I'm just taking care here because I'm traversing into legal advice and I'm not wishing to go into the details of that. But perhaps if I put it this way, at the moment there is insufficient discretion being exercised at the decision-making point of cancellation. And so our system would need to change how that decision is made, and that would require a mix of system changes and perhaps resource implications. And so obviously the way in which the issue is rectified so that the operation, now I'm having problems with that word, that the system is aligned with the law is going to require me going to government and putting different options about how might be rectified that involve systems and resources. So that could take some time.
Can you just talk to us briefly about the correspondence that you've had with providers in relation to the pause?
Yes, I'm aware that we have adjusted our provider guidelines, but I'm not aware of the details of engagement we've had with providers. So,
So, Senator, and once again, I'll take on notice kind of detailed conversations with providers, but certainly providers know that there's a pause on cancellations for persistent mutual obligations failures, which is that very last point. And it's a point that is usually made by Services Australia, kind of right at the end point. We have updated notifications and materials and guidelines to be clear that cancellation piece is not happening, but also being clear with providers that, you know, they are there to service people and job seekers with participation requirements. And there's a couple of other changes that have been made through the system that are helping with that. So, for example, a 5-day reconnection period, which was one of the recommendations in the Hill report. Participants used to have a 2-day reconnection period. With a 5-day reconnection period, we have seen people connecting back in with providers without incurring a suspension necessarily. And so now something like over 50% reconnect within the 5-day period. So we are starting to see some changes as a result of other budget measures that we've implemented.
Okay, I'm a little pressed for time. I just want to ask you, finally on this point, what feedback have you had from providers in relation to the change in engagement that job seekers have had with them?
So we have a regular update with providers every month. They are overall making sure that they've got continuity of services, they understand how the system is working, and that they have the right engagement and the right levers there for them. So
are you hearing any change in relation to job seekers fulfilling their mutual obligations?
Not fulfilling their mutual obligations, Senator, because, as I said, this is
turning up to meetings, turning up to their appointments, that sort of thing.
This is that last piece in persistent mutual obligations failures. So, in terms of the interaction with providers and people turning up for appointments and engaging, as I said, that 5-day reconnection period has had a big impact in terms of people reconnecting with their providers, whether that be online or Workforce Australia providers. The number of people who, you know, we have over 641,000 people currently being serviced by Workforce Australia.
So can you come back to us on that question? Because as we've been sitting here today, I've had providers contact me saying that they've seen a reduction in up to 90% of engagement with job seekers because of as a result of the pause in the mutual obligation, similar to what we've seen during COVID when there was a pause.
We could certainly engage with providers on that, and we will, Senator. The only thing I'll observe is, for a range of reasons not related to this, the mutual obligation system, the broader system, has been paused for a period over the beginning of the year. I will also note that...
mid-January, right?
Yeah, and so I'll also note that since 1 July 2022, there have been 585 cancellations for persistent failure to meet mutual obligations. So we've had over 1.6 million participants. The number of people who unfortunately get to this point of having their payment cancelled because of a persistent failure to meet mutual obligations is by no means the majority. The majority of people are not finding themselves working their way through to the end of that process. So I would be surprised if just this stop would be having a profound impact on engagement, because suspensions and other things, many things happen before a person gets to the point of a cancellation for a persistent failure.
And Senator, I think if what you're referring to, that what we've described and what the Secretary outlined in her opening statement was stopping the cancellation of payments for persistent mutual obligation failures. I think the conversations that we've certainly had with providers around when mutual obligations had to be paused at the start of January, what impact that had, that's a different... I think the term pause is being used in two places here.
Okay.
The pause on mutual obligations, which were as a result of a range of IT...
Sorry, and just before you go, is that pause still ongoing?
No.
Right.
So, and that was as a result of a number of things that were happening in the system, including in MyGov and Services Australia, that meant that people were getting notifications that shouldn't have been getting notifications about requirements, or they couldn't log on to systems. And so we paused mutual obligations between the 7th of January and recommence them on the 27th of January to make sure that people had time to reconnect. In talking with particularly NESA, so the National Employment Services Association, we're working with them to look at what was the impact overall, but our early indications...
Sorry, I don't mean to cut you off, and please finish what you're going to say if you want to. But I just... Maybe the feedback I'm getting is actually in relation to that period. So I'm keen to understand, get the data on what you're seeing in relation to the engagement, the impact that a pause of mutual obligations has on engagement with job seekers to service providers.
So we're looking at that data, and certainly we have seen our early indication of that data shows that referral of job seekers into services was up by 23% for the same period, and commencements was up by 20%. So we don't see the same kind of impact from our data. As I said, it's early indications, but we are in communication with providers about that. What we're seeing is people are engaging when they can engage.
Yeah. All right, we do know. I'm sorry, we're out of it.
We are. We'll move on.
Thank you.
Thank you. I'm sure we'll revisit this later.
Thank you, Senator Allman-Payne.
Document 6 in the FOI, at paragraph 33, page 19. 33.
Yes.
Talks about public statements creating potential exposure to legal class actions. Does the department believe that speaking to the public about these issues in a timely fashion constitutes a legal risk?
Senator, I'm not sure what public statements were envisaged in the brief. I've obviously just made a public statement, and I don't believe that has created a substantial legal risk. I consider it to be very important that we are transparent and communicating clearly with respect to what's going on, particularly when we've made decisions that impact on people. And I consider that in the past we could have done better on that.
Has DUA received or given any briefings that outline the risk of class action lawsuits from these issues?
I think I'd have to take that on notice. I don't believe so. And to the extent that this has been touched upon, it's probably in lengthy legal advices and to us, not us to others. So I don't believe so.
Could you answer on notice?
I will. I can. Yeah.
If you've not asking for the advice, but I'd like to know if you've received any briefings about the risk of class action lawsuits. If you go to the example CDDA letter, which is FOI document 13, that document shows that you're not communicating information regarding claims for additional compensations to affected participants. Given the levels of poverty of this cohort, it's likely that participants would be eligible for additional compensation. For example, a person who incurred additional costs because they missed a bill, because they had their pay erroneously suspended. I put it to you that surely it's best practice to inform these people who have been the subject of that defective administration of all of the options available to them, rather than just saying, we found an error, we're giving you some money. Is that best practice?
Senator, I'm honestly not sure of that. We discussed ensuring that people had access to, and we provided a link to the Commonwealth Ombudsman's website where people can escalate concerns about our decisions.
Noting that this is a really vulnerable cohort, like the reason many of them are not engaging with mutual obligations is because they have serious things going on. Like you've already said, most people are engaging where they can. Given that legally they are entitled to further compensation if there are flow-on impacts from that, why would you not just set out in that letter to the people who've been subject to this issue, why would you not just set out that they may be, rather than send them off through a complicated process that they may have difficulty engaging with?
Senator, that's a fair point. And I will take that on board for the future processes that we're looking at doing now. I consider that to be a fair point.
And can I just add, Senator, one of the things that we are have been discussing, particularly with civil society groups, is how do we better communicate with affected people? How do we make sure that we make the process as simple for them as possible? In part, and I'd have to go back to kind of the detail of this, but in part this was to try and repay people as quickly as possible and make it as easy on them so that they don't have to show the detriment that they suffered, so that we would repay them and remediate them. Certainly we're looking at how do we give people options in terms of, if you have suffered any other detriment, how do you demonstrate that clearly and simply? And one of the things that we are certainly testing and refining with the Ombudsman is how we communicate that more effectively as well.
I note that you're working on legal assurance letters, or letters as a consequence of that legal assurance issue. I think that's the right word. So basically where we've got these people who've had payments cancelled, I know that those letters, they haven't gone out yet, have they? They're still being worked on?
They're still, and that is part of actually understanding, and we're actively working through what are the mechanisms available to repay people, how do we communicate that effectively, and how do we make it as simple on those people who are affected by cancellations between the 8th of April 2022 and the 4th of July 2024.
All right. Well, I guess I would say that that previous letter would suggest that there is work to be done in giving people clear information about all of the things that they are potentially entitled to. If I go to document 6, at paragraph 16 on page 15, that brief reveals that, and I quote, major reform, end quote, to the targeted compliance framework would require legislative change. Has DUA briefed the Minister or provided recommendations or received briefings or recommendations about this required legislative change?
So, Senator, I don't believe we have made recommendations to the Minister with respect to legislative reform, and you noted a brief in this FOI pack earlier where we traversed the broader potential issues. I will note that the framework for mutual obligations and persistent mutual obligations exists in a number of places, and part of the purpose of my statement was to explain this. So there are legislative provisions. A large proportion of what happens operationally with respect to persistent breaches of mutual obligations is in the ministerial, the non-compliance determination. So it's a disallowable instrument. It is not amending the legislation itself, but depending on what you wanted to do, you may need to do a combination of repealing and replacing that instrument, which is disallowable, and or revising the legislation, the Social Security Administration Act itself. So there are some complexities subject to what the desired outcome would be.
But you haven't briefed the Minister at any stage yet about legislative reform that may be required?
We haven't briefed the Minister on making policy changes to the targeted compliance framework, no. The decisions that I have taken are administrative decisions based on the advice I've received about lawfulness, so they're not about changing the mutual obligations framework at this stage. That we have been working with the Minister and Government more generally on employment services reforms, and of course that's a very broad piece of work, of which the mutual obligations aspect is one part. But you've heard the Minister say the government is looking for a different way of achieving mutual obligations that could potentially involve a quite different legislative framework. So,
and is that being worked on at the moment? I guess I'm just confused because I heard you in evidence earlier say that there were, some things that you couldn't do because you were constrained by legislation.
Yes.
We're also hearing that there's a whole bunch of things that aren't working, and we've got people who are having to be sent letters. That in itself is a cost. It's also harmful to those people. So I would have thought that there would be a big piece of work going on right now around legislative reform to fix this mess.
Senator, our first point, our first body of work is identifying where the way the system's being operationalised is not aligned with the legal frameworks. So we're working our way through that. That will then inform decisions about whether I should be considering stopping any other elements of this framework. The question of what then replaces it comes next. I can't advise the Minister on a complete strategy for mutual obligations without having understood the lawfulness and proper delivery of the current state, if that makes sense.
I want to go back to what you just said then. You said something, I don't want to verbal you, but I thought what I heard was there's currently a question around whether the way the system has been operationalised complies with the legal framework.
That's right.
Is another way of saying that there's a question about whether this is lawful?
Senator,
is that not what you've essentially said?
Well, the statement, I think, makes that clear, that I have concerns about the alignment between the legal framework and the system. And that is in part what has driven the legal review.
Yeah. So we're not sure right now whether this is lawful.
Yeah.
Minister, are you able to state on the record whether or not those cancellations were legal or not?
I don't think I can sort of say categorically, and I can't really add to what Ms James has said about that.
Okay. Why, Minister, then are you continuing to operate the TCF when there's such a high risk of further illegal action against people?
I think I've already given you an explanation earlier about why we haven't paused or suspended the entire TCF. But as I think I've said before, from my point of view at least, the key reason that the Secretary decided to pause the cancellations aspect of the TCF was the legal advice about its validity, and that sort of distinguished the cancellations part of the TCF from the other parts of the TCF.
Is the reason the government won't suspend the system because you're trying to protect the contracts with providers?
No.
Okay. Is the Minister...
Could you just indicate, so we appreciate we spoke before, I'm just trying to get a gauge so we can give some indication to the department coming forward. We are just about an hour over time as well.
I think I've probably got 15 minutes max.
Can you, if you could do it tighter, that would be of great assistance to the committee. Yeah.
Okay. Is the Minister or the department currently aware of any other instances beyond the issues with discretion and the coding bugs that have already been reported where people have been subjected to illegal suspensions or cancellations under the TCF?
Senator, the legal review that is underway is working its way through a number of decision points. So we are actively in the process of seeking advice on a number of matters. I've not formed a conclusion with respect to any of those other decisions in the TCF framework at this stage other than cancellations made under Section 42AF2.
Has the government made any inquiries as to how people may have been negatively impacted by the potentially illegal cancellations? For example, being made homeless or destitute?
I think you're aware I've met with a number of advocacy groups and they've also written to me putting forward information like that.
Okay.
Which I've taken seriously.
Okay. Is the government aware of whether anyone affected by the potentially illegal payment cancellations has died?
No, I mean, I know we talked earlier about the report in the Saturday paper, and I know Ms Rishnu gave you a lot of answers on that point. I can't really add to anything that she said there.
How many people are yet to receive back pay?
So the cohort with respect to the cancellations is about, it's 964 people.
So we are in the process of, as we said, communicating and working out how do we repay and remediate appropriately. So out of that 964, no one has received back pay yet. In terms of the first 3 IT bugs that impacted on 1,326 people, 1,280 people were fully repaid, and they were the people that, after multiple attempts, we could contact through Services Australia.
Minister, is the government concerned, or does it think it's acceptable that second cohort of people, that 900 or so people, haven't received any back pay 8 months since the issue was identified, and while we work out what we're going to put in the letters? And
well, I think there's a bit more to it than that, as the officials have talked to you about. All I can say, as I said before, is that you know, we're taking these issues seriously. We're trying to get them resolved as quickly as possible. We've obviously got to comply with a range of laws in how we do that, but we're determined to do that.
Mm-hmm. Can you give us full details of the compensation for detriment due to deficient administration process that DUA is pursuing to back pay victims of financial penalties?
It's something that we are still settling, Senator. I'm happy to take that on notice.
Mm-hmm. And could you also tell us what are affected participants' rights? So, for example, their right to claim additional compensation under that scheme. I guess my last question is to the Minister, and that's, given that you've said you're taking it seriously, will you ask your department to investigate the legislation then that's required to fix this?
Well, I think Ms James has already indicated that this is exactly something that the department is working on at the moment. Both I and my officer are in regular contact with the department, as we are with advocacy groups about this. So all of these issues are, you know, a very big part of what Ms Rishnu and her part of the department do, very closely supervised by the Secretary.
All right, thank you. I'll leave it there, Chair.
Thank you. Good, thanks. That's we now go to, that's the end of outcome 1, and we now go to the Office of the Fair Work Ombudsman. We'll just give a few minutes to just adjourn, suspend for a few minutes while we change over. Good. Thanks very much. Senator Roberts.
Thank you, Chair.
Oh, sorry. I'm sorry. My apologies. I'm too eager. If I can, we're right to kick off, and would you welcome to the Fair Work Ombudsman, Ms. Anna Booth.
Thank you very much.
Senator Watt, you seem to want to make a short opening
Oh,
statement.
I was curious. Where are you, Senator Roberts? You look like you're in the outback somewhere.
A little place called Stonehenge, about 153 kilometres from Longreach.
There you go. Good on you. Well, good on you for still participating.
Every day, mate.
Would you like to make a short opening statement, Ms. Booth?
Not on this occasion, Senator, thank you.
Good, thank you. Senator Roberts, to you.
Thank you, Chair, and thank you again for attending, everyone. Let me just make sure my camera's right. First of all, I understand that the Fair Work Ombudsman has received a ministerial directive to investigate underpayments of casual black coal miners working under enterprise agreements. Is that correct?
Senator, certainly we have been asked to conduct that investigation, and I think on the last occasion you'll recall Mr Ronson gave you a thorough rundown, and since that time our Enforcement Board has approved an investigation plan, but I would turn to Mr Campbell to give you any further updates that he might be able to do so.
I might bring Steve up. Before he does so, Ms Booth, would it be possible to get a copy of the ministerial directive, please?
I'm not sure that I would describe it as a ministerial directive, although others might be more aware of the protocol in these matters. I believe it was a letter.
Could we have a copy, please?
I see no reason why you shouldn't, but I will hand over to Mr Campbell and Mr Ronson to give you more details.
Senator, it's Michael Campbell here, Group Manager Operations. Is there a particular aspect of our inquiries that you're interested in, or are you looking for a general update?
Yes, I'd like to know specifically, please, an overview of the status of the Fair Work Ombudsman's activities, and could you in particular describe the process that the Fair Work Ombudsman is using to conduct its investigations?
Yeah, fine. I'll ask Mr Ronson to assist.
Yeah, Steve Ronson, Executive Director, Fair Work Ombudsman. Senator, I can give you an update on the status of the investigation, and the Fair Work Ombudsman is currently investigating 18 black coal mining industry matters that involves 25 workers and 17 different employing entities. We've also received 2 self-reports from the sector. All the requests for assistance that we've received are being investigated, and as part of our project plan, we're meeting with a whole range of stakeholders, and we've begun meeting with them to talk about the investigation, to enhance awareness, increase awareness, and to encourage those in the sector to come forward. We have a dedicated email address to receive any allegations or information from any member of the sector or the community. And so far, we've had some very constructive and positive meetings. We've had 2 meetings with the Coal Mining Industry Long Service Leave Funding Corporation. We've met with the Mining Energy Union, and we've also met with the Independent Workers Union of Australia, and we've got a whole range of other stakeholder meetings lined up in the next couple of weeks.
So I assume then, thank you, Mr Ronson, I assume that there's a dedicated process which casual coal miners can now use to lodge complaints of underpayments with the Fair Work Ombudsman?
That's correct. Yeah, there's a dedicated email address we've set up for the whole project so that anyone in the sector or anyone with information relating to the sector can feel confident they can just go straight through to contacting us through that email, or they can give us a call, whichever way they want to contact with us. And of course, there's still the anonymous report function as well, which is available to all members of the community.
Thank you. Now, you mentioned the Independent Workers Union of Australia. I take it that some of the submissions or complaints have been lodged through that, and some of the others are individually lodged?
That's
individual
correct.
work?
Yeah, that's right. Probably 2/3 have come through the agency of the Independent Workers Union Australia, and the other third are just individual workers in the sector who have got requests for assistance that we're looking at.
Thank you. I must say that I appreciate your succinct and direct answers. Can the Fair Work Ombudsman provide a range of the possible underpayment amounts currently being looked at by the Fair Work Ombudsman?
It's hard to assess at the moment, Senator, what the potential underpayments, if any, could exist. Some of the requests, some of the allegations date back at least 10 years, 11 years. There are some individuals who've worked in the sector for many years, and if the allegations are upheld and if the evidence is obtained, there could be significant underpayments owing to certain workers. But at this stage, it's too early. We've requested a series of documents, a lot of information from various companies that will assist us begin, if you like, the assessment of these particular claims.
Thank you. How many employers are subject to investigation so far? Not only the mine owners, but the labour hire firms. How many?
All up, 17, 17.
You mentioned that, okay.
Yeah.
Will the Fair Work Ombudsman advertise to coal miners in the black coal mining sector, encouraging them to lodge and apply to the Fair Work Ombudsman in relation to underpayments they believe they may have been subject to?
In terms of advertising, what do you mean, like increasing awareness as in media statements?
Yes, letting them know you're open for business and you're aware that this is an issue.
Yeah, that's definitely an option available and one we're considering. It's also, there's some other ideas that we have as well about enhancing awareness. For example, there's nothing to prevent us writing to all labour hire providers and employing entities in the sector. This is one of the suggestions that's been put to us and one that we're currently considering.
Would that be a wise move in terms of trying to get to the miners? Because some of these labour hire firms, some, have been deliberately suppressing this.
Well, that's right. Yeah, good point. In terms of employees, in terms of former workers, that's a different sort of audience, if you like, and that's one we're turning our minds to about how do we ensure people who've either in the industry now or formerly in the industry are aware of this investigation. The second point I was making, was relation to employers, and that's something we've done in the past where we've written to, say, for example, the top 100 ASX companies, where we encourage them to review their status, and so if they self-identify, they can self-report any potential non-compliance.
Because my understanding is that some of the miners are not aware of it, but it's a major issue because we estimate around about 5,000 miners at least have been the subject of Australia's largest wage theft case, and it'll cost ultimately around $1.3 billion. They're rough estimates. Yeah. So I think these people need to be told that there's an option for them to seek justice.
Yeah.
And repayment.
Yeah, as I say, it's something we're definitely turning our minds to and considering what's the best way to get the word out, if you like.
Okay, let's hope that you can get that out fairly soon. The Fair Work Ombudsman will be aware that One Nation has pushed for investigation into this issue and that One Nation released a detailed report in February 2024. Is the Fair Work Ombudsman taking submissions on how the alleged underpayments have occurred, and would the Fair Work Ombudsman accept One Nation's report as a submission? We can provide data, companies involved, amounts, enterprise agreements, underpayment.
Yeah, sure. I mean, we welcome all and any information, any submissions.
So we would make submissions in the same way anyone else would?
Yes.
Okay, thank you. Would we be involved, One Nation that is, in any follow-up discussions on the nature of the issue and its resolution?
Yeah, if there's information that's material, actionable, by all means, we'll be in contact.
Because as I understand it, the Mining and Energy Union, which is what's left in the coal mining sector after the CFMEU and the Mining and Energy Union split, they're not seeking back pay. They seem to be hiding it because they were implicated with, they were involved in agreeing to the enterprise agreements, signing off enterprise agreements that were paying much less than the award. Is the Fair Work Ombudsman inviting submissions from other organisations and individuals? And if so, what organisations? What specifically? Who have specifically have been approached?
Well, to date, we've met with, as I said before, we've met with the Coal Mining Industry Long Service Leave Corporation, and we're asking that agency to provide us any relevant information. We've met with the Mining Energy Union. We've offered the same. We've extended the same invitation. We've met with the Independent Workers Union Australia, and as you know, they're actively involved and they're assisting our investigation. We also intend to meet with the Queensland Labour Hire Licensing Compliance Unit, RCSA, which is the Recruitment Consulting and Staffing Association. They're responsible for labour hire. Minerals Council of Australia, we've got meetings lined up with them, and safe work bodies in New South Wales and Queensland.
Will you be covering more than the wage theft case, the specific amounts of the wage theft? In other words, loss of other entitlements and protections and safeguards?
Oh, well, our jurisdiction only extends to, obviously, you know, entitlements or conditions that are actionable or have been created under the Fair Work Act and the regulations. So it's only within our remit.
Thank you. Is the Fair Work Ombudsman consulting with the Fair Work Commission on the issue?
Not to date. There's been no need at this stage, and I think, well, I'm confident we said at our last hearing that we don't have the power or the capability to question any approvals of any agreements that have been made in the past. Others can take that issue up.
So you lack. Who are the others who can do that, Mr. Ronson?
Oh well, parties to an agreement.
Okay. So only the Mining Energy Union, its predecessor, the CFMEU, employers, mining companies?
I'll defer to Chief Counsel as to who in particular can question agreements.
I think you've given, Rachel Volsky, Chief Counsel, Fair Work Ombudsman. I think Mr Ronson's given a reasonable list. I guess I would just say more broadly, one of the issues that I raised at last estimates is just to remember that we still have that statutory time frame that applies under the Fair Work Act of 6 years as well. But obviously that won't preclude us from investigating. But it's also just important to, you know, that the miners that we're looking at also bear that in mind.
Yeah, I'm pleased to say that it wouldn't preclude you investigating. It may preclude, at the moment, addressing the issues that are raised in the investigation, but not preclude the investigation. The premise for my next question, Mr. Ronson, is as follows. The Black Coal Award does not allow for casuals. Enterprise agreements were made, and some are still current, where the agreements pay rates that are demonstrably less than what should be paid under the award if the award allowed for casuals. To an ordinary person, paying casuals less than an award casualised rate, that's a full-time rate plus 25%, is plainly wrong. That's the pub test, as people say. Yet the Fair Work Commission endorsed the enterprise agreements. My question is this. I assume the Fair Work Ombudsman must somehow determine which instrument prevails, being either enterprise agreements that pay less than casualised award rate, or an award rate that incorporates a casualised 25% add-on to a full-time rate. Does the Fair Work Ombudsman have an idea as to how this may be resolved?
Well, that's a $64 question, Senator, if I can confirm it. And I think as previous evidence we've provided, there remains uncertainty regarding the legal consequences of the Black Coal Mining Award's lack of provision for employees in these roles, as it hasn't been authoritatively determined by a court. So it remains an open question.
Will the Fair Work Ombudsman be issuing a report or reports on its findings of the investigation? And if so, what would be the anticipated timeline for such reports? I think the Minister made some comments on the estimated timeline.
Yeah, at this stage, I think in the evidence I gave last time, more than happy to provide status updates in this forum as we go along, but we're hoping that we'd have early preliminary findings toward the middle of this year, or just after the middle of this year. But I think I said last time, and I think it's still the case, it could be at least till mid-26 before we're in a position to provide a final report. But we will keep this committee posted.
So would you be in a position to provide interim reports as the investigation progresses?
Well, I think it's probably easier if we provide status reports like I have today. The thing about an investigation, how long an investigation takes, is it all depends on the...
Yeah. So, yeah, what you find, I get it. Would any reports you provide be public and unredacted, except of course for retaining confidentiality of workers allegedly underpaid?
Well, I see no reason why it wouldn't be. A report that we provide would be as fulsome and comprehensive as we could publish. So
we're not expecting names of individuals to be disclosed.
No.
We expect them to be redacted. Yeah. Would the reports indicate the employers involved, the organisations involved, the employers and organisations under investigation, and any findings that the Fair Work Ombudsman has in relation to the specific employers?
Just before we answer that question, so Senator Roberts, just indication, we're running about an hour and a bit late, but please, I don't want to cut off your questions, but if there are some that can be on notice, that would be helpful, but otherwise I'll come back to you.
I think thank you, Chair. I think the way Mr Ronson is answering the questions directly, it won't be long at all. I've only got a few more going, and I've got to move too.
No worries.
Mr Ronson?
Well, Senator, the best way of answering your question, it's the long-held practice of the Fair Work Ombudsman to provide reports of all its major investigations. We've published all of them and they're available on our website, and it would be our practice and expectation to do so again.
Thank you. If the Fair Work Ombudsman were to conclude that underpayments had occurred, and based on the Fair Work Ombudsman's past experiences, does the Fair Work Ombudsman have ideas of scenarios for compensation of any workers' underpayments?
Well, we have ideas as to whether they're actionable or realisable. That will be determined in due course.
Yes. Something Ms Volsky raised. What is the effect of the statute of limitations, and how would that apply to, say, someone lodging a complaint today?
Well,
they would still lodge it, but...
Yes, as Chief Counsel answered, it doesn't preclude our investigations. The statute, the provision in the Act only relates to enforceability in the event of proceedings. But there's no reason why we can't go back historically and look at historic underpayments and seek to, if the allegations are upheld and there is an entitlement owing, to seek to secure that underpayment.
Thank you. Last question, Chair. Is the Fair Work Ombudsman investigating beyond the statute of limitations to ascertain full amounts possibly underpaid?
Yes.
Thank you very much. I must say, Chair, that I want to express my appreciation for Mr Ronson being direct. It enabled me to get through my questions, and I also want to communicate to the Secretariat that I'll be on the road, so I won't be able to ask the Fair Work Commission questions in the hearings, but I will put them on notice, and the same with the coal long service leave.
Thank you, Senator Roberts, and over now to Senator Cash.
Thank you, and thank you, Ombudsman. I only have a brief number of questions, and it's just really an update from the last estimates hearing. Since taking on the role of the former ABCC, how many new proceedings now has the Ombudsman initiated against the CFMEU?
In total, well, against the CFMEU, it's 2. In total, we have initiated 25 litigations.
So 25 in
25
total?
25 litigations since we took over the role of the ABCC, but 2 of those are in relation to the CFMEU, and 1 is a matter in the Fair Work Commission. Ms Volsky, of course, is, as always, in possession of more detail, so I might pass to her.
And could I just ask, in relation to the other 23, who are they against?
Definitely a question for Ms Volsky.
Oh, Ms Olsen, Ms Volk.
Senator, they're wage underpayment matters, so failure to comply with a compliance notice. I'll just clarify, so we've had 25 litigations commenced, so 23 are underpayment matters and 2 are industrial matters. The first of those was filed on the 22nd of October 2024 in relation to the CFMEU and Mr Stephen Parker. And subsequently, on the 19th of February 2025, we have commenced proceedings against John Setka and the CFMEU as well. And then the other Fair Work Commission matter that Ms Booth referred to was in relation to the suspension of Mr Margini's permit.
Could you just take me through that one, the Fair Work Commission case against Mr Edward Margini?
Yes, so that was, I think, a matter that we've spoken about
At a number of estimates, yes.
Yes, so at the moment, did you just want a status on where that's
just a status update on it.
So at the moment, the Fair Work Commission has reserved its decision, so we're awaiting that decision on suspension, and in the meantime, we're maintaining a watching brief on the criminal trial, and at this stage that is pencilled in for the 28th of February 2025.
Shortly?
Yes.
Okay, no, that's fine. Can I just confirm, so it's been about 2 years since you took the powers over from the ABCC and you've only commenced 2 prosecutions against the CFMEU, is that correct?
That's correct, Senator.
Okay. Just in terms of the wage underpayments, how many of those employers were small businesses for the purposes of the Fair Work Act?
Senator, I think we'll have to take that on notice, and happy to provide that detail to you.
Thank you very much. Just in terms of complaints, how many complaints has the Fair Work Ombudsman received about the CFMEU since the abolition of the ABCC?
Senator, I'd need to take that on notice only because not all of our investigations with respect to conduct of the CFMEU turn on complaints, as in we will act on intelligence or matters in the public interest or public domain. So I can try and find for you on notice how many have come from a direct complainant, if you like.
That would be... and could you also then on notice how many of the complaints have led to investigations?
Yeah, okay. I'll just need to break down the information we've got, because we will test the allegations in pretty much all circumstances where a complaint's made to us. So it'll be how far those allegations were made out by way of our investigations.
Yeah, no, I understand. The data that we're looking for. Just in terms of Mr McBurney, what's the status of the action in relation to the union coercion?
The matter's been filed.
Yep.
Again, Ms.
And
Volsky.
what has been filed? Could you just update me on what's been filed?
Again, I'd ask Ms. Volsky to give you that detail.
Thank you.
Certainly, Senator. So on the 19th of February 2025, we commenced proceedings in the Federal Court of Australia in the Victorian Registry against Mr Setka, former Victorian Secretary of the CFMEU, as well as the CFMEU. Those proceedings relate to a series of public statements made in social media, newspapers, radio and television by Mr Setka on the 31st of May 2024, as well as between 10 and 14 June 2024. In the statements, Mr Setka conveyed that it's alleged that if the AFL did not dismiss Mr McBurney, the CFMEU would disrupt or delay AFL construction projects. So that statement of claim has been filed and served in the court, and a first directions hearing has not yet been listed.
Sorry, what was that?
A first case management hearing. It hasn't been listed.
Oh, hasn't been listed, right.
Yep.
Okay, understood. Okay, understood there. Just in terms of site visits, and I know that we've had this discussion before, how many site visits have been undertaken since you took over the powers from the ABCC?
It's certainly routine to undertake site visits when we're investigating, Senator, but I'll ask Mr Campbell to comment on any specificity he can.
Senator, I believe the number is about 80, but if I can give you a confirmed number, that this financial year we've conducted 54.
And could you, so that's 54, and then in the previous financial year?
I think it's 26, Senator. I just probably need to confirm that, but it's close enough. So it's about 80 in total.
Yeah, 80 in total. So if I just subtract from that's fine. Okay. Can I just confirm though then, so in the 5 years before the commencement of the administrator, the CFMEU and its officers have been found to have breached industrial laws on 1,163 occasions, and they incurred $10,628,861 in penalties in respect of those breaches. And yet you have only commenced 2 actions in the last 2 years. Why is that?
So, Senator, if I can just, obviously investigations always take time in the SETCA matter, for example. So those statements were made between May and June, and we filed at the beginning of February. So probably about 6 to 7 months with the Christmas shutdown in between that. So that was reasonably quick as well. But I mean, there are certain investigation steps that we need to go through with all of our matters to make sure that they're investigated to a litigation standard, and that certainly has occurred. I think even the ABCC last time it was in place didn't commence their first litigation, I think, until some 10 months after they were established.
Again, though, you can understand my concern. 2 in 2 years, and in the 5 years before, 1,163 occasions, they were found to have breached industrial laws and incurred $10,628,861 in penalties. Mr. Campbell, you were the Chief Field Operations at the Fair Work Building and Construction Commission, were you?
I was Deputy Commissioner at the Australian Building Construction Commission, and then subsequently Head of Operations at the Fair Work Building Industry Inspectorate.
Okay, so you were there then when the ABCC was doing the prosecutions against the CFMEU?
Correct.
Are you satisfied then that 2 in 2 years is enough?
Senator...
and congratulations on the previous record. Congratulations on it. The courts were the ones handing out the penalties and finding that based on the evidence, the breaches had occurred.
Senator, I have to leave it to you to make the comment on the sufficiency of the 2 litigations, but I want to leave you with a level of confidence that we have a number of investigations on hand, which I am confident will lead to further enforcement outcomes. These things do take time, and with that time, we intend to make good our commitment to ensuring that the abhorrent conduct that we do identify is brought before the courts, and I think that is made out in the case that we've brought against John Setka and the CFMEU with respect to the conduct towards the AFL and Stephen McBurney.
Can you just remind me, how many inspectors did the ABCC have, and how many inspectors does the Fair Work Ombudsman have?
Senator, I'm not sure that I've got numbers on the ABCC. At different times, its inspectorate would have fluctuated, I suppose. I can give you information about our inspectorate. So we have, I think it's 221 inspectors at the moment.
221 inspectors at the moment.
Let me confirm that if you want to keep asking. 211.
211. And do they have different roles?
No, so all inspectors are appointed equally, I suppose, under the Fair Work Act and have the same powers bestowed on them by, Ms. both delegation but also the Act itself. What we do is develop capability of our inspectors to investigate and enforce all provisions of the Fair Work Act across all sectors.
Sorry, and that I was about to ask you to narrow it down. So 211 inspectors, How many are focused specifically on construction? So the ABCCs were specifically focused on construction. How many of the 211 are specifically focused on construction?
Senator, I'll get that figure for you. That's not a problem. What I'll say while I'm getting that is that there's right now there's 49 people in a branch that has an enforcement branch that have the lion's share of investigations in building construction, but they are not the only ones within the inspectorate that investigate matters in the building construction sector.
Just remind me, how many extra inspectors were appointed after the ABCC was abolished?
Do you mind if I take that on notice, Senator? I don't have some of that historical information.
No, that's fine. That's not a problem at all. Chair, I'm happy to go to someone else just while I go through, because I know we are getting to time and we still have another agency.
I'll go. In that case, I'll go to Senator Pocock.
Thanks, Chair. Thanks for being here. I wanted to ask some questions about the right to disconnect and how that has been picked up by you. Maybe you could begin with any general observations you'd like to make about your dealings or engagement with employers or employees around that right.
As you know, I think, Senator Pocock, we were funded for and did in fact develop considerable educational materials for both workers and their employers. I understand that when it comes to contact by workers and employers in relation to right to disconnect, the numbers are small, but I would have to return to Mr Campbell to comment on that.
Okay.
Senator, Ms Shatter is responsible for a lot of things, but education in particular and our web content and right to disconnect has been a feature of her work of late. So I might let Ms Shaffer talk about the subject first, and then if you've got specific questions.
So that's about the education program. I am interested in Ms Booth's the number of
does in fact cover also our info line.
People around issues or whatever. But if I could have a brief summary of what you've been doing.
Yeah, sure. So Nikki Chaffer, Executive Director of Advice and Education Branch. Look, essentially, as Ms Booth said, we have launched a lot of education and advice initiatives since the provisions came into effect. Our website's the primary channel by which people engage with us, and we've updated that and evolved that content over time. So to help us extend our reach and educate the community, we've also done a number of social media campaigns. We've supplemented that with paid marketing campaigns. We've emailed our subscribers several times to let people know about the provisions. So engagement with the website has, and particularly when those provisions came into effect, we had significantly high numbers. Since that date, so for non-small businesses, 26th of August I'm talking about, we've had fairly limited calls, I would say, through our Fair Work info line. So just to explain the pathway, the website's where people start, and usually most people get their information from the website. They'll often then call our Fair Work info line to either validate information or to ask for specific information relating to their circumstances. So just to provide an example, we've had quite limited calls through to the Fair Work info line about...
What does that mean, quite limited? Can you give me a number?
I can't interrupt. Just because I know people probably got flights they'd like to get to, we're able to dismiss the Coal Mining Industry Long Service Leave Funding Corporation, so you are released, and go quickly. Sorry, Senator Pocock. Back.
Mr Campbell can give you that.
Oh, do they have questions?
Thank you.
Yeah, we've had 225 inquiries in total.
Can I just interrupt again? We don't have safe work. No, sorry, my apologies, if you can continue. My apologies, my last interruption.
6 months, 225 inquiries. What's the step after an inquiry? Is there any further action beyond an inquiry?
It depends on the circumstances of the individual caller. If they want to press a particular issue, we can obviously hear them on that. We've only had one matter that's been raised in terms of a dispute with us.
In 6 months, one matter. Can you characterise the nature of the dispute?
I might just take that on notice, Senator, because I don't have that detail.
but hardly a tidal wave of which some predicted would occur, of confusion, concern and dispute around this right.
Well, we have only a small part of the jurisdiction in some respects. Our enforcement regime's limited to, I think, enforcement of orders. So, in some respect, the work would be generated elsewhere. But we obviously have the primary role in educating the community about it.
Well, as an educator, though, you'd be an early port of call for someone who did have a concern, you would expect.
Correct.
Thank you. And do you have any analysis or evaluation underway in relation to that right? Are you monitoring the character of concerns, or are you just sort of doing any analysis of what is happening?
I suspect it'd be more assessment of our own, our educational offerings and products to make sure that they're working. We wouldn't be making an assessment of the policy itself. But
though, Senator Pocock, of course, as you're aware, we have a tripartite advisory group and reference groups. We have had that item on the agenda for those meetings, and positive, constructive discussion has occurred around our educational materials, and our materials are informed by not just those reference groups, but also user testing that Ms Schaeffer carries out with all of our educational materials.
Right. And I wanted to just ask you about your tripartite advisory group. I'm wondering what outcomes you believe it's delivering for you.
It is early days, Senator, and we actually have some academics scrutinising us, so those outcomes will be well and truly documented in due course. So hitherto, we have had very successful engagement on practical products such as the Voluntary Wage Compliance Code for Small Business, cooperation agreements. Our recent compliance and enforcement policy was the subject of detailed and genuine consultation with the advisory group. We have also begun in different reference groups talking about very practical measures that the FWO takes, and the involvement that the workplace community might have in those measures to detect and disrupt non-compliance, as well as generally the culture of compliance in those sectors. And of course it differs for different sectors, which all of course have different drivers of non-compliance. But I guess the parties themselves are really the best source of judgment as to whether they're useful forums. This survey material that, or the surveys that the academic researchers are currently undertaking indicate that there's a high degree of agreement between the parties about the value of the forums for educational material, and we're working through details with each of the reference groups about areas where there's disagreement, as you would expect in the context of industrial relations in Australia.
And how did you select people to represent those three interests: employer organisations, registered organisations and workers?
So we looked to the institutional stakeholders, as I might describe them. So in terms of the advisory group, we selected the major peak bodies: ACTU, ACCI, AI Group, Business Council of Australia and COSBOA. They, of course, chose their own individual representatives. We're very honoured, really, to have people like Brian Black come to our meetings and Sally McManus, but I won't continue because, of course, one risks missing out on speaking about somebody, but those individuals are chosen by the organisations that we invited to be part of our advisory group. And then when it comes to each of the reference groups, we identified the key union and employer organisation parties to that sector, and they again chose the individuals that attend the meetings.
And are the minutes and items for discussion available publicly for people to look at?
No, the minutes themselves are not. The terms of reference are. Each group gave a lot of thought to that and formed the view that to have the most constructive engagement between the parties, the notes of the meetings would remain within the reference groups of the advisory group.
Understood. My final question goes to your risk management practices. You do a lot of work on a wide range of issues, it seems. I understand there was an external review by KPMG and a staff review as well, possibly. Perhaps you can say a little about that, which surfaced some concerns about risk management practices and pointed to some risk aversion, which might result, and I'm quoting, I think possibly from the KPMG report, delayed or convoluted decision-making, decisions being made at a higher level than they needed to be, overly thorough, strange complaint, I guess, or cautious approach to service delivery or over-servicing, and an internally focused culture. Just how are you responding to that kind of feedback?
Well, at the time that the KPMG report was released, we referred our response to the Minister, and we accepted that critique. Since that time, we have developed our corporate plan, our branch plans, we've restructured the organisation, we are developing leadership development programs for all of our senior executives, and all of those things go to, I guess, taking the decision-making of the organisation to the lowest possible level that is responsible, but doing that within the context of a risk framework, you know, that identifies what the risks are and how we mitigate those risks. Indeed, Mr Campbell's appointment as the Group Manager of Operations and the way in which that whole group has been restructured is an example of that. So I'm fond of using a particular term, which is if you can take the decision to the information rather than the information to the decision, then you will have a well-devolved organisation. So it's just a range of different ways in which you have to tackle that. It's not just one thing, but that is what we're doing.
How long ago was that issue raised? And
it was, I believe the KPMG report came to us in around, am I right, January 2024. So really I'd say throughout 2024 we have been focused on this, and I think, you know, we're not there yet. We will continue to work on this, but it really is about empowering staff. It's about giving discretion in a responsible way for individuals, say inspectors, for example, to make decisions about what matters they investigate, but to do that within the, you know, with appropriate guardrails. And Mr Campbell might like to elaborate on that.
I think you've done an excellent job, Ms Booth. It really is about empowering our staff right across the operational paradigm, really, with the rails and principles by which we want them to make decisions about how they assist the community, and from there choose which matters that we bring forward for more investment, particularly in the compliance and enforcement space. So not starting from the outcome you're trying to achieve, but really making sure that we match our investment to the genuine need of the customer, or in some cases those impacted by conduct.
Great. Thanks for your answers. Thanks, Chair. Done.
Thanks very much. Senator Brown. And if I can just indicate too that I expect that we will be at the Fair Work Commission before 6.
Okay. Thanks, Chair. So I'll be quick. I just wanted to ask a question around the first biennial report of the CFMEU Administrator that was recently tabled. In it, Mark Irving said, and I quote, "Some employers have been complicit, and in some cases drivers of that culture and engaged organised crime figures and outlawed motorcycle gangs in the conduct of their industrial relations. The infiltration of crime figures and gangs in industrial relations in the construction industry creates a whole industry problem." End quote. So it is clear that certain employers in construction industries have a history of using muscle to impose sham contracts, steal workers' wages and undercut health and safety standards. Given your role and powers, can you tell us what the Fair Work Ombudsman is doing to stamp out employer lawlessness in the construction sector?
I am going to go to Mr Campbell, Senator Brown, because he's responsible for the 36 investigations that we currently have on foot in relation to industrial compliance matters in the building and construction industry.
Senator, so I suppose I need to limit my answer to our jurisdiction. So we have, I think, as we've spoken about before, a number of investigations that are considering conduct of both the CFMEU as well as employers. At the moment we have 19 investigations underway which involve conduct, or allegations of conduct with respect to employers in the commercial building construction sector.
Employers, did you say employees?
Employers, sorry.
19 out of 36?
Correct.
And are you, I know you probably can't go into a lot of details, but are you able to tell me what sort of conduct we're talking about?
Well, with respect to employers, a majority of it will be with respect to employee entitlements. And it'll be with employee entitlements.
Yeah. Okay.
But equally, there is conduct where we allege that they've involved or engaged in potentially coercive behaviour with respect to third parties.
Right. So, of those 19, you can't tell me how many would fall under that?
No, Senator.
Okay. Well, I might, unless you've got something else to add, I'll leave it there.
Okay, thank you.
Okay, I have a few questions around wage theft and universities. So in November 2020, the Fair Work Ombudsman sent a letter to all universities urging them to ensure their compliance with workplace laws, particularly about wage underpayments. In a submission to the University Accord panel, you noted that as of 8 May 2023, you were in contact with 27 out of the 42 institutions, had open investigations into several universities, had commenced court proceedings against the University of Melbourne, and had entered into enforceable undertakings with Charles Sturt University and the University of Newcastle. Are you able to give us a high-level overview of where you are up to now with those proceedings and investigations, and provide a more detailed update on notice?
We certainly can,
on notice,
Senator. Yeah. And there are more universities that we're engaging with now, but I will turn to Mr Campbell, who might even turn to another expert to give more detail.
We'll separate it out a little bit, Senator, just because my role will talk about investigations and Ms Volsky can talk to litigations if you like. So we have 28 ongoing investigations into conduct involving universities at the moment. Sorry, that's at the end of December. You're correct, we commenced 2 litigations. We have 5 enforceable undertakings concluded at this stage.
5 concluded?
Yes, that's up to, since I think you said 3 or 2, but we've got 5 now. And that's University of Newcastle,
2.
Charles Sturt University,
2.
University
Yes.
of Technology of Sydney, University of Melbourne and University of Sydney.
Right, okay. And the rest of the information, will you be able to give me that on notice?
We can take that on notice, Senator,
Okay.
yes.
You also note in that submission to the University Accord panel that, and I quote, corporate governance arrangements that do not prioritise or consider workplace relations, risk or compliance, often with little or no line of sight over how work is undertaken at the business level, end quote. When you are working with these universities, what advice do you provide them with how to improve reporting, oversight and risk management?
I'm going to suggest that the answer to that might be found in the enforceable undertakings that have been entered into with the universities. One in particular with the University of Melbourne is we consider one of the most extensive undertakings that we have entered into, and it does thoroughly indicate the range of measures that the university should undertake. Our enforceable undertakings are available on our website. I might also add that we welcome the establishment of the Expert Council on University Governance, and we've offered to brief the Expert Council on our progress in this sector with particular reference to the inadequate corporate governance arrangements.
All right, Ms Booth. Considering I'm nearly running out of time myself, anything that you can put on notice, Mr Campbell, that would be good. My last question is, it's been reported from the NTEU wage theft report of 26 June 2024 that university wage theft is on track to exceed $382 million nationally. Is that consistent with your estimations?
We're certainly aware of the NTEU's work in this area. I don't believe that our numbers are precisely aligned, but I might turn to Mr Campbell to give any updates on our recoveries or...
Yep, Senator, I'll just bear with me 1 second. I'm sorry, I can't speak to the veracity of those numbers, but I obviously we've been...
You don't seek to ask the NTEU?
Well, we have.
We have a higher education reference group at which, of course, we have discussions with them. We don't tend to project likely recoveries, but we have in fact recovered $176 million for over 80,000 employees in the period 1 July 2019 to 31 December 2024. So I think when you appreciate numbers of that magnitude, then you can compare them against the NTEU's figures, and I think on anyone's measure there has been a very large amount of underpayments in the university sector.
So do you have an update? You gave me figures from June 2024.
July 2019 to December 2024. Do we have our figures for January and February 2025? I don't believe we have them with us. We'd need to take that on notice.
So did you have December? I'm sorry.
Oh, yeah, sorry. Ms Booth's evidence, sorry, was to December.
Oh, okay.
Up to.
Oh, sorry. Can you just repeat the figure for me then? Sorry, would you be able to repeat the figure
Yes, certainly.
you gave?
Sorry, I'll speak more clearly. During the period 1 July 2019 to 31 December 2024, we've recovered over $176 million for more than 80,000 employees.
Wow. Good job. Okay.
Thank you.
Yes.
Right.
Okay, I think, Chair, if I would appreciate what information you can actually give me on notice, that would be great. Thanks, Chair.
Good, thanks very much. We're on. Fair Work Commission. So thank you. We now dismissed. We'll just suspend for a few minutes. Mr Phelan, would you like to make a short opening statement?
Good evening, Chair. No, thank you.
Good, thanks. I'll go to Senator Cash.
Thank you very much. Just updating us from last estimates, because if you recall, we couldn't talk about a lot at the last estimates. Can I just get you to sort of now talk through, now that this has been in place for some time, the administration, just the role of the Fair Work Commission in terms of the administration and what specific steps have been taken to monitor the administration?
Good evening, Senator. My role in relation to the administration of the Construction General Division of the CFMU was set out in a statement that I released on the 3rd of October last year. I tabled a copy of it on notice.
So nothing's changed since then?
In terms of the my roles, responsibilities established under the Registered Organisations Act as amended, particularly around Section 323, that obviously enliven the administration of the division.
So just then in terms of monitoring this particular administration,
yes.
Given that this is a legislative administration, can I just ask you what specific steps you've taken to monitor this administration?
There's a number of things, Senator. So under the scheme and under the amended RO Act, my functions, and we will table my statement again, is to appoint Mark Irvin KC as the administrator to set the remuneration, to certify any rule alterations that go to the Construction General Division to make sure that they are consistent with the scheme, to be referred complaints from the administrator, and to investigate and to bring civil penalty proceedings in relation to non-compliance. And also, if I'm satisfied there are reasonable grounds to do so, I can investigate if the scheme is being effectively implemented.
Have you done that yet? Just that last one?
The administrator, the staff of the administration, have established while the administration operates and is independent of government and certainly not subject to government direction or direction from me, we've established governance arrangements for the interactions between the regulator and the division, which for my purposes is conducting the business of a union. Last Friday, I received an updated report from the administrator outlining his operations.
Was that the one that was tabled in Parliament?
No, it's a separate
one. Okay.
And this goes to the open and transparent nature of my role as the regulator,
yes.
But obviously to ensure that I'm satisfied that the scheme is. Are
you able to table that?
I can.
Oh, thank you very much.
If it would assist, I know that we're short of time here, but if you'd like, I can go through some of the major.
I will, and what I'm going to ask you to do, I'm just going to read out some questions, just in case you can actually also address them. Okay. In terms of. So, I was going to ask how many complaints have been referred to you by the administrator since the administration commenced.
We have received, I'll answer that question, we've received two complaints.
2 complaints?
And one of them we have initiated an investigation into. Some information about that complaint is on our website, and Mr Enright could provide further information on if you wish.
Thank you. And then what is the current status of the 2 investigations? Oh, sorry, one is an investigation. Yes. What's the other one?
Mr Enright, would you like to?
Thank you.
Executive Director of the Fair Work Commission. Thank you, Senator. The other matter was a matter that fell outside our jurisdiction. It related to a particular issue that didn't fall within the regulatory sphere of the General Manager.
So what then happens with that?
We advised the administrator about that, and at the same time, Senator, that precise same issue was reported to law enforcement agencies. And so it fell out of our jurisdiction.
So it refers off to the law enforcement agencies.
Yes, Senator.
And just in relation to the investigation, I know you said it was on the website, but just very briefly, what's that in relation to?
This is an allegation of potential anti-avoidance matter related to Mr Greenfield.
And that was one we discussed last time, if I recall. And so you have now commenced the investigation into that, but yes. Not proceedings.
No, Senator. We've conducted and are conducting that particular investigation, and we're pursuing obvious matters such as trying to obtain CCTV footage that's involved in the allegation, but it's very much an ongoing investigation.
Okay. Thank you, Mr. I will ask you now, is there anything else you can now take us through, just as the highlights in terms of the statement?
So the report that we hopefully you've just tabled, it's 6 pages long and outlines 100 discrete matters, activities that the administrator has conducted since the commencement of the administration. Amongst other things, the report indicates that the administration has facilitated the application of enterprise agreements to the Commission. So since the date of appointment, the Commission has approved 444 CFMU construction general agreements, with approximately 45 having been lodged within the last fortnight. And due to improved compliance with the statutory requirements with those agreements, they are now being approved within a median of 8 to 10 days from the date of application to the date of the agreement being approved, which, as far as I'm aware, Senator, is as far, these other things the administrator has identified in his report to me. He's formally commenced investigations into alleged conduct into New South Wales, Queensland and South Australia. He's referred allegations in intelligence to APRA, AFP and my office, which we've just traversed. He has issued notices to assist the administrator, terminated or dismissed 3 individuals, received final reports in relation to the conduct in New South Wales and South Australia, which I think were tabled in his report or were attached to his report that was tabled yesterday. He's commenced an inquiry into violence, threats of violence and menacing conduct within the Queensland Construction Division. He's visited each of the divisional branch offices across Australia. He's made several appointments, including to CBUS, IncoLink and the Victorian Building Industry Consultative Council, regularised arrangements with the Commission as to the day-to-day operations and contacts in relation to the governance of the relationship between my office as his regulator and the divisional branches. He's recovered more than $3.5 million in members' funds from third parties. He's highlighted the urgent need for enhanced worker safety, and he's developed and released an interim menacing conduct policy, including issuing...
An interim medicine?
Developed and released an interim menacing conduct policy, including issuing directions through the executive officers to all organisers prohibiting menacing conduct. And as I understand, as the report attests, he's also participated, or his office participated in several meetings of the National Construction Industry Forum.
Excellent. And that was the one. That was what you just tabled, is
it? Yes.
Thank you very much. Can I just ask you about how incidents are handled between the Fair Work Commission and the administrator, given, as you said, it is independent, so I completely understand that. One of the issues that we had spoken about previously in outcome 3, it was an incident in February where a CFMU organisers' union car was firebombed in the middle of the night, just 3 months after his house was vandalised with the word CFMU dog. I tabled the article earlier, but I can provide you with a copy if you need one.
I'm aware of that.
You are, right. And so I just wanted to ask you then, what happens when you now see something like this? Do you have a process whereby you touch base with the administrator to ensure that he's also aware of it?
Those communications would occur at the officer level in the general course of things.
So at the
officer level, it wouldn't be myself.
But meaning
it's staff of the Commission from the branch that's responsible for supporting registered organisations. Will converse with their equivalents in the Office of the Administrator and discuss these sort of activities or alleged activities.
So
Can I assist you, Senator, not only at that level but also in the Joint Agency Working Group, which amongst the AFP and law enforcement agencies and a range of Commonwealth agencies, those are the type of issues that get discussed. Our third meeting of that group was a couple of hours ago, and that and many other matters were discussed. So it's a coordination to make sure, Senator, that the relevant Commonwealth and state agencies and any regulatory agencies are properly focusing on matters within their jurisdiction, and certainly that was part of the discussion.
Do you know if the individual concerned whose car was firebombed has been given any extra security by the CFMEU?
Not that I'm aware of, and in the normal course of things, I wouldn't anticipate that that's something that I would be personally advised of.
Okay, no, I just thought you just in terms of you may have known that given the sort of the relationship. One of the other things that we'd spoken about in outcome 3, but I've had to pursue it here with you, is the CFMU administrator recently announced that he would launch the investigation into the culture of violence in the Queensland construction industry. Just in terms of your knowledge of what this investigation is going to look like, what type of investigative methods are going to be used, etc. Who's actually going to be running the inquiry? Is he running it himself? Does the Fair Work Commission provide any assistance?
We receive referrals from the administrator.
Yes.
My understanding is that, in relation to that, is that it's an on-motion investigation that has been commenced by the administrator.
Yes.
And he will use the powers that have been afforded to him under the amended Registered Organisations Act and under the scheme to conduct that investigation. What may occur at the end of that investigation, and he, as we've seen previously, he may appoint an external complaint or investigation handler.
Yep.
What may ultimately give cause to a referral to the Fair Work Commission, and
Yes.
then we may then accept that referral.
Yep.
And investigate it. And if we see, on the basis of independent legal advice and meeting my obligations under the Legal Services Direction, I might then initiate proceedings.
Okay. Just in terms of the Fair Work Commission itself, so now separate to the administration, this is the Fair Work Commission. Your website has a link to report matters relating to concerns of the CFMEU. How many complaints have you received, and where do the complaints go?
Okay, so this is accurate to the 6th of Feb.
Yes.
Yep. And I'm not too sure the date that we established the, but in terms of, well, I will get that information for you. 307 matters have been referred to the Fair Work Ombudsman.
Hold on, just so I get an understanding of what that means. So, the complaints that you've received, is that a different figure to 307?
Yes. In terms of there's a whistleblower function.
Yes.
People can either fill in an online form, or they can contact the number that we established for receiving this information as well. In terms of the absolute number of calls that we received or contacts we received, how many do we have, Mr. Emmerich?
So just to assist Mr Furlong, the dedicated web form was established on the 29th of July 2024.
Yes.
And I'm not sure if Mr Furlong advised you about this, but we've received 865 responses to that web form, and of those, as Mr Furlong has said, 370 matters were referred to the Fair Work Ombudsman, 16 matters to the Australian Federal Police, 3 to the ACCC, the Australian...
How many to the ACCC?
3.
3.
And 1 matter to the Work Health and Safety organisation or agency in Queensland.
Is it possible to get an understanding of what, and obviously they're whistleblowers, but an understanding of the types of the complaints? Is that something you're able to publicly talk about?
We would be reluctant to do that at the present time, Senator, because many of those disclosures, and you've touched on this earlier, contained requests for anonymity.
Yep.
Or provided their details but requested not... We're happy to share those with the Fair Work Commission, but in many cases asked the Fair Work Commission not disclose them. And so we would be concerned if we were too finite about the types of complaints.
Well, what I might get you to do is just on notice and have a look as if you can group them in terms of bullying, harassment, intimidation, but don't go any further, obviously, so as not to compromise anybody's identity. Just in terms of, so the 307, the 16, the 3 and the 1, what then happens to the other ones?
So we conduct a detailed analysis of each matter that's raised with the Commission, and if the matters fall within the remit or the jurisdiction of another agency, as exactly for the reasons that you've just mentioned, we refer it to those agencies. If there's no... many of those, I can explain to you or say to you, Senator, many of those reports, rather than contain concerns about the CFMEU, are actually supportive of the CFMEU, and where people engaging with the Commission, saying, being very positive. So there was no need for the Commission to take any action in
that. So you sort through them and work out what needs to be referred and to which agency if they do.
Exactly, Senator, yes.
Just in terms of the administration itself, do you know how many positions within the CFMEU administration remain vacant? Because there has been some churn in staff. Travis O'Brien, Jared Abbott, I think Alison Curry, Joe Brecic. Do you know if there's any outstanding positions to be filled?
I'm not aware of that, Senator, but
not aware meaning you don't know. The knowledge is not within your possession because that's not something you would know.
That's
correct. Sorry, as opposed to not being aware.
Yes. Yeah.
Yeah. No, understood. And then just in terms of, say, Travis O'Brien, Jared Abbott, Alison Curry and Joe Brecic and their departures, would you be made aware of why they departed other than the public statements?
In certain circumstances, I recall receiving an email from Mr Irving about Ms Curry's conclusion of her service, and in that email he indicated that Ms Curry had been brought on to assist with the establishment of the administration, and then at a 6-month period had concluded her service.
Understood. Okay. Can I just touch on it? I've only got a few minutes before I hand over the call, and so I just want to touch very quickly just on another topic. Just in terms of the process for allegations of misconduct for appointed members of the Commission, be it their behaviour in a matter they hold carriage of or another Commissioner, or to another Commissioner or to Commissioner staff, what's the process for reporting those allegations?
If they relate to proceedings,
yes.
And there's information that we publish in our annual report about the complaints we received about the conduct of members and about staff. So in 23-24, 54 complaints were received about members and 44 were received about staff, which is a 20% decrease on the previous year. So the Fair Work Act sets out how the President may deal with complaints about members. It's section 581A. So the President can deal with complaints but doesn't have the power to discipline members. So if there is a complaint, to speak plainly, if there's a complaint about a member by a party, then they're supported by staff. They will be dealt with by the President, or he may elect to allocate that to another senior member.
Can the President propose training sessions or other such arrangements to assist the Commissioners in these situations, for example, professional learning support for classes of bullying or the action that they have been responsible for?
The Act provides the President with powers in relation to dealing with complaints, but not about disciplining them. So the President can recommend that a member undertake training or any other intervention that he deems appropriate, his honour deems appropriate at that time. But ultimately, it's up to the member whether or not they actually comply with that.
If they don't comply, then what happens?
I'm not aware of that occurring, Senator. I'll have to take that on notice.
Take it on notice. No, that's not a problem at all. And then also, who's required to pay for that? Is it the Commission itself, or would the member be required to pay personally?
I need to take that on notice as well.
And just in terms of repeated actions of misconduct by a Commissioner, is that reported through to the Minister's office?
The President has the capacity to, if his honour deems it is appropriate, to refer matters to the Minister, yes.
Have any been referred to the Minister's office?
Not that I'm aware of, but in the normal course of things, I may not be aware of those interactions. As you'd be aware, Senator, my role as the General Manager is to assist the President in ensuring the FWC performs its functions and exercises its powers. The relationships between the President and the members often sits outside. It sits outside of my operational remit.
Is it possible then to take on notice numerical data on complaints over the past financial year against appointed members. Can you also specify if it's from an internal complaint or from a party appearing and on notice is fine? And then what course of action has been taken? Can I just go back? I just want to make sure I got your evidence correctly, just in relation to the CFMEU administration staffing issues. Are you aware if the administrator has appointed replacements for the executive directors of Victoria and Queensland?
No. But in terms of the
no, you're not aware, or no, he hasn't.
No, I'm not aware.
No, you're not
in
aware.
terms of Victoria. What I am aware of, and you'd be aware of this as well, I think that came up in evidence earlier today, and something that we've commenced initial inquiries into the alleged events that occurred at the Queensland Council of Unions last week.
Yes.
And that's obviously people entering the QCU and threatening, allegedly, possibly threatening or coercing an individual from taking up a role in the administration.
Yep.
We're actively looking into that.
You're looking at that one.
Sorry, Senator Cash, can I check? Was your question whether Mr Furlong was aware of whether the executive officer of the administrator, if that's the right term, had been appointed in Victoria and Queensland?
Correct, yes.
So the report Mr Furlong just tabled from the administrator noted that Jared Abbott was appointed as the Queensland branch executive officer.
So he has been formally appointed? Yep.
Yeah, on the 19th of February. I didn't think there was a vacancy in the Victorian role.
My understanding that Zach Smith holds the role.
Zach Smith.
So he does still hold the role?
Yeah.
Yep, okay.
I think the Queensland branch was the only one where there was a vacancy.
Yep. Okay, thank you. And thank you. I will now, thank you very much, have a look at that. I'm happy to give the call over and then just see what other questions after the dinner break, unfortunately.
So we're going to bring them back?
Yeah. Let me just check. No, I'll keep going and I'll check.
Yeah, right. Cool, thanks. Senator Pocock.
Thank you. And thank you for...
We can dismiss Comcare and, as I usually say, run quickly. Sorry, Senator Pocock.
Thank you, Chair, and thank you for being here. I wanted to, let me just clarify your role in relation to the administration of the CFMEU. It's monitoring the administration and investigating if it is effectively implemented. Is that the right language?
Under the scheme, but I still hold and maintain the role as the regulator of all registered organisations, and the Construction General Division is still subject to all of the requirements that any other trade union or employer association has under the RO Act.
So do you have an opinion, given your role to oversee the effective implementation of the administration, about the safety of the administrator at present and the officers who are undertaking that role?
No, Senator. My role is clearly specified in the Act.
So you don't have anything to say on that?
Well, I can certainly say that in relation
would
to the
seem
matter,
to be irrelevant. Keeping them alive and healthy is critical to effective implementation, I would have thought.
And it's certainly not lost on me the challenging circumstances that they're working within. And I in every interaction that I have with the administrator or his officers, I ask them about how they're holding up as much as anything else. But in terms of the well-being, a good example of where my jurisdiction may be enlivened is in relation to what allegedly occurred at the Queensland Council of Unions last week in relation to that alleged conduct and whether or not that contravened the anti-avoidance provisions of the amended RO Act.
Okay.
Can I help, Senator? The Joint Agency Working Group contains all the law enforcement agencies, and when you're talking about safety of the particular administrator, that's an area that the group of law enforcement and regulators at that group have coverage of some of the material.
Can you tell me about that? I'm sorry. Can you explain?
There's a joint agency working group that's been coordinated by the Australian Federal Police, and that involves all state police agencies.
Okay.
And so if there was a threat against an individual in the CFMEU or anywhere, and it relates to the CFMEU, then it's a matter that would be relevant to the joint agency working group and discussed and coordinated either at the federal level or at the state level.
Also, Senator Pocock, you're absolutely right to be concerned, and we are all very concerned to ensure the safety of the administrator and his team and all of the staff and organisers and officials of the union. I'm not sure if you were here earlier today when I mentioned that the government had funded security for some of the personnel in recognition that these were roles for the administrator and his team that the government effectively had asked them to take on. I think technically the government in the broader sense, Mr Furlong, also, you know, without going into a lot of detail, some of the threats that have been issued, it's not clear whether they've come from people within the CFMEU who might be there now, might have been there, or whether they're from people in the industry more generally. And so there have been steps taken to try to protect the safety of some of these individuals.
I think it's a topic that's had a lot of public discussion, so clearly anyone watching this might be a top of head consideration, and you're saying there certainly are issues there. When I look to the report that you've tabled, this is a report given to you by the administrator in recent days. It's essentially a list of things done.
Yes, approximately 100 activities since the commencement.
An activity list, as opposed to any kind of evaluation of how things are going.
Again, sorry, I'm not sure if you were here earlier. In addition to the report that Mr Furlong has tabled, yesterday I tabled the report from the administrator, which is much more detailed about how it's going, if you want to put it that way, and what he's been achieving.
And Senator, in addition to that, I've met and I continue to meet and take soundings from a wide range of stakeholders representing many different interests in the building and construction industry. And through my ongoing interactions with the administrator and with many other parties representing a wide range of interests, I've made the following observations. The first is that based on all information available to me, the division is currently meeting its obligations under the Registered Organisations Act. 2, the President issued a statement, the President of the Commission, on the 14th of February 2025 that indicated that the open and cooperative interactions with the Administrator have led to higher compliance and significantly reduced timeframes for agreement applications made by the division. And based on this information and ongoing conversations I'm having, it is currently my strong belief that the administration is successfully discharging its functions under the scheme, the rules of the division and the RO Act.
How many agreements did you say earlier? I missed the number when you said it.
Have
been finalised?
444 have been approved.
Have been approved in what period?
I will ask Ms Anderson
and
to
my
come with some of the detail.
Is how
because there was a larger number that got the applications were either withdrawn or there were certain other steps that were taken to ensure compliance with the statutory test for enterprise agreement making.
So I'm interested in the number and then how it compares historic. I know these matters are cyclical. That may be a feature also, but you know, I think what people want to know, and we're very concerned, of course, about safety and conditions in the industry while this arrangement is in place, is the bargaining level and the agreement registration at the level that is normal for the sector.
Jennifer Anderson, Acting Executive Director of Tribunal Support Branch. So just to confirm, we've had 439 applications that have been approved since the President announced the additional measures that were to be applied to CFMEU Construction and General Division agreements. So that is to 31 January. So I can take on notice to provide more updated data if you'd like.
It's more the comparison backwards that I'm interested in.
Yeah, so I don't have specific comparison backwards. I think Mr Furlong indicated that we were, at the last estimates, that we were expecting more construction agreements, certainly in the first quarter of this year. His evidence has been that they're continuing to come through. I don't have specific data in front of me.
Could you take that on notice to give us a sort of, say, 3-year backwards comparison? So I think people are in.
Works in bargaining cycles as well.
Yes,
so
I understand that, but and you may want to go longer to make sure you catch that cycle. Sure. But thank you. I read a report in the Saturday paper. I haven't got it with me, but it was an analysis about it included many comments, but one of the comments was by workers within the sector, within construction, who said they were very critical of the administrator's communication with people in the union. I wonder if you have a view about the adequacy of the communication of the administrator and his office with members of the union and people in the industry, and people who are employed in the union as well.
I've read the report as well. Those matters are a matter for Mr Irving to deal with as he sees fit. As I indicated earlier, the administration is operating independent of government and government direction. So I make no observation, nor would it be appropriate for me to do so.
Do you have any observations to make about how adequately or in what ways the administration is reaching out and taking action in relation to employer behaviour? I'm not aware of specific instances, but I understand that the administrator is on the record indicating that it was in his report that was tabled as well that every participant in the building construction industry has a role and responsibility to ensure broader compliance and bringing that industry into compliance. In conversations that I've had with the administrator, I've referred to the term the behaviour walk past the behaviour accept. And when I presented to the membership of some of Australia's largest constructors and memberships of Australia, some of the larger employer associations, I've repeated those messages as well. I guess I'm curious, and there's been quite a bit of commentary about how corruption in this industry, which has long life, is not just a matter for employee organisation.
I can help you by saying that the administrator's made it quite clear that his investigation into the culture in Queensland, into the perhaps violent culture in Queensland, certainly encompasses both the activities of members possibly within his union and employers. He's made it quite clear that he's intending to focus on that, both of those both areas, if you like, in the whole industry in Queensland.
One of the other points of commentary publicly has been about turnover within the administration staffing. Have you got any concerns about the way that is affecting the operation and its the effectiveness of its work? I think we covered this. I'm not too sure if in the room at the time. Senator. I'm sorry, I was not. Okay. Forgive me for you. We addressed these questions with Senator Cash a little earlier, and what there has acknowledged that there has been turnover. I understand that certainly one of the senior members of the administration I received correspondence from the administrator himself about Ms Curry and the conclusion of her service, which was in relation to that she was brought on to assist with the establishment of the administration, and at a 6-month point she chose not to renew her contract. As you're aware, as I'm aware, they're operating in very sort of challenging circumstances. But as we traversed earlier this evening, the senior roles have been filled in each of the branches. They're into that, yes. The administrator's report points to that horrific statistic of 45 deaths in the industry. It says in 2023. I think that's 2024. It's been the same, I think, in the last calendar year to the year before, which is, horrific. And I think, as they make the point, significantly higher. Is that right? 36% higher than the 5-year average for the industry. It's
I don't have those stats in there.
No, it's in his report, just here. Are you confident from what you are observing that the industry, the workers in this industry, whether they're in the union or not, are getting the protection and support to stay safe and getting protection for their conditions in the way that they need in a very dangerous industry?
I can only comment on the areas that I'm personally responsible for under the Registered Organisations Act. I don't think that I'm qualified to answer that question, Senator.
If you look at the business coming before the Commission, are you seeing any change in the nature of disputes, action in the construction industry that may reflect a change in the governance of the union and the industry more broadly?
I'd have to take that on notice, Senator.
Okay, thank you. And thanks for your tolerance. I wasn't in the room earlier. I was running between things probably. But I have just one other area of questioning. Is that okay?
We've just got a break, but I'd like to let people be released, so if it could be quick, that'd be great.
I'll try and get through it. I'm just interested in your observations from the Commission's perspective about the right to disconnect.
I might ask Ms. Bright to talk about the model term and then very quickly Ms. Ethan to speak about the disputes function, please.
Thank you.
Thanks, Senator. Zoe Wright, Acting Executive Director of the Legal Performance and Engagement Branch. Let me just find my notes for you. So the Commission has a range of functions in relation to the right to disconnect. We were required to make a model term, which went into modern awards. That process was conducted last year and all 155 modern awards were varied to include that term. The Commission also has a range of has a dispute function in relation to the right to disconnect, and Ms Eaton can provide some more detail about that. The Commission was also required to make guidelines about the right. We haven't made the guidelines as yet. The President issued a statement saying that he thought it would be better to wait until we'd had some disputes about, what the right looks like, what the sort of issues being determined before the Commission were, before we made the guidelines. So,
great. Yep. So if we can hear about disputes.
So from the 26th of August 2024, people can raise a dispute in relation to the right to disconnect with the Fair Work Commission. Since then, until the 17th of February, we've received 4 applications to deal with a dispute about the right to disconnect. One of those has been withdrawn and the other 3 are currently before the Commission. In addition to that, people can also lodge an application under the General Protections jurisdiction, as the right to disconnect is a workplace right under those provisions. We've received 4 applications under the General Protections jurisdiction. In one of those, a certificate has been issued and the other 3 are still ongoing.
Can you tell us a little about the certificate and what it might have said in that particular case?
I don't have that information before me. I'll have to take that on notice.
So how does that level of dispute for a new right that is, 6 months old, compare to other kinds of disputes that you're seeing? I'd have to say it low, I'm assuming.
Yes. We receive approximately 15,000 fair dismissal applications a year. What we expect is occurring is that if there are these issues are being discussed and resolved in the workplace in the normal course of things.
Which was the intention.
Yes.
And it's built into the law to have exactly that procedure. Okay. Thank you. Thanks for your evidence. I really appreciate it, you being here tonight. Thanks, Chair.
Good, thanks very much. We'll now you're excused, so thank you. Thanks for your time. That's the completion of outcome 1. We'll now, of course, we'll come back at what time? Come back at where are we? 7:30. 7:30. Cool. The 7:30.
7:30.
Yep.
Great.
Yep.
Real great.
Ready to go, and I'll go to the coalition first once we... Good, thanks everybody. We'll recommence, and I'll now enjoy us going over to outcome 2. Senator Sullivan.
Oh, thanks, Chair. I've just got a couple of questions about fee-free TAFE.
How good is it?
Very
good. Is that one?
Yeah, so I just want to table what is a transcript of a social media video that someone has posted.
Someone?
Bridget Films, at Bridget Films. Now, it is on TikTok, so...
I can't look at it.
I know it's banned from the... So, with your indulgence, Chair, I'll read out the transcript.
Sorry.
But everyone will have a...
Go ahead.
Everyone will have a copy of it. So this was posted exactly 12 months ago, on the 26th of February, with the caption, "Free education tips you can take," or sorry, for you, ex-TAFE. And it says, "I'm going to let you know some information that I'm not meant to know. You know how there's all these like fee-free courses coming out by TAFE, which if you didn't, you should effing most definitely hit that up. Holy F. Pretty sure in Queensland you can't just like study to be a nurse at TAFE for free. Like $30,000 that you don't have to pay. The TAFEs do not talk to each other. So if you're travelling, laughs, when I first moved to the sunny coast, I studied a Cert 3 in Conservation Land Management. That course was free. That was kind of more so to help the youth out. I was under 25 at the time, so it was free. In the middle of the year, I'm going up to Cairns to study my coxswain, which is like to drive boats and stuff. The course falls under the fee-free TAFE, hence why I'm going to Cairns. I'm getting a cool road trip out of it. Now enrolled to study outdoor education next year at TAFE Newcastle. It's free." So, my questions are, what Commonwealth supports are accessible to young persons studying a course at TAFE?
Well, the officials can give you some detail, but I think the answer is it depends on what kind of course they're doing. There are particular courses that are free in some states. There are different courses that are free in other states because this is all being done with the states. There are particular courses that there are additional incentives, construction, new energy, for example. So what exactly do you mean?
Well, what supports are there in addition to the actual course, the tuition fees? Are there other supports available to students? This person's claiming that they were able to get a road trip out of it. I just want to check firstly, is that something that someone can get?
So each state and territory government do have additional supports around TAFE students, depending on the eligibility. They will determine the eligibility factors and the types of additional supports they might provide to a student. In terms of the fee-free TAFE program, and Ms Wilkinson and Ms McDonald can speak to this, this was specifically around subsidising the cost of the fees, not around additional supports for students in the context of other needs that they might have.
Are students studying a free TAFE course, are they eligible for any Commonwealth loan at all, student loan?
No, they may be. No, they're not eligible for loan. They may be eligible for youth allowance in the DSS portfolio, but...
okay, so if they were continuing to study, they would then
there's youth allowance.
Continue, if they're eligible,
yep.
From a means testing point of view, then they would...
And age.
That could extend their eligibility.
Yeah, you'd need to talk to DSS, but there are a whole lot of criteria about eligibility for youth allowance.
Okay. I take it you haven't seen this video before. I wouldn't imagine you would have, but so you're seeing that or hearing about it for the first time today. And I make no judgment on the young lady that's taken up these opportunities. She's presumably working within the system that's available to her, and good on her for choosing to study to better her position. But is that the purpose of fee-free TAFE? Like, should it be enabling people to do multiple courses in series?
So the purpose of fee-free TAFE was twofold, essentially, to support priority cohorts to access vet training, and also to support to encourage students to focus on areas of high priority need. That being said, the requirements around fee-free TAFE have also been determined in consultation with state and territory governments. And so each government has also thought about what those localised skill needs are, and they set the courses that are available in consultation with the government. So whilst, I mean, I guess what I would, whilst I can't talk to the Queensland government decisions, it might, I mean, one might hazard to draw a set of logic around the GSP in Queensland is focused on tourism. It might be that there is a demand in Queensland around particular kinds of skill sets, both in terms of outdoor education and supporting the tourism in particular areas. And so that might have been a determination for the Queensland government to add those courses to the list.
And that's not my question. I mean, she's doing some courses that seem very legitimate. My question is, is the intention of the program to allow people to be able to do multiple courses in series in the way that this example shows that they're doing?
So states and territories set the individual eligibility requirements for students. Yep. So I'm aware that some states, for example, Victoria at one point, they had a limit of only one course per student, which they then changed. But it is up to each state and territory as the delivery partner to set those eligibility requirements.
So she's saying that the TAFEs don't talk to each other. That's her observation. Is that right? Like, is there communication between, across the system? Each state and territory have somewhat different arrangements around the relationship between say the equivalent of DUA, the department, and the TAFEs in their system. But there is, I think each of my peers, my skills and training officials, work very closely with the TAFEs in their jurisdiction. They facilitate those TAFEs coming together. I couldn't really necessarily reflect on how often those TAFEs talk to each other, share that enrolment data. But the thing I would say too is that, and I'm not presuming that that's the case here in relation to this statement from this person, but where a student decides not to continue study in their course, the funding for that course goes back into essentially back to the free TAFE bucket, and then is available to another student. Sure, and we don't know whether she completed the course. I'm assuming that she has, but we don't know that, I guess. But is there potentially an issue with the fact that, she was in New South Wales, then she's moved to Queensland, so there's a cross-jurisdictional issue. Is there any collaboration and communication and connection between the various jurisdictions in making sure that if the parameters are that you can only do one course?
I think that would be a matter to address to the state government. So if a state imposed a limit on the number of courses and they were concerned, particularly in those jurisdictions where the border, has towns very close on each side, that they may well talk to each other. I don't think, we're not aware of that. That is a matter for state governments. Yeah, I would say Queensland and New South Wales do have quite a level of cross-border collaboration around TAFE and their TAFEs, particularly along the border. But perhaps, Senator, that's something we could take on notice and ask of our colleagues in both of those states. You've kind of answered this already, but just for clarity,
are there any mechanisms, do any mechanisms exist that would prevent someone enrolling in multiple courses across jurisdictions?
At this stage, there isn't a explicit mechanism outside that we are aware of. I would like to take that on notice, though, because I do know that the colleagues across New South Wales and Queensland border do communicate a lot around collaboration between their TAFEs, and perhaps there's something that we might not be aware of in that case.
Can you confirm whether the Commonwealth is tracking student enrolments at the kind of individual level?
We track the total number of student enrolments.
So not at the individual level.
But not at an individual level, no. We don't have individual student
we covered that through the inquiry. So do you have any... So the Commonwealth, therefore, doesn't have any centralised tracking system to monitor multiple enrolments because you're just getting the aggregate?
Yes, that's right. We get the aggregate data.
You're getting the aggregate. Okay, so you couldn't then therefore say that right now across the 600,000 plus enrolments that have been promoted as part of the success, so-called success of this program, that it's 600,000 individuals. Because there could be people enrolled in multiple courses.
We couldn't.
So the Commonwealth couldn't possibly know.
We don't have that data. And there may well be students who are enrolling in a
so then on what
Cert
basis
1 and
is
moving up to a Cert 2 to
so on what basis then is the government able to claim that 600,000 Australians have benefited from fee-free TAFE when we've got evidence here that people are able to enrol in multiple courses and therefore would be counted 2, 3, how many times? Well, you don't know. So how are we with any confidence saying that there's 600,000 Australians?
Take that on notice because I think that's a question I'd like to ask my colleagues across states and territories, recognising that they are the owners of their state and territory systems and they are collecting the data. I'd like to pose that question to them around where they might have students who are enrolling in additional TAFE courses, but I'd just also like to pick up on Ms Wilkinson's point, which is that part of this is also about enabling people to be able to move from a Cert 2 into a Cert 3 into a Cert 4 and have that opportunity that is being able to kind of increase those qualifications.
So this video has been viewed 317,900 times. It's been liked 13,600 times. It's been shared or bookmarked 2,500 times. So it's been pretty well promoted by quite an industrious young woman here. Good on her. So does that concern you that this practice might be a little more widespread?
I think, Senator, it would concern me if the student wasn't, if there was, and again, I wouldn't want to presume based on what we're seeing if there's some sort of not entirely appropriate behaviour going on, but I think in the context of the objectives of the fee-free TAFE program, where we're really wanting to encourage people who might not otherwise be able to afford it to access skills and training opportunities and, accessing those opportunities that align to those priorities both at a local, state and national level. If she's somebody who obviously likes learning, then that's a positive thing. As I said, I would like to take on notice we can get a sense of whether or not this is a wider scale issue, but I would also note that it is part of the process around being able to re-enrol and get those additional attainment levels.
Just ask a follow-up question, Chair?
Yeah, by all means.
But, I mean, this wasn't a case of re-enrolment to increase a level of certification. This was 3 quite separate courses. I mean, presumably one of the goals of this program is to undertake a course to then go into the workforce. Whereas here you seem to have someone indicating that they're going from course to course to course.
Well, I think one, I mean, it's...
I'm not sure that's really the goal, is it?
I think it's an individual case. We don't know what her employment outcomes have been as a result of this. I think there's some relativity between two of the courses. The goal is to support people who otherwise might not have exposure to study and learning to be able to access that and to be able to, through that study and training, find a pathway to employment. So I think we're really sort of commenting on, we don't know the whole story here.
And I can accept that. I mean, it's a TikTok video, but it has been widely viewed.
I understand, Senator O'Sullivan. Someone has been having a look at this person's TikTok account while we've been talking, and in another video that they've posted, they apparently explain how these courses are linked to their career path and growth. I mean, I don't know this person. I can't verify that.
And as I've stated, I'm not in any way judging the person nor the credibility of the course choices. I mean, it's...
I guess I'm just raising that because there have been questions about whether it's legitimate for people, whoever they are, to do multiple courses and whether that's actually helping them get a career. It would appear, based on this person's video, that has occurred.
And my question previously was in relation, when you say there's 600,000 Australians, I take that as being individual people. It couldn't possibly be that number, given
I've looked at my notes
there's at least one person that's done 3.
Well, I've looked at my notes here, which indicate that what we talk about is there have been 600,000 enrolments. I don't know what different people have said about this, but what I do know is that free TAFE is a good thing, and it's disappointing that the Shadow Minister, Ms Lee, said that not only that it was wasteful spending and that your party would get rid of this in government, but that if you're a Liberal, I think the words were, a central tenet of the Liberal Party philosophy is that if you don't pay for something, you don't value it, which is a pretty snobby view, I reckon, of people who are taking up free TAFE courses.
What steps has the department taken to enforce eligibility criteria and prevent oversubscription by repeated users? You've said that they're, because you're not able to track it, are you saying that there's no way for you to actually enforce it?
So I think, as we've just said, it's a states set the eligibility, and to the extent there's tracking of individuals, that would be at a state level.
So when you're coming back to us with, you've taken some questions on notice there, can you come back to us with how many students have enrolled in more than one free course?
So I can certainly ask my colleagues across state and territories whether that is something that they can easily identify. Senator, if I can just probably, if you can bear with me, just to the point around repeated users. The purpose and the design of the VET system is a modular system where people can build upon their qualifications. So I think as a premise, we wouldn't say we have a problem with someone going back in and saying, I'm going to take that next qualification and I'll leverage, if there's a fee-free TAFE available as set by that state and territory government, I'll leverage that. Obviously want to be aware of where perhaps, that there's sort of flagrant abuse of that, but this idea that repeated users is necessarily a bad thing in the context of the program and the number of enrolments, I just would like to clarify that in many ways that goes to the fundamental precepts of the skills and training system, which is about modular qualifications and building on your qualification journey in order to get to, pathways to employment.
Just a couple more on this. Yeah, thanks. So over $1.5 billion has been committed to this program on the basis that it's delivering skills needed to deal with skills shortages. How will you guarantee that this doesn't just become a publicly funded road trip or joyride?
I think so. It's a good question. I think it's an important question in the context of the purposes of the program. We have a fairly, we're building out a fairly robust reporting system with states and territories, and I think when we spoke with you, with the committee at the inquiry into the bill, we talked about that one of the benefits from officials' perspective, I guess, in terms of transitioning this to an enduring and sustainable program is that we can then insert it into the reporting and data capture that is, again, a feature of the national system. So leveraging the national centre, the NCBR, the data custodian for all states and territories, and using that as a mechanism to enable that data reporting and oversight in terms of how this is used and where it's being directed. But in the meantime, Ms McDonald can talk to you about the reporting that is currently in place to monitor how this is being spent.
I think we covered that quite extensively in the hearings, but if there is anything you wanted to add to what was already said there,
No, Senator,
that's fine.
Yeah.
I'm across that. Chair, happy to share the call.
Good, thanks.
Sorry, before we move on, I just wanted to clarify one point that I said earlier. So if a student is an apprenticeship under fee-free TAFE, in some circumstances they may be able to access a trade support loan.
Okay.
And that would be, they would need to be in a job in a priority occupation to do that. So it would be a small subset.
Yeah, and you already said that there's other supports provided by Services Australia, that, like youth allowance,
which
and
is available in some situations.
Yeah. Okay. Thanks.
Good. Thanks very much. I just want to go to the strategic review and questions arising out of it of the Australian Apprenticeship Incentive System and the boosting and completing apprenticeships commencement programs. In the last sitting of the House in Canberra here, the Shadow Assistant Minister for Social Services, Pat Conaghan, said the government would be better off going back to the Coalition's policy where we funded the employer 50% of the apprenticeship first year wage. So it's stated on Hansard, 10th of the 2nd, 25. The program the Shadow Assistant Minister is referring to is the Boosting Apprenticeships Commencement Program. Now, if you just bear with me, the strategic review of the Australian Apprenticeships Incentive System found that the boosting and completing apprenticeships commencements programs were being misused by employers in what they call a sharp practice. And I'll go to some of the details of the sharp practice, but just broadly, the sharp practice, I understand it from the report, was the staff were involuntarily enrolled in trainee programs and often not told. Businesses were converting existing workers to an apprenticeship to receive a wage subsidy rather than for the purpose of training. And businesses would not, quote, take on apprentices with little interest in providing them with sufficient on-the-job training or supporting them to completion. What was the tag and the cost of those two programs, commonly known just as the BAC and CAC?
Belinda Campbell, First Assistant Secretary, Skills and Training. So between October 2020 and 31st of December 2024, it was $7.6 billion for the boosting apprenticeship commencements and the completing apprenticeship commencements wage subsidies.
So this is the program that was referred to by the Assistant Shadow Minister in just at the end of last year. Now, in some of those, do you have a knowledge of some of the schemes that have been named? And I might just sort of name a couple of them. It was exposed in an article in the Australian Financial Review on the 13th of February by Ron Misen. And the heading of the article is Pub Chain got $9.7 million taxpayer funds to fully train just 96 staff. Now, if I've done my calculations right, for completions it was about $101,000, which is a substantial figure, and that's what he wants to go back to. And also the article goes on to talk about the Queensland Venue Company, a joint venture between hospitality giant Australian Venue Company and Coles, and it talks about the scheme and, of course, the lack of completions. I think just 22%. I just wanted to go to this thing. Do you know how many trainees were signed up to the program overall without their knowledge? And there's not a specific number, just if you're able to give us what you understand as a broad figure. And can you take some examples that you've heard from the strategic review, just inform us about these sharp practices?
Senator, I can provide some numbers around commencements and recommencements under the Boosting Apprenticeship Commencement Program, and to split them into trade and non-trade occupations. I can't answer the question as to the number of apprentices that were signed up without their knowledge, but I can give you those other numbers.
And after you give me those numbers, you might just give me some of the examples of what the review found as sharp practices. So some examples of live examples. I gave one just then. There may be other practices examples that the review gave of what was described as by the review as sharp practices.
So under the Boosting Apprenticeship Commencements, there were a total of 429,100 commencements and recommencements. Of those, 210,900 were in trade occupations, and 218,200 were in non-trade occupations. The strategic review did look into the boosting apprenticeship commencements and did engage with a wide range of stakeholders throughout the review. And I think the sharp practice that was referred to within the strategic review referred to the increase in the number of non-trade sign-ups, particularly towards the last 2 quarters of the Boosting Apprenticeship Commencements program.
And what was some? Did they give you some specific examples in that review of what they saw as sharp practices? So they give you some examples of actual. Did they give you any specific examples of actual companies, or is it? I can rely on a number of articles that have been produced. Grilled, for example, had a very low take-up rate. $72 million thereabouts paid to McDonald's for a university hamburger, where many people weren't completing any sort of training at all, but getting paid trainee wages. So it's a particularly warped situation where there's suggestion that we go back to a scheme where 50% of the wages are being subsidised. They're also on trainee wages, so the workers are also getting hit that way, and they're not completing training as low as 22%. I think there were some reports of even lower percentages.
So it really did vary organisation to organisation in terms of completion rates. I think, as we've provided in evidence before, each of those apprentices would have needed to complete a training contract and to be supported by an Australian Apprenticeship Support Network provider at the time of sign-up. We do have, there are some variation in completion rates, but noting that a lot of those occupations that we're talking about were in non-trade occupations. The article in the Financial Review did call out completion rates for McDonald's of 53%, Grilled of 33%, the Queensland Venue 22%.
And the grilled, I think, with a 33% completion rate, if it's the other article we're referring to, the article I was referring to on the 13th of February. So we've got those figures on the lack of numbers that are going through. Was there a penalty? And again, the department's managing what you've been asked to manage, or as a policy you've been asked to manage. Was there a penalty put in place if companies were getting low margins on completion rates?
So the Boosting Apprenticeship Commencement program was introduced at a time when there was a significant decline in the number of commencements. So it was focused on creating employment pathways for apprentices. The design of the program was paid based on wages actually paid. So employers could only claim payments throughout the apprenticeship paid in arrears. So it was based on actual wages paid. So once an apprentice dropped out of their apprenticeship, they would be no longer eligible to continue to claim those wages. But it didn't include a completion payment.
So there was no. So the company's getting a subsidy, which is effectively, it's a subsidy. The workers not getting workers in a number of circumstances aren't getting their courses completed. If an employer drops below a certain percentage of performance on completion, did they maintain still their subsidies? They still able just to churn and burn through other people and still receive the subsidy?
So the way the program was designed was to pay on actual, to reimburse employers on actual wages paid, and to be paid along the life of the apprenticeship. It's a challenge in apprenticeships, particularly for longer-term apprenticeships, where we tie payments to completion rates because of the length of time. It is something that states and territories look at in determining the suitability of employers on taking on apprenticeships, and as part of their role in regulating suitable apprenticeships within their states and territory, but it was not a feature of the Boosting Apprenticeship Commencement program.
So again, we've got half the wages subsidised. We've got as little as 33% reports 22% performance. We've got billions of dollars spent on the program that obviously failed, and of course the Albanese government's discontinued that program. Employers could, under those circumstances, under the old program, have had, under that program that the Shadow Minister wants to bring back in, under that program, they could actually have zero completion rates and still receive tens of millions of dollars in subsidy.
Under the design of Boosting Apprenticeships, they would receive wage subsidies while those apprentices remained employed, and it would be paid in arrears.
Yeah, so my point is that, and I respect the way you're answering it, if someone didn't actually receive a certificate at the end and there was zero receipt of certificates, that the employer could still receive those tens of millions of dollars worth of subsidy for those wages.
That is possible as long as they've continued to pay that apprentice during that period.
Thank you. So that's the scheme that the Shadow Minister wants to return to. Minister, the fee-free TAFE. I mean, I've been to Fish Week down to the college down there and met students that are doing fee-free TAFE. I've been in the Northern Beaches, Sydney, recently down in Adelaide with Senator Grogan, and talking to students and teachers, the TAFE system, and hearing stories one after the other of people that could not have done the training without it being free. You're bringing people back into the community, back into work, single mothers, young families. Minister, and seeing the enthusiasm of people actually engaging in those programs, it brings a tear to the eye actually. So it just, it says this is something that's actually making a difference to people's lives. Minister, how important is it that we pursue free TAFE, and should we go back to what the Shadow Minister has proposed is university burgers, or is it, is that just a ridiculous sort of proposal?
Yeah, I mean, I think the proof of the success of free TAFE is there in the numbers of enrolments. Senator Sheldon, you've spoken of the personal experiences you've had meeting people who've done free TAFE courses. I've seen that myself everywhere from Rockhampton to Western Sydney and a range of other places as well. And it's a good thing that people are getting extra qualifications. It helps their employability. It helps employers to find the skilled workers that they're looking for. And, we all know that the last couple of years have been pretty tough for Australians financially, and it allows people to get those qualifications for free. So it helps them from a cost of living point of view as well. So that's obviously why we're committed to entrenching free TAFE through the legislation that's currently before the Parliament. And again, the evidence is pretty clear that the approach the former government took was not successful in delivering genuine qualifications for people in the way free TAFE does.
And with back to the department, with the policy under the former policy that the former government had, has the department investigated employers signing up existing employees as new apprentices in order to receive a subsidy? So have you looked up, have you had an investigation to any of those companies?
So under the current apprenticeship incentive system and under boosting apprenticeship commencements, there are circumstances in which an employer can engage an existing worker. There's always been within the apprenticeship system the ability to take on an existing worker into a priority occupation, or as the previous system was skills in need. The initial boosting apprenticeship commencement didn't include a cap on existing worker take-up, but after the first month of operations, a cap was introduced of 30 apprentices as existing workers
30.
Under the program.
And just on just going back to the point about the trainees that signed up the program without the knowledge, was it when those examples came out, was there a review under the previous program, a review of how that program operated? Obviously there's a strategic review, but was there an attempt to go and look at employers that had signed up or had been allegedly signed up people without their knowledge to some of these training programs? I recall a number of assertions about grilled and people discovering that they were on trainee wages and not realising that there were subsidies being provided to the company to employ them whilst not receiving appropriate or, in some cases, any training at all.
So, two parts to the answer. So, regulation of apprentices is a shared, it's a responsibility of each state and territory to regulate the apprenticeship. But we do have in place a compliance frame for all of our programs. So we have been undertaking essentially looking at instances in terms of how our programs are running, whether they're meeting their purposes, but also where there's potential, as you said, potential sharp practices or misuse of the program in the context of the program guidelines. One of the things, so we are, for instance, we have been, at the time of the back in the CAC, we had a compliance frame set up, recognising the broad parameters of those guidelines, and so what constituted non-compliance in the context of that program. We're currently, for instance, working with the South Australian Training Authority as they are investigating an employer and a set of arrangements around apprentices and trainees and whether or not they got appropriate training as part of that employment contract and that apprenticeship contract. So South Australian Training Authority is leading that work, and then we're working alongside to assess whether or not that particular employee had access to our program funding and, any other intersections, both in terms of supports available from the Commonwealth, but also responsibilities in relation to Commonwealth as well.
So just a final question to the Minister. On this question of the $7.5 billion that was spent on that program, Minister, that had some, that's, all these questions have been raised. I probably, as the next person in this room, likes a good well-cooked hamburger, but should we be subsidising 50% of the wages, as has been suggested by the Shadow Minister just at the end of last year? Or should we be investing in those skills that we need to build housing, our care industry, all those priority areas that have been identified in fee-free TAFE, and reach out to those cohorts of people that we can bring back into the workforce when there's a tight labour market?
Yeah, well, I think the review did indicate that some of the policies followed by the former government weren't effective in delivering the kind of skills that people are looking for, or that people need, or that employers are looking for. And in fact, that the review found that particularly big businesses, they were happy to take the incentives available, but they pretty freely admitted that they didn't really need them, and that didn't influence their decisions to take people on for apprenticeships or traineeships. So, we think that there is a better way and a more cost-effective way to provide people with the kind of support that they need to get the qualifications they need and that employers are looking for. And that's one of the reasons why we're such strong supporters of free TAFE.
Thank you, Minister. Back to Senator O'Sullivan.
Thank you. I'll just start with a couple of questions in follow-up to the questions you've been asking, then I'll go to Senator Brockman. Can I just... Context is always important. Can I just get an understanding, when did the Boosting Apprenticeships commencement program start?
The Boosting Apprenticeship Commencements program started on the 5th of October 2020.
2020. And what was happening in the labour market at that time?
In leading up to Boosting Apprenticeship commencements, we had a decline in commencement numbers within apprenticeships. There was a program for apprentices to support existing apprentices and trainees to remain in their apprenticeship.
And what was causing the depression in the labour market? COVID.
Once in a generation pandemic.
Once in a generation. Yes. Thank you. Context important. And were people that were employers receiving the back, were they also in receipt for those employees JobKeeper?
No, they could only receive one Commonwealth program.
Right, so other employers that didn't have someone participating in that program, or even that employer that had someone not participating in this program, would have been eligible for JobKeeper if at that time.
Yes, but this program was designed for
different
apprentices.
Purpose, but there was no double dipping.
Not
for an
to
employer?
I can't comment on that, but not to my knowledge.
Yeah, so you're only eligible for, as an employer, to claim for one of those, as far as a wage subsidy goes, in inverted commas.
Yes.
Yep. Thank you. And of course, my recollection from the learnings from research that was done around the GFC was that the first jobs to go in a depression in the labour market are those lower skilled workers, and apprentices are often included in that when you're seeing a downturn in jobs. So how important is it to have initiatives within the labour market that are actually keeping people engaged and in work, particularly for lower skilled or early skilled trainees?
I agree. I think the research shows that not only for low skill but for young people, keeping some sort of stickability to skills training or work or study is important. And I think both GFC and previous recessions have demonstrated the impact in terms of the time that it takes them to get back into the labour market after a big economic event.
Keeping connected with the workplace and the employer was really important.
Study training.
Yeah, that's different. This is about JobKeeper.
Well, you could only claim one as the employer, and these were apprentices and trainees. Thank you. We'll go to Senator Brockman.
I mean, it's interesting, Senator O'Sullivan, you make the point that that program operated during pandemic, and there may have been reasons for doing so, but we're obviously not in a pandemic anymore. So if there ever was a justification for that program, it's hard to see why it would be justified now when we've got a very different labour market.
You could set different parameters. Minister, no announcement's been made in relation to the integrity measures that we put around that sort of program. And incentives are proven to work for employers, particularly those employers.
What employer would you
agree? Would you agree that when I was a first-year apprentice once, and I can tell you, probably wasn't much value to my employer, but he stuck with me, thankfully. And in that first year, so that support to encourage employers to continue.
And you will have seen
people.
that we recently extended employer incentives for apprenticeships.
And I will come to that, but I want to go to Senator, because I do want to cover that and understand that better. But we'll go to Senator Brockman first.
Senator Brockman.
Can we go to Jobs and Skills Australia, please? Don't think this will take too long at all. Congratulations, first of all, Mr. Glover. You were recently appointed to, and I'll get this right, the Australian Tertiary Education Commission as the Commissioner, starting on the 1st of July. Am I correct in that?
No, Senator.
No. There you go, very quick.
Thank you. That was your line of questioning?
That was my line of questioning.
He might come back. He's come all this way.
So that wasn't announced?
I'm sorry, Senator?
That position wasn't announced, your position?
No, what I've been requested to do, Senator, is to provide advice in my role as Jobs and Skills Australia Commissioner to the interim commissioners for the Australian Tertiary Education Commission, Professor O'Kane and Distinguished Professor Brent. In my role as JSA Commissioner, I have a remit to provide advice to government and government agencies in relation to the national skills system.
So this is part of your current role as head of JSA?
My current role.
Commissioner for JSA.
Yes.
So it's incorporated into your current role. There's no new position attached.
That's exactly right, yes.
Oh, okay. There you go. This was a very quick set of questions. Excellent.
Senator O'Sullivan.
Thank you.
Should we keep JSA at the table?
I think that might have been it. Okay, hang on.
No, Joe, let's
have you been appointed to anything else?
but thank you.
I will ask a follow-up question. The reason I thought it was a separate appointment, so I apologise for getting that wrong. But isn't there a potential conflict of interest between the demands of JSA and the demands of the, I'll get this right, Australian Tertiary Education Commission? I mean, determining priorities between, say, TAFE and the universities and employment priorities in the overall economy?
If I might start with that, Senator. So not at all would be my view, because a key priority for the government and for stakeholders coming out of the University Accord and numerous other reports is, do we say harmonisation? Between the vet and university sectors and better relationships or better integration and accessibility across the two sectors. And so it's entirely appropriate and really helpful for Professor Glover to be in that role. He's played a really instructive role as part of the consultation process that the Minister set up to advise him on the Accord response, the government response to the Accord. And so
We are seeing shifting in the architecture across universities and skills. Jobs and Skills Australia was birthed in this government, and we've also got Jobs and Skills Councils and other important architecture to bring order and focus to and stewardship into the vet sector. But of course, we know that it's really important to have an integrated tertiary system, and there are a lot of challenges and a lot of work and a lot of initiatives coming from the budget around that really do require the vet and university side of things to come together. And Secretary Cook and I certainly discussed this appointment, and we're both very comfortable that there's no conflict of interest.
Okay. I'm happy to leave it there. Well, before you go, was there any remuneration attached to the ATEC role? So you're there by virtue of the fact of being the Commissioner?
By virtue of being JSA Commissioner. Yep. We do work on tertiary harmonisation, the national skills taxonomy, our vet national data asset work. We are there for the integrated data assets we can provide to support decision making in the ATEC. JSA is a secondary statutory authority, which means our structure is of value in the establishment of the ATEC. I bring extensive experience as a former Vice-Chancellor and a member of the University Accord review panel to provide insights into the challenges of the sector at the moment, and certainly, as it's been indicated, JSA has played a critical role and released a report on Saturday around tertiary harmonisation. So I look forward to providing advice and guidance, which I do to many departments and many agencies when requested, on all matters to do with jobs and skills, the national skills system and its interplay with Australia's labour market. Yep. I think that's appropriate and within the remit of the Act and my position.
Yeah. No, that sounds very, very sensible, very straightforward. Have you, in terms of needing to take on, though, the additional responsibilities that do come with the Commissioner role, has any additional resources been required within JSA to offset anything that you're not able to cover off? I mean, or it's not a material issue?
I don't think it's material, Senator, and I do have, as you know, 2 Deputy Commissioners who have begun, so there's great support for me as the Commissioner, and I look forward to the support of the Executive Director and the leadership team at JSA. It's a very close relationship between Jobs and Skills Australia and the work that will be undertaken should the ATEC be established in the future.
Okay. That is all. So that is actually going to be all for Jobs and Skills. So I don't know if you're allowed to leave early, but Coalition's not going to ask you any more questions. So thank you. You'll have to check with the chair, though.
You are definitely allowed. You're definitely permitted to leave, and thank you very much for coming and joining us.
Thank you for that. So I do have another line of.
Oh, that's good.
Oh no, not there yet.
Oh, right.
Gee, it's only 8:30.
Nearly, though.
Okay, I do want to go back to the Strategic Apprenticeships Review. I'll just wait for the officials to come. Is the department aware that we have record rates of small business insolvencies at the moment?
Well, this has been pointed out many times. That's your version. If you look at the number, the proportion of small business insolvencies relative to the overall number of small businesses, the number at the moment is far from being record. I know that's not your narrative.
The quantum.
Well, there's also a lot more businesses.
So it's suddenly just grown.
Sorry?
The number of businesses has suddenly just grown.
It has. The number of small businesses has grown. And not surprisingly, the number of small business insolvencies has grown, just as the overall number of small businesses has grown.
Right.
So in percentage terms, it's far from being a record. I know that isn't your narrative, but that's the facts.
In the context of the Strategic Apprenticeships Review, did you take into account how difficult it is right now in the construction sector?
For just the construction sector,
yep.
or small businesses in the construction sector? No, sorry, I was just... So certainly the strategic review looked at, so I think over 600 people that spoke to numerous consultations all around the country, both in terms of through a sector lens as well as through talking to state and territories, regions, etc. They definitely recognised, looked at when a key feature in the recommendations is around ensuring that the apprenticeship system and the incentives are aligned to those key skills needs, and that included construction in that sense. We can also sorry, I'll stop there, but I can talk to what the government has done around construction as well, if that's helpful to you.
Yeah, I do want to go there because we are hearing from builders and tradies that they're struggling at the moment to be able to afford apprentices with all the uncertainty that is occurring in the construction industry right now.
So the government has a range of initiatives in relation to supporting the construction industry and its employment of apprenticeships. So in addition to the fee-free TAFE dedicated construction places, so 20,000 dedicated fee-free TAFE construction places, the government also made an announcement around extending essentially the new energy apprenticeship program to include, so announced the key apprenticeship program, and that would include construction occupations. So that increases the 5,000 that's available to both the employer and 5,000 that's available to the apprentice to 10,000, and that kicks off on the 1st of July of this year. In terms of the other thing, just teasing on your comment about small to medium businesses, I think one of the things we are very cognizant of is the importance of small to medium businesses and the role that they play in ensuring we have, a thriving, apprentices and trainees across the country. The government also announced, and this was a recommendation from the review, recognising the role that group training organisations play in supporting small to medium enterprises to take on apprentices or trainees. And the review recommended a pilot to help subsidise the cost of the GTOs, so that the GTO can play a really important role with a smaller business in managing the ups and downs, particularly construction. And managing that they might not be on site constantly, and so the GTO can step in and continue the training. The initiative...
They need a pipeline though, don't they? As in they need hosts, they need employers to be able to...
Yeah, so basically the pilot subsidises the host, the employer, for the cost. So a lot of the time small to medium enterprises won't use the GTO because it's just that bit more expensive. This is an initiative to subsidise those costs so that they can have access to what is a great service and a great capability, and therefore be able to take apprentices on.
I'm pleased to hear you say that. So I'll try and get through these questions quickly if I can. Was this issue around the construction sector raised as part of the strategic review into apprenticeship support?
Construction was definitely something that the reviewers heard from their consultations.
And affordability, was that raised as an issue?
Affordability of the apprentice?
Yeah.
I think...
And confidence about being able to... Yeah, because you're committing, unless they are with a GTO, they're committing for a long period of time.
I'd have to... can you recall exactly?
So, noting this was an independent review, and we had independent reviewers who went out and spoke to a wide range of stakeholders. We did hear through a large number of submissions that different sectors were facing pressures around the cost of taking on an apprentice, some of it just in meeting the costs of taking on an apprentice, as well as apprentices struggling to make ends meet, particularly in the early years when their wages are lowest. We also heard that the challenge that some employers faced, particularly the smaller employers, to provide that certainty when you need to sign someone up and agree to take them on for 4 years with the length of contracts and not necessarily having that guaranteed pipeline. And this is where the GTO measure may be able to provide assistance.
The government's yet to provide any long-term certainty on employer incentives. Why not provide that certainty as part of this response?
So in response to the review, the government has agreed to keep the current incentive settings in place until the end of this calendar year. So that's $5,000 for apprentices in priority occupation and $5,000 for employers in priority occupation.
But given that an employer making a decision around an apprentice is often for maybe up to a 4-year period, only having 12 months is...
So within the apprenticeship incentive system, the eligibility for the incentives follow over the life of the apprenticeship, so they're based on when you sign up your apprentice.
Okay. Has the government considered increasing support for employers to put apprentices on?
So
increasing the
support. So, for instance, the key apprenticeship program, which includes new energy and construction occupations.
Is that the 5 and 5?
That's the 10 and 10. So that is an increase for employers.
Sorry.
Correction.
Sorry, to correct that, it is in line with the new energy apprenticeship program. It is a payment for apprentices only. The normal incentives are available for employers, so they would attract $5,000 in incentives because the apprentices will be in priority occupations, and the apprentice in line with the new energy apprenticeship program would attract $10,000.
As an additional 5? Sorry, as an additional 5 or an additional 10?
It's an additional 5, so a total
to make
of 10. Yes.
I was just going to say, we're obviously still in the process of considering the recommendations of the review, Senator O'Sullivan's, but we recognise the need to provide some certainty to business and apprentices, which is why we've extended the existing incentives. You may not remember this, but it's just worth noting that the funding that had been provided for these incentives by the former government actually was due to expire on the 1st of July last year. So had those changes gone ahead, then incentives for employers would have fallen dramatically. Sorry?
We didn't win the election, unfortunately.
No, but that was the budget that you took to the election, was that it actually had those incentives ceasing or falling dramatically on the 1st of July 2024. So we've been able to extend and provide that funding for employers much longer than was proposed before.
Has the government costed any options for new wage incentives for employers?
I think we're probably getting into the sort of cabinet things we can't really talk about category. I mean, we're obviously giving consideration to the recommendations of the review.
Will there be any further commitments in response to this review?
Well, as I say, we're giving consideration of those recommendations, and as we
take it as so we shouldn't take it as it's complete.
The response to the review? No, I don't think it is complete. But what we have attempted to do is to provide some certainty around programs that were reaching expiry dates and things like that. And also taking the opportunity to deliver on some of the recommendations that we saw as most urgent.
So why hasn't the government continued with providing that quantum of incentive, except you might want to change the parameters as to who's eligible and all that sort of thing? But why has a decision been taken not to continue the
employer incentives?
The employer incentives.
I think we have maintained.
Continued the employer incentives for priority occupations until the end of the 2025, and that was in alignment with the phasing that had been in the budget. Well, it's actually, to the Minister's point, it's an increase on the phasing that had the step down that had been in the budget since 2022. and so that continues till 31 December 2025.
But there's no increase, so decisions been taken not to increase it.
So the current apprenticeship incentive system was designed in 2 phases. The first phase was the step down from boosting apprenticeship commencements, where employers of apprentices in priority occupations attracted $15,000 in incentives. Apprentices received $5,000 in incentives, and employers taking on an apprentice in a non-priority occupation attracted $3,500. That was always designed to be a 2-year period, so from the period of 1 July 2022 to June 2024. The current incentives that are in place included a top-up to move to that phase 2. So phase 2 had planned to take apprentices in priority occupations down to 3,000 and employers' incentives down to 4,000. So there's currently a top-up of for apprentices of $2,000 and employers of $1,000 to have the 5 and 5 in priority occupations.
Has the government received any views from stakeholders at all in relation to requests to see an increase in the incentives?
The strategic review itself had over 600, spoke to over 600 people and organisations. There was a document that reflected what they had heard, and certainly, there was a lot of material in relation to incentives and what different preferences of employers, etc. All of that consultation and feedback is being used to support further deliberations around the recommendations in the strategic review.
I might also, just in terms of stakeholder views, you may have seen when we announced the increase in the incentive for construction apprentices, master builders welcomed that. And said, coupled with government funding of fee-free vocational education and training, there is no better time to pick up the tools and become a tradie.
Yes, and in the inquiry they also said that there should be choice in vocational training. Anyway, we shouldn't enter in an argument right now. I've got other questions I want to get to. With respect to the $627 million for construction and the new energy apprentices, including the 10,000 payments. Can you give me a breakdown of what that funds and for how long, please?
So $626.9 million to establish the Housing Construction Apprenticeship Program will extend the program, including new energy, to the 30th of June 2029.
So the 627.9 is all of that the incentive payments?
So it's the top up to to take the apprenticeship support to $10,000.
Okay, but it's not for any program funding at all. Like there's no. Like will all of that money go to top up the subsidies?
Yes.
There's no other program money in that. Okay.
No.
As in, when I say program, I mean
Department.
Facilitation of it and that sort of thing. What is the split of funding between new energy apprentices and construction apprentices? Is it 50-50 or there's no cap?
In terms of the current numbers in training, or in terms of how we anticipate? So the 626.9 is for the Housing Construction Apprenticeship Program, and then we have funding for the new energy apprenticeship.
Oh, it's a separate fund?
Yes.
Okay, how much is that?
79.1 million.
79
for new energy.
79.1?
Yes.
Thank you. We've heard that a number of trades are not eligible for this payment in the construction space. Why is civil construction sector overlooked for this payment, given it's a vital part of construction?
So the details of eligibility for this new program is still being finalised.
Okay. Right. Well, can you tell me whether or not civil construction is included? Is it intended to be included, or where's it at?
Perhaps could we take that one on notice, because we are working through that?
Okay. Okay. How many new energy apprentices have taken up this support to date?
So as at 31st of December, 5,677 apprentices have signed up, and of them, 5,369 have been approved as eligible for the program, noting that a number that are included in those sign-up numbers are still in the process of being approved.
Remind me, what was the original target?
10,000 new energy apprentices to have completed their training by 2030-31.
Has there been any consideration given to provide increased support to any other critical skills areas other than construction?
So, more broadly, so the National Skills Agreement, it's a $12.1 billion agreement with all states and territories, has identified, in agreement with all states and territories, the key skills priority areas, and that includes care, it includes manufacturing and digital, as well as focusing on closing the gap in First Nations. So there are in that context, that's framed, for instance, the fee-free TAFE eligibility settings, and so for instance, we see a very high take-up in fee-free TAFE around nursing and care qualifications. And then what we see as well in the Apprenticeship Connect, which is the service that Commonwealth provides to support arrangements between the employer and the apprentice. We have dedicated specialist Connect providers focused on both net zero and First Nations in that context of where those priority, both those priority skills gaps are, but also priority cohorts.
Okay. Chair, I've just got another block. I'm conscious that we were due to break. There's just one more section, so I don't know if we want to hold everyone till after a break, or you want me to just keep going?
I think you should keep going. I was hoping that we're going to power through and be finished reasonably at the same time.
You weren't alone there, Chair.
We'll finish. I promise we'll finish earlier.
Yep.
If we're not having a break.
Quite early.
Quite early. If we're not having a break.
All right. I want to ask about the Building Women's Careers program. Thank you. Has the recipient been announced?
Sorry, Senator. Sorry, could you repeat the question? Has
the recipient been announced for the Building Women's Careers program?
No, Senator. So we are still in a procurement process.
Oh, okay. When will that conclude?
We are in the procurement process. We're going through those deliberations. I'm not able to say an exact date.
But the submissions have been received, though, so we're at that stage, are we?
Yes.
So final decisions needing to be made.
Yeah, deliberations are underway.
Yeah. Okay. I want to ask about the media release. I've got copies of that we'll table from Minister Giles. where it says that nearly 80% increase in women learning a trade. Was the department involved in this media release? Have you got it yet? Sorry. I'll give you a moment just to have a quick look. Was the department involved in this media release?
In line with normal arrangements for media releases, we did provide input to the media release.
Okay, did the department fact check this release before it was issued?
I can provide the data that supports the 80% increase.
So perhaps, Senator, I can take on notice, I mean, as Ms Campbell has said, in line with normal processes and arrangements, we would normally fact check, but I think in terms of just there's many media releases, so perhaps we can take on notice that specific question, but we can talk to the data.
I'll go through the questions, and then if you need to take anything on notice, you can. So in the release it states that the Building Women's Careers program announced in the 24-25 budget is driving further structural and cultural change by supporting more women to train and take up jobs in male-dominated industries. Is that what you can see there?
Mm-hmm.
It is written in the current tense, which indicates that this program is already having an impact today. Mm. Can you enlighten us?
Look, Senator.
Thank you.
Got a double promotion. He's not even a shadow minister yet.
Yeah.
I thought you were a shadow assistant minister.
Oh, yeah. Come on.
Steady, I suppose in the broad sense.
As I said, I think I would like to take that on notice in the context of...
but you can see that it's written in the current tense.
Yeah, look, and it might be that it's, just a misplaced past pretense, past particle, but I just would like to check that.
So these questions are pretty self-evident, I guess, then. So keen for an update. How many women have been supported in this program to date?
So as I said, still in procurement, still in deliberations, not in a position to talk about it.
Simple answer.
But very excited to talk about it in the future.
Yes, but my question was how many women have been supported through this program to date?
Well, so what I would sort of
it's pretty simple.
Posit.
I mean,
the program that doesn't. But the program it has the guidelines. So supported by research and consultation, looking at structural and systemic change, both in place and across sectors. It will have the potential to hopefully create quite substantial change and affect many women. I suspect this is a typo in the context of putting it in the past, in the future tense, but as opposed to future tense.
But it's
the
not
guidelines.
Correct. It's not correct to say that it's driving structural and cultural change.
I think. Let's not make a mountain out of a molehill. I think. I'm guessing that the point that was trying to be made was that in announcing, in developing, in implementing this program, it is driving